Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our look at the Slender Man stabbing case. Just make sure my audio seems okay. So welcome in, everybody. We are continuing with Anissa Weier. We did Morgan Geyser last week. No, it was earlier this week. It was last year, I can say that with confidence. And then we picked up on Anissa Weier. So that's where we are finding ourselves today, part 2. So welcome in. Sassy, cold morning from freezing cold Ohio. Good to see you. Come in, warm up. Richard in the kitchen. Crazy Mary Joe, Iowa backyard. Good to see you. Shirley, good morning to you. Ed, seems like a year since I followed the trial. It has been, right? Lynn, good morning to you. Good to see you. Deviant, P. Cooper. Thank you for joining us, JMS. Good to see you. Shirley, I hope everything is going well with you today. Crunchy Frog, still chilly and so far. Barry Adams, good morning to you. Selena, Laura, hello. Welcome in. Saudi Girl, Alice, Happy New Year to you. Cynthia, I didn't even know she had a trial. Yeah. Yeah, it's more of a sentencing. This is more of a sentencing. Denisha, good morning to you. Thank you for joining us. Angelique, good to see you. Hope you guys had a peaceful, fun, festive New Year's celebration. Toby, good morning to you. Carolyn, good to see you. Fanny, good morning to you. Michelle, Brett, good to see you. All right, so let's continue on. Settle in and get comfortable. I know it's chilly out there for a lot of you, so let's get right to it. So Payton Leutner is the victim. She survived. She was stabbed 19 times by Morgan Geyser, who we covered her trial earlier. And now we're looking at Anissa Weier. So Morgan and Anissa are the co-defendants in this. This happened on May 31st of 2014. They were 12 years old at the time this happened. So I'm going to read through this. This has a lot to do with Morgan's side of the story, but because we covered Morgan, we covered Morgan first. But Anissa is interwoven into this as we're finding out and seeing. So the story of Morgan begins before the 2014 Slender Man stabbing, rooted in profound mental illness and social isolation. From an early age, Morgan experienced severe hallucinations, later identified as early onset schizophrenia. We have a lot of questions whether Morgan was actually had schizophrenia or not, even though there were 3 or 4 experts, doctors, that said she did. A lot of her actions and talking and affect just doesn't really fit that bill. Plus, she says she malingered. Then she said she wasn't. Then she said she was, or she was lying about it. Then she wasn't. So there's a lot of questions about Miss Morgan. Now, hearing Anissa, we went through day 1 and part of day 2. And we're listening to her interview with law enforcement, and she sounds pretty put together, or pretty all together there. She doesn't sound like she said that she thought she saw Slender Man while she was riding the bus, but I'm also leaning towards these two. I think really fed each other, because we had this conversation the other day with you guys about when I was, 15, 16, 17, older than these guys, than these two, your buddies would you'd be hanging out, and it'd be dark out and you'd be in the woods. You'd be like, oh, what was that? I heard that. So I'm kind of, then I project that out onto these two, and maybe that's what they were doing as well. We're like, oh, I think I saw something, oh, what was that? And they were really going down the creepypasta route, which we will get to in a second. So Morgan described seeing colors bleed from walls and interacting with inhuman figures who spoke to her and appeared as companions. Some hallucinations took the form of fictional characters, most notably Severus Snape, whom she said regularly visited her bedroom at night. Morgan was aware she was perceived as odd by peers, teachers, and struggled to connect socially. We heard from Anissa that Morgan would she would pretend she was Voldemort, and she would run around. She had blood on her hands or her fingers in the playground. So we heard that from Anissa the other day. So now in 2013, Morgan and Anissa met. They lived in the same apartment complex and they would go to school. They would ride the same school bus together. So Anissa was another socially isolated classmate with a long-standing history in online horror culture, particularly creepypasta stories. Anissa had been reading and discussing Slender Man lore for years and understood it as fictional internet horror, even though she engaged with it intensely. When the girls became close and they met at the bus stop and they would ride the school bus together, Anissa introduced Slender Man and related stories into their friendship. Morgan's experience with Slender Man developed differently. Long before meeting Anissa, Morgan had been experiencing hallucinations and delusions consistent with early onset schizophrenia. After being exposed to Slender Man lore, those pre-existing symptoms latched onto the character as a framework. Shoshana, good morning to you. Good to see you, Andriel. They were 12 when this happened. They were 12 years old. Denisha, good to see you. Fanny, Jennifer King, good morning. Welcome in, everyone. Just making sure I see everybody here. Joyce, good to see you. Brenda, thank you for joining us. Paralegal Mandy, good morning to you. So, when the girls became close, okay, we read that. Morgan came to believe Slender Man was real and claimed she had been seeing him since early childhood, interpreting shadows, trees, and figures in her peripheral vision as proof of his presence. Now, Anissa, as I said earlier, they'd be riding the bus, and that's what she told law enforcement. She's like, oh, I think I saw him out, I saw a tree and thought it was a Slender Man. So Morgan claimed to believe Slender Man was real and claimed she had been seeing him since, okay, I read that. Anissa, initially treating the stories as fictional, began to accept Morgan's accounts and eventually came to believe she had seen Slender Man herself. What began as shared horror fandom evolved into a mutually reinforcing belief system that reframed their social isolation as being chosen rather than rejected. As this belief deepened, the girls became convinced that in order to live with Slender Man in his imagined mansion in the Nicollet National Forest, which is northern Wisconsin, where they lived, in, I think, central, they were more like by Madison, I believe, they would need to commit to take somebody out as proof of loyalty. They ultimately targeted their mutual friend, Payton Leutner, right, lucky girl, who went by the name of Bella. During the months leading up to the attack, Payton was increasingly bullied and isolated, and we heard about that, right? We heard how they bullied Payton, though Morgan repeatedly apologized and promised the behavior would stop. Now, in May of 2014, during a sleepover for Morgan's 12th birthday, the girls lured Payton into a wooded park under the pretense of playing hide and seek. There, Morgan stabbed her 19 times, so Payton got stabbed in the torso, the arm, and the leg, while Anissa encouraged her. And Payton came literally within like a whisker of one of those stab wounds hitting her in the heart, and she would have obviously died. Believing Payton would die, the girls left her and began walking toward what they believed was Slender Man's home. Now, Payton survived by crawling to safety and alerting a passing cyclist. Both girls were arrested within hours and confessed. Anissa Weier was sentenced to 25 to life in a state mental health facility with the possibility of supervised release. And we will see that. We're going to be covering that over the next, today we'll see the result of that. Morgan, however, she received a maximum sentence of 40 years to life in a psychiatric institution. Now, we saw all of this when we were covering Morgan. Over the following years, Morgan petitioned multiple times for conditional release. She was denied several times, and then ultimately she was allowed, asserting she had learned to manage her illnesses. After 3 denials, she was granted conditional release in 2025 and placed in a supervised group home in Madison, Wisconsin, with strict conditions, including a GPS monitor. Less than a month later, Morgan fled the group home with the help of a 43-year-old acquaintance named Charlie Mecca after claiming she feared punishment and loss of visitation. There's no evidence these fears were grounded in reality. And again, we watched all of that with Morgan's side of the story. All right, I'm going to skip that because that's all about Morgan. Now let's get to creepypasta. A lot of you the other day were asking, what is creepypasta? So creepypasta is a genre of internet horror made up of short, fictional stories designed to unsettle or scare the reader. The term comes from copypasta, slang for text that is copied and shared repeatedly online. Creepypasta stories are typically circulated on forums, blogs, Reddit, and YouTube, and often feature unsettling themes such as supernatural entities, psychological horror, urban legends, or corrupted versions of familiar characters. And if you were with us the other day, we pulled up the creepypasta. There's Creepypasta Wiki, and then there's creepypasta.com. So we pulled up both of those websites, and I read a few paragraphs of each. So if you guys want, I'll do that again. Maybe towards the end of the day, we can do that again. Many creepypasta stories are written in a realistic tone, such as journal entries, eyewitness accounts, or found footage narratives. And I always say Blair Witch. For those that are familiar with Blair Witch or the paranormal series, it's usually a handheld camera, real DIY, black and white. That's kind of the vibe. Now these items, they can blur the line between fiction and reality, especially for younger or vulnerable audiences. Well-known creepypasta characters include Slender Man, Jeff the Killer, we heard his name as well, and other fictional figures that originated online and evolved through collective storytelling. Now, also just think about urban legends, the couple on Lookout Point or Lover's Lane, they're kissing and making out, and all of a sudden they hear a tap, 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 and it's this guy with a hook, and he kills them. So then there's Pumpkinhead Boy. I was talking about that. That was one of our, when I was a kid. Well, no, I was like 15, I was 16 or 17 because we were driving. And there was this, Pumpkinhead Boy lives in this part of the woods, and we would go there, and there was like a cabin or something, so we'd freak ourselves out. And don't forget, that was also around the time of Halloween, and Friday the 13th had just come out. So this is like 79, 80, 81. So it was easy to like freak yourself out. And this was before, obviously, all of this. I have no idea what I would have done if I had access to internet when I was like 10, 11, 12. So over time, creepypasta became a major part of internet horror culture, inspiring fan art, videos, games, and adaptations, while remaining entirely fictional in origin. So creepypasta evolved from chainmails of the 1990s and early 2000s. Think of forward this email to 10 people, or a ghost will appear, or look into the mirror and say, Bloody Mary 3 times, or, kind of things like that. Jenny Lynn, this is new to you. Creepypasta, what a name. Yes. Yeah. It's interesting stuff. We've been familiar with it since probably Aaron discovered it first. Let's see, it was probably 2000, maybe 13 or 14. I think that's kind of when we started to kind of get into it. So 4chan, this is widely considered the birthplace of modern creepypasta around 2007. Users on the paranormal board would share short, scary stories designed to feel like found accounts or leaked secrets. Something Awful. This forum birthed one of the most famous icons, Slender Man, during a 2009 Photoshop contest to create paranormal images. And then, of course, Reddit, created in 2010. This community popularized the everything is true here rule, where authors write in the first person and readers act as if the story is real. Now, Slender Man specifically, hey, Mel, folklore, yep, youth and imagination can make strange bedfellows, for sure. Jeff the Killer is creepypasta as well, yep. Saudi Girl, yes, Pumpkinhead was a movie, and there are probably just a couple of movies about Pumpkinhead, right? All right, so specifically, Slender Man is a fictional supernatural figure that originated on the internet in 2009. And we saw some of Morgan's drawings, and with the tentacles and such as that. So he was created as a part of the Photoshop contest on the Something Awful forums, where users were asked to invent paranormal images and backstories. Slender Man is typically depicted as an unnaturally tall, thin humanoid wearing a black suit with a featureless face, white face, and elongated limbs. So in online stories, Slender Man is portrayed as a stalking presence who appears in forests or near children, often lurking at the edge of perception rather than confronting victims directly. Common elements of the mythology include mind control, inducing paranoia or hallucinations, abducting children, and exerting influence through dreams or intrusive thoughts. The character evolved through collaborative storytelling known as creepypasta and has no basis in folklore, mythology, or reality. And it's kind of like, when your older siblings say, or somebody's like, oh, the boogeyman's going to get you, or don't look under the bed, because, stories that we tell children. So it's just kind of, I guess it sort of has evolved from that too. So despite its entirely fictional origins, Slender Man became a prominent figure in internet horror culture, inspiring stories, videos, games, and fan communities. The character is not real and was never intended to be perceived as real, though its ambiguous documentary-style presentation in early stories contributed to confusion among some audiences. So now let's get into some definitions. So Devian, yeah, you said, so what is that? What is Slender the Arrival? What is that? You mentioned that earlier. Slender the Arrival. Oh, it's a game? Is it a game or is it a movie? Slender the Arrival. Oh, it's a video game. Okay, developed by Blue Isle Studio and Parsec Productions. Ah, okay. Oh, we can watch a trailer? Oh, for sure. Oh, yeah. Let's check this out. Hopefully we won't get in trouble. We might get in trouble for sharing this, though. All right. I don't want to get in trouble for sharing that. So anyway, if you go to Slender the Arrival, you're on your own, no one to come for you, no one to help you, no one to hear you scream. Slender the Arrival is back and scarier than ever with the long-awaited 10th anniversary update, a complete visual overhaul of the spine-chilling 2013 release. Wow. All right. Slender the Arrival. All right, I think I can show this. Let's show this. Let's see. All right, let me go over here. Carolyn, you're not playing that game. All right, here, let's check this out. Hold on. So let's check this out. All right. So here's the website. I can never interact with these. Dang it. I always have trouble interacting with these pages with them. Yeah, I can't scroll. Yeah. All right. So I can't scroll down. So anyway, so that's all right, hold on. We're going to figure this out. I got to turn my camera off real quick. All right. Thank you, Aaron. Aaron to the rescue as always. All right. So here's the do you think we'll get in trouble if we play the trailer?
I don't know what you do.
There's a trailer here. It's on YouTube. I don't want to get in trouble. All right.
This is the website.
No, you can hear it says watch trailer.
You can explain the website.
All right. All right. Well, anyway. So that's
well, it's a game, right?
I guess. Yeah. Yeah. Well, here, let's watch the trailer. I won't put any audio on. So there's the trailer. Slender Man is unleashed. So it is, yeah, so it's a game. Deviant, I should play it on stream sometime. I'll just keep it muted. So yeah, so Slender Man is back. So I would totally play this game if I'd play it now, but I would if I was like 12, 13, 14, maybe if I was 14 or 15. Maybe if I was 12, I'd probably be too scared. But I would definitely play this. Yeah, I would play this when I was 15, 16, 17 for sure. You're just kind of walking around, and so what happens? Anything like... Nope, there's Slender Man. There he was. All right, I guess that's it. All right. If it's like a Ouija board, don't bring it into chat. Definitely not. Definitely not. All right, so that's that. All right, so let's get to, now you guys sort of have the background of Slender Man and these 12-year-old. I mean, they didn't have the video game back then, but they had everything that was online, and they just, it's like this it's like two tornadoes getting together, and they just they fed into each other, I think. So Selena says your husband plays all kinds of games, and he said he would probably play it. Yeah, I mean, I don't know, I would. Yes, Harvey. It was the play. I think I saw it once as a kid, I think. Is that with the rabbit? Iodine, good morning and happy New Year to you. All right. Let's get settled in, guys. Let's get settled in, and let's pick up. So we left off. It was they had broke before lunch, right? So I didn't play it because it was like 4 o'clock already. It's like another 2 hours. So we stopped there. So it was the morning, and now it's this is the afternoon. So yeah, Harvey is the it's the guy who hallucinates. I saw it as a play. It's a 1944 play by Mary Chase about a man, Elwood Dowd, whose best friend is a 6-foot-tall invisible rabbit named Harvey, leading his family to try and have him committed to a sanitarium, with chaotic and humorous results as the doctors and staff become increasingly affected by the delusion. This play is a classic comedy known for its charm, humor, and exploration of sanity, with famous adaptations, including a 1950s film with James Stewart, one of my favorite actors. So Jimmy Stewart played in, it's a 1944 play. So, all right. So this is day 2. This is from September 30th. I'm sorry, September 13th. Let me just pin this here. So this is day 2 from September. All right. I'll pin that up here. Okay, here we go.
All right, thank you. Please be seated. We're back on the record in State versus Weier. The jury's back in the jury box. Parties are prepared to proceed. Attorney McMahon, do you have a further witness?
We do, sir. First, we would be calling Detective Michael Carpenter.
All right, thank you.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. All right, thank you. Thank you. Good afternoon. Please be seated, pull up to the microphone, and then state your full name and spell your last name.
Michael Carpenter, last name spelled Carpenter.
All right, thank you.
Detective Carpenter, where do you work?
It's a City of Waukesha Police Department.
And were you
did you become involved in a stabbing investigation of a young lady by the name of Payton that occurred on May 31st of 2014?
Yes, I did.
And what was your role in it?
I'm a detective with the computer forensics unit, and I was asked sometime after May 31st, I believe it was the beginning of June 2014, to examine several devices that were collected as evidence.
And do you remember what devices you examined?
I believe there was one of them was a cell phone, I believe, belonging to Anissa Weier. I cannot recall exactly what brand at this time. An Apple iPad from Anissa Weier, and I believe it was a Dell PC and a Kindle tablet from Weier and Geyser.
Okay. And did you develop reports regarding what you found?
Yes.
And who did you provide them to?
Detective Casey.
Okay. And specifically thinking of the Geyser PC, did you do any type of search of that personal computer?
Yes.
And what did you do?
The first thing I did was make an exact duplicate of the hard drive, and then I ran the image of that hard drive against several forensic software programs. I believe they were, one was called FTK, Forensic Toolkit, and the other was Internet Evidence Finder.
Okay. And the purpose for doing that is what?
To locate any evidence that might be pertinent to the investigation is information that Detective Casey would have been looking for.
Okay. And how would you determine what evidence was pertinent to the investigation? Where would you get your information?
Sometime prior to conducting the search, I had received information from Detectives Trussoni and Detective Casey. I believe it was information obtained during their interviews of Anissa Weier and Weier and Geyser, certain keywords they were looking for, such as Slender Man, Jeff the Killer, things of that nature.
Okay. And did you run a search of the Geyser computer for those things?
Yes.
And did you find entries that seemed to indicate that those words had been searched?
Yes.
And did you do anything with that information?
I created a report out of it, placed it on the disk, and turned it over to Detective Casey.
Okay. And the report that you generated was not of everything that was found on the Geyser computer, correct?
Correct.
It was just related to the information that Detective Casey and Detective Trussoni had provided you.
Yes.
And the report, how did you generate it? What did you use?
The program I used for that specific report was called Internet Evidence Finder.
And did you eventually develop a Firefox web history?
Yes.
And you see on the screen in front of you and above you what to me looks like something I would never be able to read. It's computer jargon, correct?
Yes.
And when you open it, it shows what the searches were, correct?
Just for clarification, the links that are shown aren't necessarily a keyword search that was performed on that computer. It means I did a keyword search on Internet Evidence Finder, and it said these file names, whether it's Slender Man or whatever it may be, were found someplace in that web path.
So based on requests from Detective Casey and Detective Trussoni, you searched and it pulled those particular websites out of the, or web searches out of the Geyser computer.
Correct.
And then you provided that information to Detective Casey, correct?
Yes.
And the idea behind the links, these are called links, right?
Yes.
One of the few computer terms I know. It's that you have the ability to trace where someone has, or to go where someone went. It's like a path, right?
I don't know if trace would be the appropriate word, but it would just open up the web page as it was seen in that point in time, if it still existed.
Okay, so the majority of them seem to deal with Slender Man, the Creepypasta Wiki, Jeff the Killer. There were other things that Detective Trussoni and Detective Casey asked you to look for too, correct?
Correct.
And you kept those, like the Slender Man. Was that pulled up in relation to something they asked you for? Or?
That I'm not positive of.
Okay.
What was that? What was your answer?
I'm not positive.
But all of this information was provided directly to Detective Casey after he had asked you to look for certain terms.
Yes.
And after that, in your report, you noted any further evidentiary value would have to be generated by Detective Casey.
Yes.
So the intent was to research, apparently.
I'm sorry.
It appears that there was an attempt to gather information on creepypasta on the parts of the Waukesha Police Department and Slender Man.
Yes.
And that was your understanding of what you were doing, is gathering that information in relation to the particular case that you were working on.
Yes.
And you have no way to know whether any of the officers actually looked at the information on this screen.
No, I do not.
So if they had wanted to, they could have gone here, for example.
And I apologize, I didn't see which link you actually clicked on.
Observer symbol.
What was that? Observer?
Symbol.
It's a possibility. I can't say that a link that was looked at on that computer in January of 2014 would appear the same today as it did, 3.5 years ago.
Okay. Thank you. Nothing further.
Cross-examination.
State has no questions.
All right, thank you. Was Attorney McMahon,
Sir.
was the material you showed on the computer part of an exhibit?
It was not a part of an exhibit, Your Honor. Detective Casey had looked at it yesterday and wasn't able to really talk about what it was. And therefore, the person who generated it was produced.
No, but what you used today, is it an exhibit today?
It could be if the court wishes.
Well, I think since you showed it on the screen, it has to be an exhibit. So how would you name it?
I would name it the Firefox web history.
And is it a police document or a police disk?
Yes, sir.
All right. Is there a particular disk that it's on that's like
It is.
has an evidence number
Certainly.
that we previously used?
It was not previously used, Your Honor. We had uploaded the information.
I
to,
meant as previously used, excuse me.
I believe it would be the disk we were provided that it was named data. But I can double check that, Your Honor. It would be on this particular disk. And it is within the file Geyser Family PC Internet Evidence Finder.
Geyser Family Internet Evidence Finder?
Geyser Family PC Internet Evidence Finder. Am I saying that correctly, Detective?
Yes.
Okay.
So that's the entity from which you viewed the material that was on the screen.
Correct.
All right. So let's mark that. Now, is that That's actually the disc there.
It is the actual disc.
So let's mark that as Exhibit A4, unless you have some other suggestion.
No, sir.
You know, I'm hesitant, I'm going to change that marking. I note you've got because of the way we're marking exhibits, you've got an A1, AA, and A3. I think we're going to make it, we're going to double the letters. So your A1 will become AA, A2 will become AB, A3 will become AC, and now we'll have AD as in David. That way we'll keep our numbering system consistent. State agree with that method of marking?
Yes.
All right, thank you. Then are you moving that into evidence?
I would say.
All right, any objection?
No.
It's received. Then, Detective, I believe you're complete.
Thank you.
Yeah, thanks for being here. Have a nice day. Is Detective Carpenter under subpoena?
Yes, he is, and I would release him.
Any objections?
No.
All right, very good. Thank you. Do you have further witnesses to call?
Yes, Judge, Dr. Melissa Westendorf is present.
All right, thank you.
Judge, are you okay with me putting exhibits WX up there right away? That's her CV and her report.
Yes. Yeah, ma'am, right up here. Then if you'd stay standing, raise your right hand, clerk will swear you in.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, thank you, and good afternoon.
Good afternoon.
Then pull up to the microphone. It's the bar with the red light.
Grab some water here.
Sure,
please.
go ahead, it's fine. Then state your full name and spell your last name.
Melissa Westendorf. Westendorf.
All right, thank you.
Dr. Westendorf, I am placed at the witness stand two exhibits. First one I want to draw your attention to is Exhibit W. Can you take a look at that?
Yes,
And do you recognize that?
I do.
And what is that?
This is my curriculum vitae.
Okay, so Exhibit W is your CV.
Correct.
Okay. And who prepared that?
I did.
Okay, and are you the person that sent me a copy of the CV?
I did.
Is that CV an accurate, up-to-date in regards to your education, training, your employment, and other history in the field of psychology?
It is.
So I want to start with your educational background. Can you go over your educational background for me?
Sure. I received my bachelor's in psychology from the University of Iowa, and then I received I attended a joint degree program. I earned my law degree from Villanova University in 1999, and then I earned my PhD in clinical psychology from Hahnemann University, which is Hahnemann, in 2002.
And have you been involved in any internships?
I did. As a part of earning a PhD in clinical psychology, you have to do a formalized one-year internship. And I did that internship at the Milwaukee County Mental Health Complex.
Okay, and I believe you just said that that's a part of the training that all psychologists have to go through in order to begin work as a psychologist.
Right. Those who are earning their PhD have to do these internships to complete the program.
Okay, and can you describe the internships that you were involved in?
So when I say internship, my formalized internship occurred after my classwork, and in that I was considered the forensic intern, and so I did evaluations for Milwaukee County, forensic evaluations. I also then worked on mental health units, working with chronically mentally ill people who have been placed in a hospital due to various behaviors. I also worked on the juvenile unit, a similar situation, juveniles who are placed in the mental health unit to care for their mental health needs. I did outpatient therapy as well, both with juveniles and with adults.
Okay, so a lot of your practice when you were doing internships involved working with children.
It did. When you say internships, I also did what formally we call practicums while I was in graduate school. And there I had a forensic rotation doing juvenile evaluations, forensic evaluations. And then I worked in the Philadelphia Child Guidance Center, which is doing therapy with children and families. So yes, I had multiple experiences related to working with youth and families.
Okay, and you used a phrase that I want to make sure the jury understands. You said forensics evaluations. Can you describe what you mean by that?
Sure. So there's a difference between a clinical psychologist and a forensic psychologist. A clinical psychologist is the person who does therapy with the individual, meets with them over the course of either brief therapy or longer therapy, and works on their mental health issues. A forensic psychologist comes in and typically, so there are legal questions that we're helping the court to answer as related to how does the psychological piece fit into this. And so the forensic psychologist comes in and they look at all the evidence that's provided to them or that is part of the case, and they come in with an objective piece. They want to look at all the information objectively, and they meet once, but maybe twice with the individual depending on the issues that are involved.
Okay. And I wanted to ask you a question about, you said you have a law degree. Is one of the reasons you got your law degree was to assist you in doing your forensics evaluations?
Initially when I went into that, I really liked the intersection of law and psychology, how psychology, the mental health law, so to speak, the family law, criminal law, that was very interesting to me. And so it does certainly inform my forensic work because it helps me understand the legal process and what's asked of me when I do a forensic evaluation.
Okay. So, in what fields are you licensed right now?
I have my license in psychology for the state of Wisconsin. I also maintain a license for my law degree as well.
And do you belong to any type of boards?
I have. In the past, I used to sit on the Wisconsin Licensing Board. I did a 4-year term, 3 or 4 year term with them. I was a part of the American Psychological Association. They had a committee on legal issues, and so we would meet and work on policies for the American Psychological Association related to those issues. And then I've been part of many memberships, the American Psychological Law Society. I've been part of the Racine County Bar Association, let's see, what else? The Wisconsin Psychological Association. There's an interest section of forensic and correctional psychology. So I'm not current on all of them, but in various times throughout my career, I've been part of these organizations.
And now let's talk about your current employment. You're currently employed where?
I maintain a part-time position with the state of Wisconsin doing forensic evaluations, and then I also maintain an independent private practice as well as a forensic psychologist.
Okay. And let's talk about your part-time position first. How long have you worked in that position?
That particular position I've had since 2011.
Okay. And your private practice, what is your private practice?
It's my private forensic practice. I've maintained this practice since 2003 when I became licensed.
Okay. And what is the name of the private practice that you are involved in?
It's Melissa J. Westendorf, JD, PhD, SC.
Are you also involved in, your CV mentions the Technology Wellness Center. Could you explain what that is?
Sure. In 2013, I joined forces with a colleague of mine that I went to school with, and we formed the Technology Wellness Center. And we formed this center to help parents and kids manage a healthy use of their electronic devices and technology. In the course of my practice, my forensic practice, I was having more and more cases involving the internet, or what we call technology overuse, but almost the addictive quality of electronic devices. And it was concerning to me because these kids were ending up in the legal system. And so we formed the company to help teach parents some of the problems with using the internet and using electronic devices, and to talk with kids about the dangers that are out there regarding using these devices. And then we also, I've presented to both those groups, and I've also presented to, say, social workers, other professionals who work with kids, and giving advice on how to work with them. Our goal is to teach people how to have a healthy balance between using their electronic devices and having a healthy lifestyle.
Okay. So in 2012, you recognized that there were some dangers involved in the internet.
It was certainly before then. It was when I joined forces. We wrote a book to help parents, give them kind of a primer, what you'd call a primer on some of the issues that they really need to be aware of.
Okay. And have you gone to like schools and things to give presentations at schools regarding that?
Right. I've been brought into schools to talk to middle schoolers and high schoolers, and then I usually do a parent presentation afterwards. And I've also presented in a couple different states. In Illinois, I've talked with other I would say counselors or social workers who work with kids.
Okay. Now I want to talk to you a little bit about the forensics psychology work that you've done. Have you testified in court before?
I have.
And have you ever testified in court as an expert regarding the issue of not guilty by reason of mental disease or defect?
Yes.
And has there ever been a time when you have been determined not to be qualified to testify regarding that issue?
No.
Okay. Judge, I believe the state has maybe stipulated to her being an expert. If not, I'm going to ask that she be found to be an expert in the area of assessing the issue of not guilty by reason of mental disease or defect.
I'll permit the evidence to stand as it's been received and have the testimony go forward.
Okay. And Doctor, how did you get involved in this particular case?
I was called by the court to perform an evaluation on Anissa.
Okay, so you were not called by the district attorney's office?
No.
And you were not called by my office?
No.
Okay. Has there been times in the past, though, that you've been contacted by the district attorney's office to do evaluations?
Sure.
And have there been times when they contacted you to do not guilty by reason of mental disease or defect evaluations?
I have been contacted by them. There have probably been a couple cases that have related to this particular issue.
Okay. And has there been times when you've been called by the defense to do not guilty by reason of mental disease or defect evaluations?
Yes.
Has there been times when you have reached conclusions maybe different from what the person that hired you were expecting you to reach?
So there certainly are times when I cannot support the particular position of the party that has hired me.
When you approach not guilty by reason of mental disease or defect evaluation, what's your process? How do you go about approaching the NGI issue?
So as a forensic psychologist, what I do is I try to obtain first as much information that is available or that's part of the evidence of the case. And so what's really important to me is police reports associated with whatever has happened, witness accounts of what's ever happened. Certainly the criminal complaint is important because it summarizes all that information as well. I also try to find if there's been any mental health services that have been involved, and I want that information. Depending on the age of the person, I want education information. I will then also speak with people involved in the person's life, including whether it's parents or spouses, teachers, therapists if they're involved, anybody that might help me understand the individual at the time the offense occurred. I will also then, if they've been located within a facility or in custody, then I try to obtain that information as well, any documents that are prepared in the normal course of their business as they supervise someone. And then wherever that information may lead me, I might have to look for other information.
Okay. So in this case, there were recorded interviews of the victim. There was a recorded interview of Morgan. There was a recorded interview of Anissa. Did you get complete copies of those interviews?
I received copies and watched the recorded interviews of Anissa and Morgan. I did not receive any recorded information on the victim, but I did have the police reports associated with the interviews of the victim.
Okay, and you read that complete
Yes.
report and you watched those entire interviews?
I did.
And the information that you described that you normally obtain for purposes of doing your not guilty by reason of mental disease or defect evaluations, is it common for someone in your position to seek that information when doing their reports?
Yes, it's customary to try to obtain all the information you can. I didn't say it earlier, but I also interview the person who's been accused. But yes, that's the normal course of business as a forensic psychologist, and it's what I do in my practice.
Okay. And now let me ask you this. This is something people might be kind of curious about. You know that the court's asking you to do a not guilty by reason of mental disease or defect plea when he contacts you because that's what you're informed, right?
Yes.
So when you get all of these collateral informations that you just described, do you walk into your assessment, determine ahead of time that this is NGI and I'm going to then look at other things that might rule it out, or how do you approach your thought process when you're doing your evaluation?
You know, when you approach these evaluations, you go in and you want to look objectively at all the information. You know, people are responsible for their behavior, and then you start to look at the evidence to see if there's a mental disease or defect that might be part of this. And if you find this, then how did it affect the other two components, or their capacity, to appreciate the wrongfulness, or whether they could conform their behavior. And so I'm looking at the intersection of all of these pieces, and sort of, I don't know if a filter is the right description, but, I'm looking to see what is in the totality of the circumstances and all of the evidence that's available and taking an objective view of that.
Okay. So if I understood you correctly, you go in there with the mindset that this person is responsible for the crime.
That's the assumption, yes.
Okay, and then you look at all the other data that you received, and then try to figure out what motivated the behavior.
I'm trying to see how all of the evidence fits together, certainly.
Okay. So taking into account your interviews of Anissa and those collateral information that you reviewed, did you reach some conclusions about her?
I did.
And did you prepare a report and then submit that to the court?
I did.
And I want to show you what has been marked as Exhibit X. Can you look at that and then tell me if you can identify that?
Yes, this is my report that I filed or sent to the court on November 4th, 2016, and it appears to be an accurate copy with all pages included.
Okay. And in that report, did you record your observations, your conclusions, your opinions?
Yes.
Okay. Now, there were other doctors that were involved in assessing Anissa. There was Dr. Michael Caldwell. There's also Dr. Gregory Van Rybrook. Did you have their not guilty by reason of mental disease or defect reports with you before you prepared and submitted your report?
No.
Okay. And so did you get a chance to consult with either one of those doctors before you submitted your report?
No.
I want to talk about what you were able to find with Anissa. Did you find a diagnosed disorder for Anissa?
Yes, I did diagnose her with a disorder.
And I want to have you look at your report, page 19, and can you tell me what that diagnosis is?
Sure. The name of the disorder is Other Specified Schizophrenia Spectrum and Other Psychotic Disorder, Delusional Symptoms in Partner of Individual with Delusional Disorder.
Okay, and that's a long name. Is that commonly known in another phrase or?
Yes, so the Diagnostic and Statistical Manual, or the DSM, what people refer to as the DSM, was reorganized a couple years ago, and some of the names have changed. This particular disorder used to be considered shared psychotic disorder, but for whatever reason, it was moved around a little bit and these other words were added, and I don't know the background of that, but in essence, it's the same disorder, it just has a different name. I'm going to use shared psychotic disorder because I think 3 words describes it a little bit better than the 8 or 9 that is included right now, just for ease.
Okay, and you said you referred to the DSM. Could you explain what that is?
The DSM is a listing of mental health disorders that are people work with, therapists work with, that people have as part of their life. And what they've done is they've tried to organize it in a way with symptoms for each disorder. And so therapists will use this. Certainly it gets used as part of either therapy or evaluations by counselors or forensic psychologists, and it is the treatise that most psychologists use when they are making diagnoses and working with people.
Okay, so that's the treatise that's commonly used by psychologists when forming their conclusions about a diagnosis for an individual.
Psychologists, psychiatrists, all levels of mental health professionals.
So I want to go back to the shared psychotic disorder. What does that mean?
Shared psychotic disorder is a disorder that is, as it indicates, shared between at least two people or more. And you have, in this instance, two individuals, one of which has possibly a more significant, more overt, more observable psychotic disorder. They may have multiple types of symptoms, delusions, hallucinations, whether it's auditory, visual. They might have mood problems. There might be other things going on. And then the second person, in this instance, then shares at least one of those psychotic symptoms. Delusional symptoms is present with this disorder and in this case. The sharing of that. Now, that second person may not have any of those other psychotic symptoms. They may not have hallucinations or some of the other things I just talked about, mood problems or cognitive slowing. But they do share this one common disorder, or one common symptom, which is delusions. Now, this is between, like I said, two or more individuals. Typically, there is a special relationship that's between these two individuals. This is not a very common disorder, and in fact, if you look through the literature, the psychological research literature, you don't find studies of 100 people where they've studied this particular disorder. At best, you get a case study where a psychologist will write or an academic will write on a particular case study that they have or patient that they've encountered. So it is really quite uncommon for this disorder. And I talked a little bit about that special relationship which is required. The special relationship typically involves maybe a parent and child, or maybe spouses, sometimes it's siblings. In this case is unusual because we have two children involved, but it takes a special relationship for this sharing to occur.
Okay, and I want to have you define some of the words that you just used. I think that you referred to a delusion, and I wanted you to explain what you mean by a delusion.
Sure. A delusion is a fixed or very persistent false belief that doesn't really change much despite contradictory information given to the individual. In working with people with delusions, you can not argue, but you can give them contradictory information and they keep that delusion intact. So for example, if a person believes that somebody did a secret surgery on them, took out their organs and replaced them with the organs of somebody else, even if I said to them, well, you don't have any surgical scars, it wouldn't alter that particular delusion. So that's what I'm talking about in terms of contradictory information. It doesn't alter the delusion. I'm not saying the delusion can't change a little bit over time, but that comes from within the person. It's not really necessarily the result of somebody coming in and telling you, well, that's the wrong, that's fake, or that's the wrong belief, or that couldn't happen to you.
Okay. Is there also something referred to as a bizarre delusion?
Bizarre delusions are considered those things that can't happen in normal life. And another example of a delusion would be, perhaps a person has, say, a pain in their toe, but they believe that pain emanates from an alien person who's inserted a tracking device into their toe. Okay, so that's bizarre because aliens aren't inserting tracking devices into our toes, right? But the pain is real. That piece of it is real, but it's what they think about that is delusional.
Okay. I want to ask you a question. I heard this mentioned a few times since our trial started. The belief in Santa Claus. Now, Santa Claus is not real. How is that different from a bizarre delusion?
So, that's a culturally accepted, I guess you could call, it's not a delusion, but it's a culturally accepted norm that we have in society, right? And eventually over time, kids start figuring out that, maybe this isn't real. They start challenging some of the notions that they had about Santa Claus, and they try to, sometimes even trick their parents into confessing, etc. So it's different in that it's culturally accepted. It becomes challenged by the person themselves, by the child themselves, and they outgrow that particular piece.
Okay. You have seen people other than Anissa suffering from delusions in the past.
Yes.
In cases where you've had people that you've evaluated who've suffered from delusions, have their families always picked up on that and noticed that?
No, not necessarily.
And is there always possible for, even let's say someone's a student and they go to school every day and they see the same teachers every day, is it always common or possible or observable by a teacher that you might come in contact with every day?
So with delusional disorder, people can behave in very normal ways when you're not tapping the delusion, so to speak. I've done many evaluations, people who have delusional disorder. When I can talk with them about their family, their education, their work history, and you wouldn't know that they had a delusional disorder. But the minute I tapped into it and I asked about it, then I would start getting all those beliefs about whatever the delusional system was that they believed. And so it's not uncommon, and the DSM talks about that people with delusional disorder can look very, I don't say normal, but that they can function well in whatever setting that they're in. That toe example that I gave you, I can, unless I start talking about the toe and the pain, that person may never tell me about it. So you can go about your life and have some bizarre delusions, and people may not necessarily detect it.
Let me ask you this. Have you had examples where you were doing interviews with someone and it took maybe hours before you picked up on the delusions that they were experiencing?
Yes, as I said, there have been cases where I know that they're using the not guilty by reason of mental disease or defect plea, that they've entered that, but I've gone in and it can take an hour, hour and a half before some of that starts to come out. And in some instances, what they tell you might be very believable, but when you check it against collateral information like the police reports and you talk to other people, you start to realize, well, okay, maybe they are delusional because what they're saying to me has no basis as to what other people are reporting.
Now I want to talk to you about the shared psychotic disorder as it applies to Anissa. How does that apply to her?
With the shared psychotic disorder and applying in this situation, if you remember what I said is that there's a primary person, the one who has more overt symptoms, has multiple types of symptoms as a psychotic disorder. I believe in this case, after looking at all the evidence, that Morgan is the one that was the primary. And Anissa was what's considered interchangeably called the recipient or the submissive or the secondary person. And what they had in common was the delusion about Slender Man and what they needed to do to go to Slender Mansion, and all of the characters associated with Slender Man. Jeff the Killer, I'm not recalling the other ones, but there were some other names of other killers or proxies that were associated with this delusion. And so it was their relationship that sort of gave the groundwork for the transference or the sharing of this delusion.
Okay. And you said that your opinion is that Anissa was the secondary and Morgan was the primary. I want to show you a clip, and I want to, you said that you reviewed the entire interview of Anissa. I just want to show you a short clip. Oops, I didn't have that.
That one, my friend Kelly gave me this one. Oh, they're neat. My nieces and nephews made me the rubber band one. Mm-hmm. Okay. All right, I will be right back with you, okay? Just give me a couple minutes. Okay. This is about Morgan. She can be a little jumpy and like get off task and look around and forget what she's saying in the middle of a sentence a lot. Okay. Because, like, she says she hears voices, too. But I just wanted to tell you. So we're aware of that? Maybe not put off by that, then? Okay. Well, thank you for telling me that. Okay.
Okay, and I wanted you to hear that, Doctor, because that's towards the beginning of Anissa's interview. And in the beginning of her interview, she's sharing with Detective Trusani some concerns about Morgan. Does that factor into your conclusion about Anissa being the secondary?
Yes, what's really interesting about this, the secondary can often help keep the primary person together, so to speak. They can do some caretaking for that primary person. And when you look at this, I mean, this is what she's doing, right? She is trying to help the detective say, hey, you know, Morgan sometimes, you know, you can't understand her. She gets confused. You know, she just wanted the detective to know. And I think the detective said, okay, so not to be put off by that, or something to that effect. That shows the type of relationship that they have, and it shows how the secondary can help along the primary maintain at least some semblance of just caretaking for that primary person.
Before we go further, where was it on your inventory of clips? I'm looking at Exhibit F1.
And Your Honor, we are in the process of generating a new one. Our computer person is in Madison and is supposed to be placing the time stamps in it. And I just sent him a reminder that he needs to get that done pronto.
So does that mean we don't have it?
At this second,
right.
No, Your Honor.
All right, we should just return at a certain point and put it in the record.
We will.
Okay. All right, very good.
And Doctor, I think you also mentioned something about symptoms that the two are experiencing. Is there something about what you know about Morgan that helped you determine that Morgan was the primary in this case?
Based on some of the, the information that I received in evidence, I was suspecting that she might have been the primary. And then I was able to obtain 3 reports of Morgan that were looking at different legal questions related to this case. And in there, the psychologist reviewed documents where she went after the interview and how she was, the symptoms she was manifesting, the disorders that she was, or disorder that she was diagnosed with. And so it helped establish or verify my belief that she was, or she is the primary in that relationship. And it's consistent because she was diagnosed with schizophrenia. She demonstrated multiple psychotic symptoms with the hallucinations and the delusions. And there's indications that these delusions and hallucinations were occurring, well prior to what happened in May of 2014.
Okay, and these were reports prepared by 3 child forensics doctors, right?
They were 3 forensic psychologists.
Okay. And in Anissa's interview, you looked through the entire interview, there were points in the interview where she started to express some, I don't know, some doubts, I guess, about Slender Man. Did that help you in terms of your assessing who the primary and the secondary was?
It made sense to me. So when you're shared psychotic disorder, a long time ago, had a French phrase. It was called folie à deux.
That had a French phrase.
Called folie à deux, which is F-O-L-I-E, and then there's a space A, and then a space D-E-U-X, which means madness shared by 2. Okay, and in that relationship, I'm sorry, can you restate the question one more time?
Okay. Anissa, during her interview, she made comments that appeared to be divorcing herself from the delusion after she was separated from Morgan. Did that play a role in your determining who the primary and who the secondary was?
Right. So the way they used to treat this, which is where I was going for, the way they used to treat it, they thought that separation was enough to help break that delusional connection, and that in time, because this person was technically healthier than what the primary person was, that over time they would lose the delusion or begin to challenge themselves, begin to have better contact with reality as related to the delusion. You know, nowadays, even though this isn't a common disorder, sometimes people do need antipsychotic medications. The secondary needs antipsychotic medications or group therapy or individual therapy. They may need some additional assistance other than just separation. But separation is crucial to help break, you know, sort of that, the intertwining of that delusional piece that keeps them together related to that delusional scheme they have.
Okay. Another thing that I believe you would have reviewed is some comments that Payton made about Anissa when she was outside of the presence of Morgan. I believe she described Anissa as being nice.
Relationship brought out different things in Anissa, and when she was away from Morgan, you know, the victim said that when she was in the presence of Morgan, she was mean and rude and, you know, would hit her. But outside of the presence, Anissa had apologized for her behavior, and she was much nicer to the victim. And so the victim's perceptions was that Anissa was doing this as part of the relation, or not, she didn't describe it as relationship, but, you know, to impress Morgan or to, it was just different with Morgan. Now, Anissa's father had also said that it seemed as though Anissa was sillier when she was with Morgan than with maybe other girls or other friends.
Okay. And is that something you would expect to see when the secondary and primary are together? Primary might be affected by the secondary?
There are no expectations because this is, you know, so rare, but it fits into that pattern. It fits into that relationship dynamic that I've talked about.
So the delusion that Anissa suffered from was what delusion?
She had the delusion about Slender Man, and there was several parts of it, but that Slender Man was a real individual who hunted children, and that he lived in Nicolet National Forest, and that to be a part of his world or to please him, that you needed to become a proxy, and to become a proxy you needed to kill a friend. And that at that point then you could become part of Slender Nation, and you would fall under the she likened it to military, the president, the general, you know, and then the people who follow the general. She likened it to that. You would, you know, do his bidding, so to speak.
Okay. You know, the delusion that Anissa had about Slender Man, what may have prevented her from realizing that that was a delusion?
There are a lot of factors that go into this. You know, first of all, she was 12, right? And so she was young, and she was looking at the Slender Man, or Creepypasta is the wiki that it's on, website. And she was looking at this website, and this website looks real, right? I mean, it has stories, it has clippings, it has articles that a 12-year-old might have difficulty distinguishing between what's real and not real. I mean, I work with kids who have ran into these problems, and the internet can be there are a lot of things, there can be things on the internet that are difficult for kids to understand are not real. I mean, adults sometimes have problems with it, right? I mean, we hear all sorts of stuff about fake news and articles that aren't real. Just in the recent past, there was a tweet about the wishing Miami International Airport, luck because they were underwater, but that wasn't even real. It was the New Mexico, it was some airport in Mexico, I think. And if adults have trouble with that, 12-year-old kids are going to have trouble with that because their brain isn't at the place where we're at as adults in terms of being able to discern or being able to have, to analyze, what's real and what's not real. And with this website, it's my understanding that it was after the fact that they posted on the website, that this is fictional, this is not real, it's not intended for anybody. But from my understanding, it wasn't there to begin with. And the deeper you go into it, she had described the website as when you would look at one story, based on what you looked at, it would feed you other stories. Just like, Google does, or, when we're shopping and then all of a sudden it shows up in our emails, right, that we've been shopping for this. Same concept, really, is that you get an article and then you get additional articles. So you have those two things working together. A third piece of this is that Anissa was brand new to the school that she was at. She had attended an out-of-district elementary school, and now she's coming into middle school in 6th grade, where she doesn't know anybody. And she was, as she described, desperate for friends. She had met Morgan relatively early, I think October, into the school year, and she said, I clung to her for dear life. I mean, she wanted a friend. She had talked about sitting at the lunch table and no one would, everybody had their friends. And so she was the new girl. So that certainly plays a piece of this whole puzzle, is that she wanted a friend. And, and so it's all that put together. She had a common interest with Morgan. They liked the horror stories, the paranormal, and so they had this common interest that brought them together, that they could discuss these issues, not issues, but discuss these stories. The problem was, Anissa would have no idea that Morgan was very susceptible to developing delusions around this, because she had already demonstrated some psychotic symptoms. She had already believed that some of the Harry Potter characters she could talk with, or that was part of what was going on for her. And so there's no way Anissa would know that, but it was the perfect storm of events, if you want to say. She introduced this to Morgan, and then Morgan integrated this into her delusional thinking patterns. And this was shared back with Anissa, and the two of them discussed these stories. And they would discuss them with other people too, a couple other people, but their belief in them and the sharing of that really, it like solidified it, made it a nice, tight, delusional scheme or system that they had between the two. So there's no contradictory evidence presented to either one of them between the two of them, right? And even if there was, Anissa often said, I wanted to prove the skeptics wrong. I wanted to prove the critics wrong. This was real. So again, you have all of these events that are occurring simultaneously that could probably never be recreated again because it was just this perfect storm of all of these factors.
Okay. And I want to have you talk about something that you just mentioned, because in Anissa's recorded interview, she does say when she was searching Slender Man on the internet, there were skeptics. So she believed Slender Man was real. She saw evidence that Slender Man was real on the internet, but she also saw people that were skeptics. How do you explain her holding on to those delusional beliefs in the face of that, contradictory evidence there?
She had a real life person that was a partner in the delusional system with her that could help reinforce it. There was probably a transition time, maybe where she had some doubts from time to time. I mean, that would be kind of normal, especially in a developing psychotic disorder. But over the course of time, she was intent to prove these people wrong, that he was real, and that he, could do harm to children and walked around in the woods, but you couldn't see him. I mean, she believed all of that.
Okay. So I want to ask you this. You didn't meet with Anissa in 2014. When did you meet with Anissa in person?
I met with her on September 20th in 2016.
And when you met with her, I think some of the comments that she made to you were different than the comments she made initially after this happened.
Correct.
And do you recall some of the comments that she may have made to you?
So 2 years later, Anissa's trying to make sense of what's happened in this situation. And she is clearly trying to, what I'd say, divorce herself from having that belief. I mean, she demonstrated a lot of self-loathing and described herself as a monster for doing this. And, imagine this is from 12 to 14-year-old brain trying to make sense of what has happened. I think her father remarked that early on, she said, how could my brain let me do this? So she is psychologically trying to figure out, and she doesn't want to be crazy. She doesn't want that. And so at this point, I think we're seeing the process of her trying to make sense of that and saying, I couldn't have believed that. I don't believe that. But if you go back through the evidence, and if you go back through all the other information, it truly believes as she did believe that. And there were actually indications also in the interview that she still holds on to it. It's changed a little bit, but that she still holds on to it. At one point, I asked her, in the end, you didn't prove either way whether or not Slender Man was real or not real. And she looked at me and she goes, exactly. It told me that she still has a piece of it. And then she goes on to describe, well, if he is real, he must be the devil. And she talked about now having a belief in God, and that, that those are her beliefs, and that if Slender Man is real, he must be the devil. So there's still this piece of it. She wants to intellectually say, I didn't believe that. But her belief and her statements indicate that there's still like that core piece is there, or at least, the core delusional system is there. And just like I talked about, just generally speaking, with shared psychotic disorder or anybody with a delusion, it's not going to stay the same from the age of 18 to 33. It does change over time, but the core is still the same.
Okay. So when you met with her, she was 14 years old, right?
She was.
And She was basically talking to you about, again, something she did when she was 12.
Yes.
And 14-year-olds, you probably had experience with 14-year-olds multiple times, hundreds of times, thousands of times over your years of practicing as a psychologist.
Yes.
And you would probably agree that a teenager doesn't want to be seen as different.
Right, I think, yes, I would agree with that statement.
So when you're talking to her at 14, she's trying to divorce herself from those things that made her different from other kids.
Yeah, that's how I interpreted what we're seeing now, or the statements that we're seeing now, is she's just psychologically trying to make sense of this. I mean, adolescence, from puberty on, you're just trying to make sense of who you are and where you are in the world and what the world means. And so now you have this very significant event, this or incident, you have a mental health disorder, and trying to make sense of that that could be overwhelming.
Okay. I believe you looked at some of the accounts of what happened that she made around the time that this occurred to other, doctors as well. Did you have access to other statements that she's made to other individuals about what happened in 2014?
Yes, there were provided to me were other reports that have been generated based on previous hearings on other legal issues as related to it. And so I had those available to me. And for some of those reports, they talked about the incident, what happened, and her belief in these things. And it was consistent. Those were all consistent.
Did you ultimately reach a conclusion on whether or not Anissa suffered from a mental disease or defect? And by that I mean an abnormal condition of the mind substantially affecting her mental or emotional processes?
I did.
And what is that mental disease or defect again that you diagnosed?
So I'll shared psychotic disorder, but formally, according to the DSM-5, I'm going to read it here, other specified schizophrenia spectrum and other psychotic disorder, delusional symptoms in partner of individual with delusional disorder.
And did you reach an opinion regarding whether, as a result of that mental disease or defect, Anissa lacked substantial capacity either to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law?
I did.
And what was your conclusion regarding that?
I concluded that she could not conform her conduct to the requirements of the law.
And I want you to explain how you and why you reached that conclusion.
So I looked at, the events of the day, of what happened, beginning with when they were first talked about Slender Man, when she introduced Slender Man to Morgan, which was, I believe, in October of 2013. And then in evidence there are, email exchanges that they had, and there's her report of their discussions. And it pretty much consistently, everybody says in February 2014 is when Morgan came to her and said, we can become proxies by killing a friend. And at that point, the victim was selected. And they went about planning, when it was going to happen or how it was going to happen. And as you fast forward, they made some plans in preparation to do that, and it was over the course of these months that they planned it. They took actions that would accommodate when they would be gone. Say, like Anissa left a note on her phone saying, "Don't miss me, family. You don't deserve me. I'm not perfect," something to that effect. And so I'm looking at all that information, and then I'm looking also at the actual 3 times that there are 3 plans that they come up with during the May 30th to May 31st. And because of their inept plans, how they kept working this, because they had started this plan. This plan was they had to kill someone to become proxies, and then they were walking to Nicolay Forest, right? They got a map of how to get there. All these things, and the 3 plans that they had really indicated that they felt compelled to do it. They felt like they could not comply with the law. They had to do this plan as part of their delusional system. They had to do this plan, and then they were going to walk to Nicolay, and that's what they did, the Nicolay National Forest. That's what they did. They attempted to walk there. And so that evidence indicated to me that they couldn't conform their behavior to the requirements of the law.
Okay, so she was willing to leave her family behind and walk to Slender Mansion in Nicolay National Forest. Did that impact the conclusion that you reached?
Right, I think that just further supports the belief of the compelling nature. This is a 12-year-old girl, or these are 12-year-old girls who are willingly giving up their family because they feel that they have to do it. Otherwise, Slender Man may come back and harm their families. And at some point, Anissa really believed that if she didn't go with, that Morgan might successfully get there and come back and kill her family. And despite having what she called mental breakdowns along the way, I'm assuming these were because of the trauma that had happened, that these were a lot of anxiety and fear and feeling very scared, these moments, they continued on their path. I mean, they considered, should we give up? But they couldn't. They had to keep going.
Okay. And as they were going, they reported seeing Slender Man as they were walking to his mansion. Did that in any way impact your conclusion?
I think it's consistent with what I've said before. At some point, they come to a tree and they mark an X on the tree, I think in a circle, but I'm not sure about that, but an X on the tree, and then Morgan said some sort of, I think she described as weird poem, and she felt that she saw Slender Man out of the corner of her eye, adding, but he's really quick, you can't hardly see him, he's black and white, so it's seeing something out of the corner of her eye, which she interpreted as that was Slender Man, and she said Morgan saw the same thing.
Okay. I want to give you what I believe could be an alternate rationale for Anissa's actions that day. She was close friends with Morgan.
Yes.
And did she tell you that as well when you talked to her?
Yeah, she described their relationship as, best friends. I don't know if she used the word best friend, but she said she clung to her for dear life, which indicates a very close relationship.
Did you consider that maybe she was doing it because she did not want to lose that close relationship with Morgan?
You consider, I guess, all the possibilities, but there didn't seem to ever be a threat that Morgan wasn't going to be her friend, that Anissa needed to do something to maintain the friendship. And, from all the reports, Morgan was very much shunned by her peers. And people thought she was weird and odd, and they didn't want to, the teachers described her as nobody wanted to sit next to her or do projects with her. So if Anissa didn't believe these things, she would likely be much more similar to those peers that didn't want to be around Morgan. Because Morgan was odd, and at 12, that was very odd behavior that people didn't want to be associated with. So I didn't see any evidence that she couldn't maintain this friendship if she didn't go through with the plan. And I think if she didn't believe in this system that was in place, that she might not have maintained herself that friendship with Morgan.
Okay. I want to talk to you now about just how they plan to harm Payton.
I think at this point we're going to take a brief recess. I think that's an appropriate breaking point. So let's take about a 15-minute recess then. right, I think we're all here. Thank you. Please be seated. We'll be back on the record then in State versus Weier, same case number and appearances. Dr. Westendorf is on the stand and under oath and being questioned by Attorney Smith.
And Doctor, I believe when we left off, I had started to ask if there was anything about the way that Anissa and Morgan planned to harm Payton that affects your opinions.
With regards to planning, or there were essentially 3 plans that they developed, not all at one time, but the first time it occurred in the middle of the night. They were going to wake up. They believed that if someone is sleeping, they can't scream, and that you, off of the Slender Man or the creepypasta website, you never want to kill someone when their eyes are open because then you see your reflection. So that was the first plan. But Morgan said, no, not now. It's, I know what you're like when you're sleepy, or I know what you're like at this time. So they went back to bed. They continued talking about it that next morning when they got up, despite engaging in what would seem like normal 12-year-old behaviors, playing dress up, playing silly putty, answering those questions on the websites. They were contemplating, how are we going to do this? They continued to develop another plan, and at that point then they developed the plan of going into the restroom in the park. They get to the park, and while they're trying to do this, Anissa was supposed to be the first person, or was supposed to be the person who would do it. She couldn't do it, and so the knife gets handed back and forth. They tell the victim to go to sleep, because remember the eye, not to look in the eye. Well, the victim's like, I'm not going to sleep now. It's, they're in the bathroom. They just tried to, this plan isn't working. It's not. They hit her head against the wall, and I don't know how hard, but they hit her head against the wall, maybe to knock her out, which didn't work. I mean, the victim was even understanding that something is odd going on. And Anissa described this as, Morgan was having nervous breakdowns. Those were her words. And so she was trying to help her, calm her down. And so then when they sent out the victim, they came up with another plan. Okay, what are we going to do next? Let's go into the woods. Let's play hide and seek in the woods. And so they did that, and again, there was a bunch of back and forth. Anissa couldn't do it. She didn't want the knife. She couldn't do it. And that's when, unfortunately, Morgan had it and harmed the victim. This tells me that they were compelled to follow through with this plan of killing the victim and heading up to Slender Mansion. As inept as it was driven. They were compelled. They had to continue on with this plan. And I think that's what all these different attempts or plans, to try and harm the victim indicate.
And you said just a moment ago that, again, Anissa was provided the knife and she could not do it. Anissa did, though, tell Morgan to do it when Morgan said, I'm not going to do it until you tell me to do it. And how does that affect your belief that there was that delusion that Anissa was suffering from?
I think that goes to sort of, if you imagine like a crescendo. I mean, these events are transpiring, and these are traumatic events that are occurring, that they're trying to enact this traumatic plan, and this is starting to overwhelm her, and she said she couldn't look at it. She just wanted it over with. She wanted to go home, but eventually later she says, I couldn't go home because Morgan might become a proxy and then come back and kill me and finish the plan. So it was this crescendo to this event, to the harm that was caused, and it was just so overwhelming for her. And again, all this stress is leading up to this moment, and now this moment's happened, and now they have to continue on with the plan. I mean, really, that's not the end game, that was the middle of it. Now they had the next act of they had to walk to Slender Mansion, which at that time, at least initially, they believed was almost 4,000 miles away.
And I want to talk to you a little bit about some of the preparation for that, what they thought was a 4,000-mile walk. As you know, they had a purse, and that purse was filled with 2 water bottles, some granola bars, sanitation napkins. They didn't have a GPS, they didn't have a phone, they didn't have a tent, no blanket, they had no money with them. That part of the preparation, how does that have an effect on the conclusions you reached?
To some extent, it shows that they're 12-year-old girls who don't, that's not a plan to walk 4,000 miles, right? The other thing that they had was pictures of their families. They did not believe they were coming home. And it wasn't because of the police. They didn't believe they were coming home because of Slender Man. They were going to be living in this forest. She said they didn't take money. You don't need money at Slender Mansion. He takes care of your needs. Slender Man was going to be, they were going to be with him, right? They were going to be these recluses, I think she said, that lived in Slender Mansion. I don't know if they had a real conceptual formulation of what Slender Mansion looked like. They just knew it was in Nicolet National Forest. I didn't hear any talk about what the house looks like. They just would know it, right? And that's part of the delusion. There's always cracks in the delusion that the person who doesn't have it says, well, what about this? Remember, there's no surgery scars on you. So how could you have had surgery? That part doesn't matter. It's the whole delusional scheme that was important. They were going to be heading to Slender Mansion.
Okay. And I want to go back to something I think that we touched on a little bit earlier. During her interviews, Anissa started to divorce herself from the delusion a bit after she was taken into custody. Did you, when you watched the video, did you see a little bit of that?
There was a little bit. I mean, she certainly, when she described Slender Man and Slender Mansion, she looked like she believed it. I mean, the way that she talked about it. But I think there were some comments about, he can't be real or he must not be real. And I think what happened there is this was such a traumatic event. I mean, clearly for the victim, this is traumatic for these girls as well. And it sort of, what I'd say shook the tree of Anissa. And some of the delusional leaves started falling off, saying, wait a minute, what is happening here? Now, I mean, I still believe some of those leaves still exist on this tree, based on what I talked about before, what she shared with me. But I think that incident and that attack shook that tree enough for her to start to really, the confusion for her, I think we're starting to see at that point. But there, certainly during the interview, she certainly describes what they were going to do, how they had to do it, what must be done, the fear about her harming their family. That was still there too.
Okay. And I want to show a few clips from her interview just to let you look at those and maybe provide some information about how what I'm going to show you impacted your conclusions.
While you're working on obtaining the video clips, is this from the same source as the previous clip you showed?
It is.
So we'll be able to have a way to identify the location of the clip?
Yes.
And you have the data that you'll file?
Correct.
All right, thank you.
That one doesn't work once you go to that. See if the third one works.
We played around a little bit. Morgan kind of started freaking out a little bit, so I said, Bella, I need to talk to Morgan. She's freaking out a little bit. What was she freaking out about? Killing. She had never done that before. She's stabbed apples before. Okay. It was like chopsticks. Okay. But she never actually cut a flesh wound into somebody. How was she freaking out? What was she doing? She said, I can't do this. I'm too scared. You have to. Did Bella hear this? No, Bella was outside. I told her to go outside and play. Yeah, this was in the bathroom. And then Morgan started freaking out, so I had to hug her and calm her down.
Okay, so what Anissa's talking about there is what happened in the bathroom when they were going to stab Payton in the bathroom, and Morgan couldn't do it and started freaking out. And you saw that before, and you factored that into the conclusions that you reached in your reports, right?
Yes.
And what does that show you? I mean, what does that help you in your conclusions to form opinions about?
Well, it helps to set what was going on for the girls at the time, that this was an extremely stressful event, and that Morgan this is, I think, what Anissa's talking about, the nervous breakdowns as she describes them to me. I think this is what she's talking about, and that she was trying to calm her down and soothe her. Again, that's the secondary or the submissive's sort of job in this relationship. It seemed as though she was trying to help Morgan, and this is an example of her doing that, even though this is very traumatic for the both of them.
You can go ahead.
I said, hey, we could go to the park and kill her in one of the bathroom stalls. When was that said, last night or this morning? This morning. Was Bella around at that time? Yeah, Bella, we were playing dress up, and Bella was putting on a costume in the bathroom, a princess gown, a pink one. So Morgan said, we have to kill Bella today, and I was like, but can't we stay another night and do it tonight? Because I was still kind of scared and kind of hopeful. Scared and kind of hopeful. What do you mean by that? Like, I was scared because, A, I would never see my family again, and B, I was kind of hopeful to prove that I wasn't crazy, that I wasn't seeing things. Because even I saw Slender a few times. Okay. I think that was probably my mind playing tricks on me. When was this before the party that you saw Slender? You've seen him before? Twice. Once, well, they were both on a bus. We ride the same bus, just to and from school. So we were, talking on the bus. I look out the window and I see this, supposed thing standing like this, with tendrils, looks exactly like a tree. They were gone like that. And I told Morgan, and so I actually thought that he was real, because I saw him. And you call them tentacles? Tendrils. Tendrils.
Okay, in that clip, Anissa's describing seeing Slender Man before the stabbing occurred. But she also says in that clip that could have been my mind probably playing tricks on me. So, what does that tell you?
These are the moments where that tree is shaking. When she first said slender, she went slender. But then she says, I was scared because he was going to kill my family, and I was scared about all of this stuff. This was very scary for her. She believed him. She wanted to prove the critics wrong, right? That was her second point. She wanted to prove them wrong. This goes to the fact that she believed, and her desire to prove these people wrong, that he was real. I've seen him. Was very compelling to her, and that she needed to continue with this plan. Now, these are crucial moments right here where you see that she's trying to make sense of this. I mean, this is an extremely traumatic event and causing her to think, what is going on right now?
Morgan and I rode the bus to our house. We went to my house so I could pick up my things. I also picked up 2 pictures of my family. Okay. One of them was one of my siblings and me when we were really young.
How did you do that?
Memories.
Okay.
And then we went around grabbing stuff like Kudos, granola bars, and water bottles. The water bottles are mine.
Okay. So you were packing a bag
So she's talking about her preparations again, the things that she got together for her 4,000-mile walk to Slender Man, and the pictures that she packed. And again, that helped form your conclusions in what way?
It formed the conclusion that she didn't plan on coming back. She planned on being gone from her family. Not related to being picked up by the police, but being gone from her family because she was going to be living in Slender Mansion. And at some point, the delusion incorporates that she's protecting her family, that if she doesn't go up there, he'll come back and kill her family. So there's a little bit, there's multiple parts to this delusion, but she didn't believe she'd be back to see them. That's why she left the note on her phone as well, saying, I'm not the perfect daughter for you. I think she was giving away her worldly possessions to her parents. She didn't intend to be at home.
When the son was walking away, Morgan said that she wouldn't do the deed until I said she could, so I kind of started to walk away, and then I said no, and Morgan said, don't be afraid, I'm only a little kitty cat, and then lunged for Payton, the ballistic.
So that's Anissa. She's talking about not being able to do it herself, but again saying to Morgan, do it. And how does that, what impact did that have on your conclusions?
It goes to their relationship, the strength of their relationship. Morgan says, I can't do this unless you tell me, so Anissa's stepping in at this point to assist with Morgan. And it also, I guess it goes to the fact that, this was becoming overwhelming for Anissa. She said she had to turn around, walk away, and she just, she said the words.
And does that also in any way show any insight into her belief that it needed to be done?
I think the whole series of events...
I'll object to the question, it's leading.
Overruled.
Can I have the question again, please?
does this also have, I guess, some insight into Anissa's belief that this needed to be done?
As I've stated earlier, I thought all of the behaviors that occurred during this time frame on the 31st just goes to show the compelling nature of what they felt they needed to do.
This is the last video clip I'll show.
If we saw him, actually, we think we see him sometimes.
Okay.
Like when we were walking up to where we were going, we saw him, like, I saw him out of the corner of my eye on this side.
Okay.
And then Morgan said she heard a twig crack when no one was moving.
So today, after everything happened with Bella, when you guys were walking, you thought you saw Slender as you were walking?
This was after Morgan stabbed her.
Okay. So you thought that possibly you would see the Slender? Okay.
Okay. And can you tell me how that played a part in your conclusions?
I think it just further supports that she believed Slender Man was real. I think this is the incident, when she was describing it to me, they put the X in the tree. And I think you've seen pictures of what's supposed to be Slender Man's face, and there's X's for eyes. I think that's all part of what she was telling me 2 years later, is that she felt she saw him out of the corner of her eye, and that Morgan saw it as well. So again, you have just, this traumatic event that occurred. She's still believing that Slender Man is real on this walk, and that she's moving towards the Slender Mansion.
And you still have Exhibit X in front of you?
I do.
And the information contained in Exhibit X is accurate?
Yes.
So are there any changes that you would make to your opinions and conclusions today?
No.
Judges, if I haven't done so, I would like to move in Exhibits W and X into evidence.
Any objections?
No.
Received.
And Doctor, just a few more questions. Did you eventually receive copies of Dr. Caldwell's and Dr. Van Rybrook's not guilty by reasons of mental disease and defect reports?
I did.
And again, did you receive those before or after you submitted your report to the court?
I received it afterwards.
And did you review those reports in their entirety?
I did.
Okay. Did their conclusions and opinions have any impact or effect on the opinions and conclusions that you hold?
It didn't alter any of my opinions or conclusions at all.
Okay. There's a few more questions I want to ask you. But the opinions that you hold and that you testified to today, do you hold those opinions to a reasonable degree of professional certainty within the field of psychology?
Yes.
Okay. And the last thing I want to ask you, there was some mention earlier about the belief in Santa Claus. Is the delusion that Anissa suffered from the same as a magical belief in Santa Claus?
I would describe it differently. Certainly we share with our children this belief in Santa Claus. It's culturally accepted, this belief in Santa Claus. But if you look at adults who have delusions, some of them have delusions about being Jesus or being God. And so what they do is they take what's been culturally accepted, figures in our society, and they incorporate themselves into it. this is very similar here with this delusion of Slender Man, is that they've incorporated themselves into it. Because Slender Man, despite adults maybe not knowing about it, it appeared to be part of the culture of middle school. At least there seemed to be a lot of people who knew about Slender Man. And so that was part of their culture, and they incorporated themselves into that culture. The magical thinking towards Santa Claus, I said before, we all know this. Kids start doubting it, right? As they reach a certain age and their brains are developing, they can start challenging some of those concepts. We have to remember these girls were 12 as well. Morgan was much more susceptible. Her magical thinking took on a delusional quality earlier, right? She had delusions about Harry Potter and Voldemort and Snape. Anissa still had that magical thinking as well. This occurred over a short period of time, within 6 months, 7 months. That it's different than Santa Claus because they were incorporating themselves into this whole genre of Slender Man.
I don't have any other questions, Judge.
All right, thank you. Cross-examination.
Doctor, I guess I'll start there. You said this is part of the middle school culture, right?
It appeared as though other kids knew about Slender Man.
There are no other cases of any other 12-year-olds trying to kill somebody as part of a belief in Slender Man, are there?
Not that I've ever heard of.
Okay. I want to make sure that I understand your opinion that they could not conform their conduct to the requirements of the law, right?
Yes.
That's your opinion.
That is my opinion.
And that's based upon them wanting to become proxies, right?
Yes.
And based upon them fearing that if they don't go through with this killing, Slender Man's going to hurt them or their families, right?
Overall, yes.
A belief that they were in some danger.
Correct.
And your opinion is that they were able to appreciate the wrongfulness of this conduct, right?
Certainly, they seem, they questioned that, could they get the electric chair? Now that's juxtaposed with them also saying, am I going to miss school on Monday? But they had a concept that this was wrong, the killing was wrong.
You testified earlier that this shared delusional disorder is very rare, correct?
Correct.
And even among shared delusional disorder cases, one between two friends is even rarer, right?
Of the cases I read, I didn't see one between two children who were friends.
Okay. Typically, you testified that it's a spousal. That's one of the typical types, correct?
Yes.
Maybe between siblings, right?
Yes.
Maybe between parent-child.
Absolutely.
All of those would be more common than between friends and even friends that are children, right?
Those are the cases that I was able to, that I've read about. I mean, there was one exception. There was an individual and a dog that they thought was part of it, which is truly exceptional. This, I didn't read any that included two children like this.
You said a couple of times that Anissa was trying to make sense of what happened, right?
Yes.
She didn't ever say to you, Dr. Westendorf, I'm trying to make sense of what happened, did she?
No.
That's your perception, is that she's trying to make sense of what happened, right?
Yes, those are my adult words on probably an unconscious process, not something she can comprehend that's going on at the time.
And you saw some clips from the interview with Detective Trusoni about Anissa saying she may have seen Slender Man and she certainly believes in Slender Man, right?
Yes.
But by the end of that interview, she says he's a work of fiction, and I believe that people who say that they have seen him in person have read creepypasta and then recall memories of strange trees instead of the Slender, because I know that was one of the cases on the bus. I looked back at the tree and it was strange. That's what she told Detective Trussoni.
Yes.
I'm going to just go through a few of the other things that she told you. She told you that in October of 2013, she was desperate for a friend, right?
Yes.
She had switched to the middle school, and all the kids from her elementary school went to a different middle school, right?
Right.
She went to Horny, right?
Yes.
She had nobody there that she was friends with, right?
Correct.
She met Morgan, right?
She did.
And she told you that she clung to Morgan for dear life.
Right.
It was Anissa that introduced Morgan to creepypasta, right?
It was.
And it was Morgan who told Anissa that they should become proxies.
It was Morgan that told Anissa. Yes. Right. Yes.
And Morgan told Anissa they should kill Payton in order to become proxies.
Yes.
Anissa said that she didn't want Morgan to feel crazy, so she said yeah. Right?
That's what she said, yes.
She also said that she didn't think Morgan was serious, right?
Correct.
And that they wouldn't literally try to kill Payton, right? That's what Anissa said?
Right, that's what Anissa said to me in 2016.
They began planning, right?
Yes.
Anissa told you that it was exciting to talk about this, right?
Yes.
Like discovering something new, right?
Yes.
They spoke about these plans almost every day.
Yes, I believe on the bus every day.
There were times that Anissa thought about calling it off, though, right?
Yes.
But she felt we're too far in. Morgan's been planning this whole thing out and building this up, and I don't want to pull the rug out from under her, right?
Yes.
She just followed Morgan because Morgan was doing most of the work.
Yes.
And again, she said, I didn't think we were going to try to kill her, right?
Right.
She told you some different things about Slender Man as far as whether she believed in him or not, right?
Yes.
Well, at one point she said, I never really believed in him, right?
Right.
And at another point, your report says that Anissa told you she estimated half of her believed in Slender Man.
Right.
And I want to. You took very detailed notes while you interviewed Anissa. Is that fair to say?
Yes.
And you did that because you wanted to be able to refer to those notes when you wrote your report, right?
I type my notes because it's easier for me, it's faster for me, yes.
Okay. And you go back and use those notes in creating your report, right?
I do. I can't use everything that's in it or my reports would be very lengthy, but I use the salient features of my notes in the reports. Absolutely.
The most important things from your notes go in your report.
Right. I mean, several of those things can be repeated several times, but yeah.
Okay. I'm going to show you, Doctor, what's marked as Exhibit 4. Do you recognize that as a copy of your notes?
Yes.
And I guess I would refer you to page 6, paragraph 6. I think that's where you get the information about Anissa at one point saying, well, I half believed in him and I half didn't believe he was real. You see that on page 6?
Oh, yes, 45% believed it, that paragraph.
Right. So she really told you 45% believed it and 55% she didn't believe it, right?
Typically, my question isn't in there, but I ask for, what percent of you believed it, what percent of you didn't believe it.
And I guess it's kind of nitpicky. It is kind of half, but 45% versus 55%.
Correct.
But after that, she says, there were things that I could explain that I don't think supernatural could explain. I didn't want to tell Morgan because I didn't want to make her feel crazy, right?
Yes.
So she's talking about Slender Man, right?
Yes.
And then at another point, she tells you, I did believe in him, but by May, I started to think it was crazy, right?
I don't see that in this paragraph, but certainly she did say that.
I'm sorry, not referring to you
okay,
anymore, I'm sorry.
That's okay.
But she did at some point tell you that by May, I started to think it was crazy.
She did.
You didn't have any issues in your interview with Anissa regarding whether or not she was competent or not, did you?
No.
No concerns about that?
No, if you mean like if she could talk with me, if she was, you don't mean competent to stand trial?
Well, either one.
Any of them. No, I mean, she was well aware why I was there, what we were going to be talking about. I mean, she understood what was going on, certainly.
And had you ever reviewed Dr. Caldwell's report where he determined she was not competent to stand trial?
The competency report, I know I believe I had three competency reports on Anissa, and I believe I was able to see the competency evaluation.
Okay. Do you recall whether one of those was Dr. Caldwell's?
I'm just going to look up because there's been a lot of yes, it was a report dated 12/5/2014 authored by Dr. Michael Caldwell.
I don't have anything else. Thank you, Doctor.
Thank you. Attorney Smith, redirect.
Thank you. Doctor, I just want to ask you some questions about just kids and their sort of their beliefs and what it might mean to cause a death. You've had occasions to actually, unfortunately, discuss.
I guess I'll object, Judge. This is beyond the scope of the cross. If you wanted to go into this area, you should have done it on direct.
Now, I don't yet know what he's going to say. I heard the word death and cause of death, but I'd like to get the question out and then I'll address the objection.
Sorry.
I was just going to ask you, Judge, generally what you've come to perceive as what some kids and younger kids might believe that happens when you die.
It's a big question.
Oh, wait, now, there was an objection. Are you renewing the objection?
I maintain the objection,
Okay.
yes.
All right.
Sorry.
All right. All right. Well, I think I'm satisfied that's beyond the scope of the cross-examination.
Okay, but that came to my mind, Judge, because I thought on cross, Attorney Sapaka was asked the doctor what Anissa thought was going to happen if she helped kill Payton.
I recall that conversation or that question. It's still your question or the area you've about to move into. It seems to. I'm satisfied is beyond what was Mr. Sapakowic's cross. Now, at this type of trial, of course, if you made a motion to direct the court's attention to an aspect of the case, I'd consider it.
So I'm asking the court to allow her to give her opinion on that in light of that question that was asked earlier on the
So
cross-examination.
you're asking actually to reopen the direct exam?
Yes.
All right. Mr. Sapakowicz, any comments?
No?
No. All right. I'll permit you to reopen the direct exam and go forward.
Thank you. And can you, Doctor, answer that question?
So kids may not, they don't have a good understanding what death and dying means. In my notes, from what she talked about with me, that there was some sense of, it's like a video game. They would just sort of fade away when that happens in a video game. And then her next comment was, I didn't know it would take so long. She's 12. She doesn't have a good concept of what dying and death, what that really means, in the grand scheme of things. There are kids, very young kids who have committed suicide, and they don't have a concept of what it means that they no longer be around. They think they can resolve whatever's going on at the time and then move forward. Again, it's their brain development, right? I mean, the neuronal pathways that develop to help us with impulse control and executive functioning and making decisions and being able to analyze situations, it really begins in puberty, right? And at 12, she was prepubescent. She hadn't really, that process was not, she wasn't very far along in that process that they had started. And that's why kids, they can believe in the magical thinking of various characters. They can believe in that dying is like a video game, and you just start over again.
And then I wanted to, if I can, ask questions about comments that Anissa made to you when you met with her in September of 2016. She began to divorce herself from the delusions when you met with her.
Yes, clearly.
And one of the things that you did was you not only looked at the recorded interview she gave to Detective Trissani, but again, you looked at her account of the events when she spoke with other doctors close to the time period in which this took place.
Yes.
Okay, and when she spoke to those other doctors, let me give you an example. One of the reports you looked at a report authored by Dr. Antoinette Kavanaugh. Her report's dated May 22nd, 2015, but she met with Anissa prior to that date. Is that correct?
Yes.
And do you recall whether the account she gave to Dr. Kavanaugh of what happened, was it consistent or inconsistent with what she told Detective Trissani?
For the most part, it was consistent.
And you looked at reports dated September 5th, 2014, September 14th, 2014, December 12th, 2014, prepared by Dr. Anthony Jurek. And she gave accounts of what happened on the date of the offense to that doctor as well, isn't that correct?
She did.
And was her account of what happened to Dr. Jurek consistent or inconsistent with what she told Detective Trusani?
In all of these reports, it was consistent. The way she discussed her beliefs and the beliefs in Slender Man.
Okay. And so so those were both psychologists, right?
They are, yes.
And Dr. Michael Caldwell, Dr. Robert Roski, they're both psychologists as well?
Dr. Roski is the psychiatrist.
Okay, thank you. And they both spoke with Anissa about the events that happened on the date of the offense as well?
I believe so, yes.
And as far as you're aware, were there reports to those two doctors consistent or inconsistent with what she shared with Detective Trusani?
I believe they're consistent. My memory of Dr. Roski's, as it was dealing primarily with a competency issue, I don't remember as much detail on that report, but otherwise, it was consistent.
Okay, so how did that impact your belief about what Anissa believed on the date that she participated in the stabbing of Payton?
That she believed the whole delusional pattern of Slender Man and Slender Nation, and what she needed to do to save herself, save her family. That's consistent, and it makes sense to me based on my training and experience and education that at this point she's trying to, what I say is, make sense of what has happened and trying to pull herself back from not wanting to look, quote, crazy in her words.
I don't have any other questions, Judge.
All right, additional cross. I heard you again, Doctor, say that Anissa believed she needed to do this to save herself and her family, right?
Yes.
And by this, we mean stab and kill Payton, correct?
Yes.
And your opinion that she wasn't able to conform her conduct to the requirements of the law, that she was compelled, as you've said, was because she needed to kill Payton to save herself and her family, right? In part.
In part, my conclusions are based that all of her behavior was driven on this delusional belief about Slender Man, about proxies, about what you needed to do to become a proxy. And through the course of on that day, it appears as though she begins talking about the going to harm my family. I don't want them to harm my family. I don't want Morgan to go alone because she'll become a proxy and come back and harm the family. So delusions are never neat, right? There's many parts of them, and all of that together is what drove the behavior.
But you did just testify that prior to stabbing Payton, she believed that she needed to do it to save herself and her family. I can have the reporter read back your answer to that question.
Right. I guess what I would say is, when was the specific moment that she believed that Slender Man would come back and harm her family? I'm not sure about that. But I know that it was part and parcel of this Slender Man delusion. Whether she read about what he might do if you don't become a proxy, I'm not sure where that piece of it came. For example, she talked about on the Slender Man website you could read, kill somebody when their eyes are closed because you don't want to see yourself in their eyes. So I'm not exactly sure what she all took from the website and when exactly she knew it. But my opinion is based on the fact that she believed in this entire delusional world of Slender Man.
I think you testified earlier, part of what she believed was that at the time Payton was stabbed and they tried to kill her, they did it because they were afraid Slender Man was going to harm them or their families, right?
If that was part of my answer, yes.
Part of what you based your opinion, right?
Yes.
And I guess I'll clarify that. I think we understood each other, but that was something that Anissa believed, right?
Yes.
Okay. Thank you. Nothing else.
Any further direct?
Just a few more questions. Doctor, you said that what you do know is that her behavior, it was driven by her delusional belief system.
Yes.
Right? And does it matter, in your opinion, whether her belief that Slender Man was going to come back and kill her and her family before or after the act?
The biggest component to me is that she believed this entire system and incorporated herself into this entire world. Where the specific beliefs come in and at what time is, I guess, I don't want to say less relevant, but came at different times that I specifically don't know exactly when they came into play. But again, I'm looking at the totality, the overall. She had this belief, and that's what drove the behavior and compelled her to continue on with the plan.
I guess the last question I wanted to, ask is it common for a delusional belief system to be just like neatly presented, described, and is that, or does it morph at times? Does delusional beliefs, are they easy to just, categorize and explain and figure out?
All delusions are different. When you're working with someone with a delusional disorder and they're expressing their delusions, there's going to be holes in their delusions. I mean, there's just holes in it, right? Because it's a delusion. It's not reality. And so even if you try to ask questions about it, you can't make this a nice, neat package. And it changes, like I said, over time. It's going to change or morph as they start, or as the individual starts incorporating other parts into the delusion. So it doesn't maintain an entire consistency. It doesn't stay the same the entire time, and it's never just a entirely consistent, system.
Thank you, Judge.
All right, any further cross?
No, thank you, Judge.
All right, with that, then, our examination then of Dr. Westendorf is complete. Is Dr. Westendorf under subpoena?
She is, Judge. We'll release her from the subpoena.
Any objections?
No.
All right.
I would move, Judge, for the admission of Exhibit 4.
Excuse me? Yes. Okay, just before you leave, Doctor, I have to receive the exhibit. So Exhibit 4 has been moved into admission. That would be Dr. Westendorf's notes. Any objection?
No, Judge. No.
Okay, received. Then, Doctor, you're excused. Thank you. Have a good day. With that, then, further witnesses?
And Judge, Dr. Westendorf was the remaining witness that we had for this afternoon. Tomorrow we'll have Dr. Van Rybrook and Dr. Caldwell and Mr. Allen, and those will be the three remaining witnesses that we have.
All right. Very good. Well, at this point, then, we'll recess for the day. We'll start again tomorrow at 8:30 in the morning. So Ken will take care of collecting everything that you have. Have a good evening and a restful evening. We'll see you in the morning. Thank you.
Bring your notes with you then.
All right, thank you. You can be seated. I did distribute proposed jury instructions, so you get a chance to look at them along with a sample verdict. We'll discuss those later, but just wanted to note that they've been distributed. On the standard instruction 158, which addresses recorded material, I modified that instruction to take into account that the instruction appeared to be one that would typically be read before recorded statements were read. I modified it to fit in more with what happened, just what the witness or what the jury could look at in observing a recorded statement. And they used the word videotapes, and I took that out, and I think I said recording. Just, you can look at it, we don't have to discuss it tonight, but just so you know, I made that modification. Otherwise, I think, other than the other modification I made to 605, which we talked about previously, everything else are the standard wordings. So anything else we should discuss tonight?
Not from the state, Judge.
Will Ms. Weier be allowed to see her family this evening?
I'll order that till it's almost 4:15 to 5:30 at the juvenile center, and then
Thank you, sir.
she'd be transported back. All right. With that, it will be in recess. Thank you, everybody. Have a good evening. And remember that additional charge for the...
Yes, sir. I've already sent several
All right.
emails.
Thank you.
All right, so that ends day 2. So we're going to go on to day 3, which is from September 14th. But I wanted to read this. We were talking about, has this happened before? I've never heard of it. And you heard the doctor there. She said she'd never heard of it. Of course, that was back in 2017. But this is from this place just called Horror? Vocal.media Horror, the real life crimes. All right, so this was written about a year ago. Creepypasta, the internet's version of urban legends, is typically seen as a source of entertainment. These chilling tales, ranging from haunted games to malevolent entities, captivate readers with their eerie storytelling and imaginative premises. However, the genre's growing popularity has also led to darker consequences. In some cases, individuals have cited creepypasta as an inspiration for real-life crimes. These incidences have sparked debates. Here, you know what? Excuse me, I think I can, let me just read this to you guys, or let me show this. I can show this instead of just reading it. I can read it and show it to you at the same time. How about that? Okay. Yeah, because there's pictures. All right, here, check this out. All right, we'll read this. We'll read along with me. Okay. Here are some of the more infamous cases where creepypasta stories blend into real-world crimes and the lasting impact they had on society. All right, so the Slender Man stabbings. So we all know about the Slender Man stabbings, created in 2009 on the forum Something Awful. Slender Man's a tall, faceless figure. Okay, then they talk about the crime, 2014. Two 12-year-old girls in Waukesha, Wisconsin, lured their friends into the woods, stabbed her 19 times. All right, so we know all about that. Okay, then here's the case of Laughing Jack. So Laughing Jack is a sadistic, clown-like figure from creepypasta lore who preys on children. Sounds like Pennywise. He befriends them, gains their trust, and ultimately tortures and deletes them in gruesome ways. The character is a nightmare-inducing blend of malevolence and manipulation, making him a popular figure in horror communities. Right? That sounds like Pennywise. Now, however, in the crime in 2015, a mother in Indiana claimed that her 12-year-old daughter, again 12 years old, stabbed her younger brother while under the influence of Laughing Jack. The young girl allegedly told authorities that Laughing Jack instructed her to commit the act. The aftermath. This case further fueled concerns about the potential psychological effects of creepypasta stories on impressionable children. Critics questioned whether parents and educators were sufficiently monitoring children's online activities, while others argued that such stories could amplify underlying psychological issues. Then you have Jeff the Killer. All right, so we've heard about Jeff the Killer. So Jeff the Killer is a disfigured homicidal character from creepypasta lore who whispers the phrase "go to sleep" before attacking his victims. Okay, so this is where they were saying close your eyes, go to sleep, right? This is what Morgan and Anissa were saying. His gruesome origin story and disturbing grin have made him a staple of internet horror, though critics often decry the story for its graphic and violent themes. And now here's a crime. While no single incident rivals the infamy of the Slender Man case, there have been numerous reports of individuals citing Jeff the Killer as an influence for violent acts. In one case, a teenager in the UK was reported to have attacked a peer after becoming obsessed with Jeff the Killer and fan art. So the aftermath, though not as widely publicized as other cases, incidents like this illustrate the potential for fictional characters to inspire real-world aggression, especially in vulnerable individuals. All right. Let's see. Impact on society and media. So the role of mental health. One recurring theme in these cases is the vulnerability of the individuals involved. Many of the perpetrators were young, struggled with unrelated mental health issues, making them susceptible to suggestion and fantasy. Now, see, when I was growing up, I was into D&D and fantasy. I've told you guys that before, sword and sorcery and all that stuff. And there was a kid, I think, in Dallas where he was a D&D player, and I think he killed somebody. I forget. Let's see. Crazy Mary Jo, you were worried about your son's focus on Dungeons and Dragons 60 years ago, right? Yeah, so this was like late 70s, early 80s, right? That's when I got into it heavily. But I was always into like Alfred Hitchcock, and I always loved cemeteries and ghosts and goblins and all that stuff. So I just always liked that. And then that evolved into elves and dwarves and, wizards and all that stuff. And I think there was this kid in Dallas, right? Let me look this up. Dallas, Texas, D&D murder maybe, or was it killing? All right. Okay, here's 1996. No, this is well before. So there is a 1996 6-year-old attempted to take out his brother, where the mother was convicted despite claims of an intruder and connections to D&D in her defense. No, there was something else. Or maybe he self-deleted. Could have self-deleted. All right. Apparently there was a prodigy from MSU, 1979, 16-year-old prodigy disappeared from MSU, I remember this, entered steam tunnels in a self-deletion attempt and later died in 1980. His case became a symbol for anti-D&D activists despite evidence of his mental health issues and drug use. So Mazes and Monsters, that's what it came out of that, Mazes and Monsters. So October 15th, 1979, James Dallas Egbert. Okay, I do. Oh, yeah, there you go, Toby. Yeah. Yep. Yeah, that's what I'm reading right now. You know about the kid who disappeared and they blamed it? I thought it was in Texas, though. Okay, maybe that's okay. And that makes sense, though. 1979, yeah. I thought it was something, for some reason I thought it was in Texas. But anyway, so that's it. And that satanic panic, yeah, I didn't realize that's what it was called, but yeah, it's all about 12,000 unsubstantial cases of satanic ritual abuse starting in North America in the 80s. I don't remember that, but I mean, now it's like, yeah, it's like talks about kind of like what they're saying about certain political groups and certain Hollywood celebrities and all that stuff. I mean, we can really go down a rabbit hole, but I don't want to do that on this stream. But that's what that seems to. So, well, Rosemary's Baby in '68, Exorcist in '73, and then The Omen in '76. I mean, those were three huge movies that had to deal with all of that. Interesting. All right, let's get back to here. All right, do we need to look at this anymore? I don't think so. All right, we don't need to look at that anymore. Let's go back to here. All right, let's see. Your cousins who are like 20 years older than me grew up on D&D, much to my aunt and uncle's disdain and dismay. Well, guess what they play now with their friends and for the community when golf is rained out. Yeah, I haven't played it in a long time, since I was probably 17 or 18. No, is that true? Have I played it since then? Yeah, I honestly, I don't think I've played it. Jenny, oh, we should get a game going. We should get a campaign going. That'd be a lot of fun. You also played Magic the Gathering. They took role play. Absolutely. Yeah, that's what it was all about. All right. Oh, Aaron sent a photo of Jeff the Killer. Oh my God, he is scary. You know who he looks like? Like, thank you, Aaron. Thank you. Appreciate that. That is all right. Don't take this the wrong way, but I'm going to show this picture and then you guys, oops, nope, not that one. You guys tell me who this reminds you of. I'm sorry. Well, you guys tell me who this reminds you of. All right. you guys, who does that remind you of? All right. Who does that remind you of? Just real quick. I'll leave that there for. Tell me who does that remind you of? Sorry, I've got to do this. I've got to do this. Who does that remind you of, you guys? No idea. All right, I'm gonna put up this. I'm sorry, but this is just it's just where my mind went. All right, this is where my mind went. Right? Could be the Joker, but that's where my mind went. Yeah. P. Cooper, you got it. Maryland, right? That's where I go. That's where I go. Freddy Krueger. Joanne, your ex. Juice thing. I don't know juice thing. What's juice thing? Shirley, is that something? I don't know. I'm not familiar with juice thing. Yeah, that's what I think. Yeah. I think of it Marilyn Manson, but so Jeff the Killer. Oh yeah, that guy that guy from Music. Yeah. Yeah, Marilyn. Mr. Ed. That's Marilyn Manson. He's a performer, singer. So Brian Werner is his name, but goes by Marilyn Manson. Beetlejuice, yeah, little Beetlejuice. Musicians say musicians, yes. You're right. Grampy, Michael Jackson. You never knew who Marilyn was? Yeah, he was big in the 90s. I guess he still is pretty big, but yeah, he was really came up in the 90s and then 2000s. And we all know he partied with Johnny Depp. So he's born in 1969, Brian Werner. He's from Fort Lauderdale, right? He's actually was born in Canton, Ohio, but he grew up in Fort Lauderdale area. When did he really, so 94, 96, 98, 2000, he came out in 94. So he's still going. He's got 2004, he put out another album. So 94 to 2004. So anyway, all right. Yeah, Maryland, he was born in Canton, of all places. You still think Joyce Elmo mixed with it? All right, they named a juice after it? I don't know about that. I'm not familiar with that. All right, let's enough of Marilyn Manson and Jeff the Killer. All right, let's get to day 3. So you heard them talk about jury instructions and all that good stuff. So we may be getting close to a verdict. All right, this is from September 14th. So this is day 3. This trial was only 3 days, you guys. So it was a quick trial. And remember, the defense has the burden of proof. So that's why the defense...
All right, thank you.
Sorry, that's why the defense went first, and which was confusing to a lot of us, including myself. I'm like, why is the defense going? Because they had the burden of proof. All right, let me just pin. This is day 3. Let me just put this up here for you guys. Okay, pin that. And we'll get started with day 3. Okay, here we go.
All right, thank you. Please be seated. And good morning to the jury. We're prepared to proceed with the state versus Anissa Weier, same appearances as previously noted. Jury's in the jury box. We're prepared to proceed. Then, Attorney McMahon, you have an additional witness to call?
I do, Your Honor. We'll be calling Mr. Teggy, formerly known as Mr. Allen.
All right. Good morning. Morning. Stay standing, raise your right hand. Clerk will swear you in.
You swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do. All right, be seated. Microphone is the bar with the red light on it. Pull up to that. Then state your full name and spell your last name.
Sure. Jeffrey Taege, Taege.
All right, very good. Thank you.
And were you previously known as Jeffrey Allen?
Yes.
And about 3 years ago, were you a teacher at Horning Middle School?
I was, yes.
And what part of Horning Middle School did you teach?
I worked in the flight academy.
And in Flight Academy, did you have a student by the name of Anissa Weier?
I did.
And do you see Miss Weier sitting over at the table?
I do.
And how was Ani as a student?
She was what I would describe as a typical middle school student. She was very happy, excitable. She loved the program that she was in. She did really well with all of her academics. She knew how to ask for help. She was a great student.
Okay. And when you say she knew how to ask for help, what sort of help would she ask for?
Sure. I was primarily her math and science teacher, and so if she ever had questions about, typically, from what I remember, it was usually math. If she had questions, she wouldn't hesitate to approach me, or she would email me, and we'd have correspondence back and forth and help her work through those.
Okay. And when she would email you, do you remember if it was just during school hours, or was it after hours?
A combination of both, I believe.
So if she was, for example, working on schoolwork after hours and she had a question, she would reach out.
Yep.
And she felt comfortable doing that.
Yes.
And again, your recollection was she sought help for math and science.
Yes.
Now, what do you remember her, how do you remember her as in relation to her other classmates?
She was, I mean, she was happy, but she was a little quirky. She was always really excited about everything that we were doing and wanted to be involved. Yeah, I guess I would describe her like that.
Okay. And by really excited, you mean high energy or what?
Yes. Whenever we would introduce something new or we'd talk about a new experience that we were going to have, she would get really excited about it and want to be a part of that.
Okay. And within Flight Academy, there were children of various grades, correct?
Correct.
And at times in the beginning of the school year, with the newer students, assignments would be created where they worked with another student, correct?
Correct.
Do you remember Ani working with a student with the initials of KN?
Yes.
And after they initially worked together, did they continue to work together?
I can't remember exactly, but I would assume so. They were really good friends.
Okay. And were you aware that they talked about Slender Man or creepypasta?
No.
They didn't share that with you?
No.
None of your students did?
No.
And when you thought about Anissa, did you think of her as at the same maturity level as her classmates, or higher or lower?
In terms of maturity level, I think maybe a little bit lower in terms of interacting with her peers, but with interacting with adults, I would maybe describe her as being higher.
Okay. So she related better to adults?
I would say so, yes.
Okay. And with her peers, you thought she seemed a little less mature?
Yes.
And can you tell me why?
Again, 3 years ago, but I just remember vaguely there would be instances when maybe Anissa would make a joke that she would think was a lot funnier than some of her peers. Her peers might find it funny, but not to the extent that she would. Or I think just the level of excitement that she displayed was more than her peers at that time.
More like a younger child than a middle schooler.
Yeah, I mean, all sixth graders come in at varying levels, but yes.
Okay. Was her appearance ever different than her classmates?
Not that I can remember, no.
Would anything refresh your recollection? Did you speak to anyone about Anissa 3 years ago?
Detective, yes.
Would looking at his report help you?
Yes, probably. Yes.
And did that refresh your recollection?
It did.
What did you recall?
When I talked to Detective Casey, I had mentioned that she wore clothes that were different and more childlike. And again, vaguely remembering from 3 years ago, I feel like I remember that there were times when her clothes didn't necessarily seem to fit. They were maybe a little bit small, or the characters that were on them were more atypical for a middle school student.
Okay. So like something you might see in grade school, but not in middle school.
Yes.
And Anissa had to deal with the rules of your classroom, correct?
Correct.
And was she a rule follower?
Yes.
And did she expect others to do so?
Yes.
What happened when they didn't?
Initially, I remember her calling them out to either myself or Mrs. Crowder. And then she would, for example, if someone was breaking a rule in another area of the program, because we're all spread out in different rooms, she would send an email, for example, that someone was talking in the lounge when they weren't supposed to be.
Okay. So when I was a kid, we would have called that a tattletale.
Someone would use that term, yes.
Okay. And did the other children appreciate that?
I don't know that they ever necessarily knew that it was directly her. There were lots of children who would report when others were not following the rules, and we would never single someone out who had reported to us.
Okay. Did she ever attempt to redirect children by herself?
I can't remember. I can't recall.
You recall her yelling at one child to shut up?
That does sound like something she would have done, yes, initially, early on in the year.
When things like that happen, you had to redirect her, correct?
Correct.
And when you would redirect Anissa, how did she react?
Redirection, I would say, was a little bit more difficult for her than some of her peers. It seemed like it took her a little bit longer to process the redirect.
And how do you mean by process the redirect?
She would kind of go blank just for a second or two, in my opinion, while she was thinking about what she was being asked to redirect. I would interpret it as her wanting to understand the why and not just the what of the redirect.
Okay. And was that a typical reaction of your students?
Not usually, no.
You have fond memories of Anissa?
Yes.
She was a good student?
Yes.
And you used her as an ambassador for your program, correct?
Yes.
She was excited about it.
Yes.
When she knew things about something, she wanted to tell people.
Yes.
Thank you.
All right, thank you. Cross-examination.
Sir, you told Detective Casey you believed her to be smart, right?
Yes.
Nothing else.
All right. Any further direct?
No other questions. Thank you so much, sir.
All right, thank you, sir. You can step down. Is Mr. Tagey under subpoena?
He is, and we will release him.
All right, very good. Thank you. Any objections?
No.
All right, thank you. Have a good day, sir.
Thank you.
Then further witnesses?
Yes, Judge, Dr. Gregory Van Rybrook.
All right.
Next witness.
You could bring him in.
And if the court's okay with this, I'll get his CV and his report and put it next.
That's fine. Good morning.
Morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Thank you.
Thank you.
Be seated. Pull up to the microphone.
Okay.
That's the bar with the red light.
Sure.
Then state your full name and spell your last name.
Gregory Van Rybrook, capital V-A-N, capital R-Y-B-R-O-E-K.
All right. Thank you.
You're welcome.
Dr. Van Rybrook, I'm going to give you two exhibits, Exhibit Y and Z. And I want you to look at Exhibit Y first. Do you recognize that Exhibit Y?
Yes.
And what is Exhibit Y?
This is my curriculum vitae, sometimes called a resume.
And did you prepare it?
Yes.
Is it an accurate document in terms of up-to-date regarding your training, experience, background, professional information?
Yes.
Let's start by talking about your educational background. Can you describe it?
Sure. I have an undergraduate degree in psychology. I have a master's degree in counseling. I have a doctorate degree, a PhD in psychology, and I have a law degree.
Okay. And I want to talk to you about the law degree. You primarily practice in what area?
Psychology.
But you also have a law degree. What is the significance, or why did you decide to obtain a law degree?
Well, it turns out that along the way, I decided that I didn't want to do strictly private practice, clinical kind of work, and I secretly knew that, but couldn't admit it for a while. And then I was the kind of person who came into a courtroom just like this one, and while it's unpleasant in lots of ways, it also is interesting in other ways. And so I decided I was interested in the field of psychology, psychiatry, and the law, sometimes called forensics. And so I went back to law school with the purpose of understanding better how these issues come together, mental health issues and legal issues.
Okay. And does that training in law school and as a lawyer assist you when you're called in to do forensic evaluations?
Yes.
Okay. And have you had internships that you were involved in the past?
Yes, I have.
And could you describe those?
Well, so graduate school takes a long time, and the expectation when you go to graduate school is that you do many different experiences, internship-wise or practicum-wise. So I've done work inside regular hospitals. I've worked at the university counseling service for college students or graduate students, and I spent many years at Mendota, which we'll get to, Mental Health Institute, as a student working with children, adolescents, adults, geriatric adults, and so forth.
Can you go a little bit further and explain the details of some of the internships you worked in that involved primarily children?
So so I've been at Mendota Mental Health Institute for a long time, and I say that now to tell you that the first 3 years or so were for free because they don't pay students there. And my early years there as a student was working on children's units and adolescent units as part of academic training.
Okay, and let me ask you this. Could you, you said Mendota, and I wanted to see if you could describe what Mendota is.
Sure. So the state of Wisconsin has 2 state psychiatric facilities. These are secure psychiatric hospitals, and one is in Oshkosh, Winnebago Mental Health Institute, and the other one, the oldest one, is in Madison, Mendota Mental Health Institute. It's been around since 1860, and the purpose of the mental health institutes are to be sometimes called the safety net for people who have mental health troubles one way or another. There's lots of legal issues attached to that, but that is the purpose, and Mendota from 1860 until today has served in that capacity.
And when you say secure, what you mean is it's locked?
Yes.
And what other training have you received in the past related to your profession?
Oh, my. Do you mean in school training or others?
Any additional type of training that you haven't described already?
So what happens is you go to school for a long time, undergraduate in psychology, and then of course in graduate school, which takes another many more years, and then there's ongoing training throughout the rest of one's career. So psychologists, like lawyers, like other doctors, have to get continuing education credit. So I've received those credits and participate in those kinds of trainings, and I've actually done those kind of trainings for other people as well.
And since you work primarily with children, right?
I actually work with children, adolescents, and adults.
Okay. And you work with children, so is it important that you understand adolescent brain development?
Yes.
And did you yourself educate yourself on adolescent brain development?
Yes.
And can you describe that? What adolescent brain development, what the new science has learned about adolescent brain development?
Well, we like to believe that the brain is all set at a very early point, but the new science shows that the brain actually is developing greatly in the earliest years, from 0 to 3. There's a lot of development going on, and then in the adolescent years, the main development is going on, where the brain is busy trying to develop in the frontal lobe, the front portion, in the areas of judgment, decision-making, patience, kindness, and those sorts of things that are all more higher level and more abstract. And the new science is showing that the brain of young people versus the brain of a mature adult, stopping at around the middle 20s or so, is different and not ready to go prime time. Prime time meaning an adult, fully responsible brain. So I can say, having been a young person and not being one now, that makes a lot of sense to me. And I can say, having been around young people, including my own children and many others, that makes even more sense to me just by looking at the behavior and then remembering my own.
And let me finish up with your CV. I apologize. I'll go back to that. Right now, are you licensed to work in any areas in Wisconsin?
I'm licensed as a psychologist. I'm also licensed as an attorney, but I don't practice law.
And let me ask you this. Do you have any teaching positions?
Yes. What I do at Mendota now is I'm the director of Mendota. I've been at Mendota about 37 years, and for the last 17 years I've been the director. I can explain that if that's necessary. But I also teach at the University of Wisconsin in Madison, and I have been doing that for about 25 years. My classes are always about something having to do with psychology and law, social science and the law, forensic psychology, mental health law, that sort of thing. And I teach undergraduates right now I'm teaching a course called Psychology, Law, and Social Policy, and I also teach in the law school for law school is usually 3 years if you go full-time. Third-year law students have elective courses where they can select, and I teach a course there called Mental Health Law for lawyers that are interested in how mental health and the law work.
And I believe you said you're currently employed at Mendota.
Yes.
And I want to go over again with you. What's your position there?
So currently my position is the director, and my career over the 30-plus years has roughly been split with about 10, 12 years with patient care, so much more me and the patient directly on units. The second half was more middle management, which means being the supervisor of a particular unit with other people who do the same thing, and also doing that kind of work with patients. And then the last third or so has been more administrative or clinical administrative, which has to do with the operations of the whole hospital.
And have you yourself published any works?
Yes.
And have you yourself done any presentations?
Yes.
Okay. Judge, at this point I'm asking the court to allow me to move in Exhibit Y.
Any objection?
No.
Okay, proceed.
Dr. Van Rybrook, have you ever testified as an expert in court before?
Yes, I have.
And have you ever testified as an expert in court on the issue of not guilty by reason of mental disease or defect?
Yes, I have.
Okay. And your experience, have you ever been found to be not qualified to testify as an expert on the issue of not guilty by reason of mental disease or defect?
No.
And throughout the years that you've been practicing and you've been requested to do evaluations for purposes of not guilty by reason of mental disease or defect, Have you been hired by the state to do them?
Yes.
And have you also been hired by the defense to do reports?
Yes.
And when you've done those reports in the past, have you always come to a conclusion that either the state, when they hired you, had hoped that you would come to?
No, I regularly say the wrong things to people.
Okay. And same question about from the defense perspective. Have you always reached the conclusion that the defense has been hoping that you would reach?
I seem to say the wrong things to the defense as well.
In this case, though, you were not hired by the prosecution, you were not hired by the defense. How did you get involved in this case?
I'm not really sure. I was hired by the court, but I don't know exactly how that happened, to be honest with you.
Judge, I'm going to ask permission to offer Dr. Van Rybrook as an expert in assessing whether or not a person meets the standard for not guilty by reason of disease or defect.
I'll permit the testimony to go forward.
Okay. Doctor, I want to go back to your occupations a bit, because you work at University of Wisconsin-Madison as a professor, isn't that correct?
Yes.
And I know that one of the other witnesses, Dr. Michael Caldwell, he works at the same place.
Yes.
Okay. In your field, does it, I mean, I'm assuming that when you work in the field of psychology, you meet other psychologists.
Yes.
Okay. When you work in the field of psychology, it's common that you can actually work in the same area or same employer as other psychologists.
Yes.
Okay. When you were ordered by the court to do your evaluation, did you consult with Dr. Michael Caldwell about what you were requested by the court to do?
No, I did not.
Were you provided a copy of Dr. Michael Caldwell's report before you formed your opinions and submitted your report to the court?
No.
Okay. And when you submitted your report, did you send it to me?
I did not. I sent it to the court.
Okay. And when you completed your report, I contacted you because I wanted to talk to you about what your report said. What did you do?
I guess I didn't answer you. I wrote to the court and said, what do you want me to do here?
Okay, so you wrote to the court and asked for permission to even talk to me after you completed your report?
Yes.
You work with Dr. Caldwell. You guys have even published things together, and you've done presentations together, right?
Yes, we have.
Okay. At any time while you were preparing your report, drawing your conclusions, did you talk to him about what you were thinking about the case?
No.
Okay. Dr. Melissa Westendorf, she also evaluated Anissa. Prior to sending your report to the court, prior to reaching your conclusions, did you talk to Dr. Westendorf?
No.
Prior to submitting your report to the court, did you get a copy of Dr. Westendorf's report?
I did not.
After you submitted your report to the court, you did receive a copy of Dr. Westendorf and Dr. Caldwell's reports.
Yes, I did.
And do either of those reports cause you to change any opinions or conclusions you reached in your report?
No, they did not.
Okay, so let's talk about your contact with Anissa. And I want to have you look at Exhibit Z. And can you identify Exhibit Z?
Yes, this is the report that I wrote after evaluating Anissa and looking at the documentation around the case that brought me to evaluating her.
I want to go to page 2 of your report. On page 2, it talks about things that you did. It's titled Database. When did you meet with Anissa?
I saw her, I have to look at this, in September of 2016, September 29th, or
Okay.
September 29th, yes.
And I noticed that on page 9 there was a reference to seeing her on October 29th, but October 29th of 2016. But if it says that, that was a typing error.
Yes, I'm sorry that I somehow have the wrong date there.
Okay. And when you met with her, how long did you meet with her?
About 4.5 hours.
And you met with her, did you tell her why you were meeting with her?
I did.
And did you think she appeared to understand what you were talking about?
She did seem to understand why I was there and understood the purpose of the meeting.
Did she appear to have any concerns about like orientation to place, person, time when you were meeting with her?
No, she was well aware of what year it was and those sorts of things, what was going on in the world, what was going on in her experiences there at the county detention center.
Okay, did she appear to have any concerns about being preoccupied with internal stimuli?
No.
Okay. Was she able to provide you with any information about her social history?
Yes.
Okay, and did she appear to be cooperative during your contacts with her?
Yes, she was.
You know, you first met with her, you said, September 29, 2016, so that was over 2 years after the offense was committed.
Yes.
Did that present any issues for you?
It's a challenge that's a little bit hard in NGI insanity cases because the requirement there in the law is to try to understand the person's mind or their mental state at the time of the alleged crime. So it's a challenge for anybody involved in this kind of an evaluation because it's always later, of course, and what we're trying to do is go backwards in time, which is difficult. So I have to say that this is a standard challenge in this work.
Okay, but you did try to compensate for that, didn't you?
Yeah, the best that I know to be done, of course, is to interview the person for their memory and so forth, but then there's a lot of information that is collected in police reports and statements and interrogation tapes and that sort of stuff. That's all closer to the time.
So, okay, and is that information that, like, it's normal for psychologists to seek and review when doing an evaluation for purposes of not guilty by reason of mental disease and defect?
Yes, absolutely normal to do that.
Okay. And in your report, page 2, under the database area, so those are things that you all reviewed, it lists some reports by Dr. Jurek, Dr. Rosky, Dr. Caldwell, Dr. Kavanaugh. Those were other reports that were done, but they were not related to the not guilty by reason of mental disease or defect issue, correct?
Yes, that's correct.
And you reviewed those for purposes of trying to get a sense of probably what she told other professionals early on when she met with them. Is that correct?
Yes.
You also, did you review her statement to the Detective Trusani?
I don't remember the name of the detective, but is this the person who did the interrogation?
Yes.
Yes.
Okay, and you reviewed it in its entirety?
Yes.
And it's the video recorded interrogation that lasts 3 hours, correct?
Yes. Yes.
And did you also review the video recorded interrogation of Morgan?
I did.
And did you also review the interview that was done of the victim, Payton?
Yes.
And that was in police reports, right? The detective summarized it?
Yes, as well.
Okay. You, I just want to ask you this. Based on your knowledge that you've gained working as a psychologist. Well, let me strike that question. There was something I wanted to clarify from some testimony that was presented yesterday. What does the DSM, what is the DSM?
The DSM stands for Diagnostic and Statistical Manual. It's the best way to say it is it's a guidebook for professional people who are trying to figure out what might be wrong with somebody, so the diagnosis. And the reason to say guidebook is that many professional people, psychiatrists, psychologists, researchers with that sort of background, come together to agree on ultimately what each diagnosis means and what the criteria are for that diagnosis. So it is the manual that helps professional people who are trying to understand mental health troubles that they go to, so that there's a consistent view of what it is or what it is not. So it says in order to be X, you have to have number 1, number 2, number 3, or you have to have 4 of 6 or whatever, and the professional should go and look at those criteria and compare it to the case in front of them.
Okay.
To help reach a diagnosis. Does that help?
It does. And so what you're trying to prevent is someone, a doctor, coming up with a diagnosis out of like thin air.
Yeah, exactly. It's trying to be reasonably consistent about mental health, which is very sort of soft and squishy at times. It's hard for people to agree on what is wrong, if anything is wrong, and those things we know from life. So this is trying to get a playing field that everybody agrees, at least let's look at this and talk about this against whatever the issue is with the person.
Okay. After you met with Anissa and you reviewed the collateral information that's listed on page 2 of your report, did you conclude that she met a diagnosis for mental disease or disorder?
I did.
And what diagnosis did you indicate that she has?
So, need to... So as you might imagine in my work, what a forensic person is often is skeptical. I don't believe people a lot, and I have to spend a lot of time trying to figure that out. And in the end, I get to have an opinion in the court of law, and I get that it's an opinion. So I say that as the groundwork here because I often start with, I don't know if anything's wrong with a person, and I wouldn't want somebody to decide something's wrong with me just because I'm in the office. So I just start that way. And then because of my experience, I guess, and legal training, I start to look for evidence of what might be wrong. And in this case, without needing to, unless you want me to go through this more carefully, with that as the background, I thought that Anissa, at the time, not in front of me right then so much, although there were still elements there, but at the time she had a delusional disorder. So a delusion is a fixed belief. If I say I'm the King of Spain and you brought me the King of Spain and told me this is the real King of Spain, I would not believe you because I have a delusion. In my mind, I believe I'm the King of Spain and you have brought me the false King of Spain, or you're part of the conspiracy to show me how wrong I am and you're against me now too. So it's a fixed belief that is a false belief. And in Anissa's case, I thought she had a fixed and false belief that she shared with her friend Morgan. So we call that a shared delusion. And that at the moment of this terrible, tragic event, that she was confused and convinced that something real was going on with this very strange character called Slender Man, who she had been dunked in with her friend Morgan for several months repeatedly. And they had gone on something that one could call just an adventure in one way, if you don't want to think of it as a mental illness, or she moved from fantasy to more than fantasy to a delusion, so on a line. So something like that, I believe, is what happened in her case. It wasn't immediate. It was gradual, more like a glacier than it was a big bang, a thunderstorm, or a lightning bolt. It was something that gradually got into her head along with her friend, and they became together confused about what was going on there, and they morphed or changed or moved into the world of mental health for the most important moment here, and the moment here is the terrible event in and of itself. And I came to that conclusion after reading all this paper and watching her on video, which was much closer to the time, as you know, or will know if you haven't seen the video, and then in meeting with her and talking to her about the whole thing. And I have to say that when I met with her, so this is some 2 years later, I still could feel sort of the leftovers of that, but the leftovers are more the confusion, not really sure, putting it more into a religious demon. This is Satan talking. It's not really Slender Man. It was the Slender Man was the image of somebody who was representing the devil, if you will. And I saw her last week, a week ago, today actually, and I still could feel that coming off her. And she said those words to me, because you can imagine if you go through something like this, from her point of view, you're trying to understand it yourself as well. Terrible as it is for everybody else, it's also terrible for the person. So my job in this case is to understand the person accused of the crime, who now is saying, I didn't know what I was doing at that time. And I still feel that in its own way I think it's 3.5 years later today.
And you did say that when you saw her in 2016, and you saw her like a week ago, she was trying to divorce herself a bit from that delusion. Is that something that's common or uncommon in this situation?
Yeah, so I wouldn't say divorce. I would say she does what we all do when something terrible happens. And if we're involved in doing something terrible in our lives, we reconstruct what it was about. We rationalize it, we explain it, we take a little bit off of our own responsibility, and we change it. And our memory changes and other information changes, and it's not exactly the same as it was then. In her case, she was caught in like a whirlpool of really dumb, really bad judgment, and just was drawn into that and lost touch with her ability to stop herself. So the law says the person in insanity, the person has to have a mental illness, a mental disease or defect, and they have to either not appreciate the difference between right and wrong, or not be able to control or conform their behavior to the law. And in her case, I think even at the time, she knew it was wrong. She knew the difference between right and wrong, but even so, she could not stop herself at the moment that mattered most, because she was convinced that this character, who was a fantasy in our minds today, was not a fantasy, but was real in her mind, and that he would kill her, and that he would kill her family and people that she loved in place of, in reaction to her not following through with this whole crazy thing about becoming a proxy for him to do whatever he wanted to do. That's what she believed. That's what I thought was true to her at that time, if that makes sense.
Okay. And I want to refer you to page 2 of your report. At the top of it, the third line from the top, you, in order to assist yourself with doing this evaluation, you consulted the statute and the jury instructions covering the not guilty by reason of mental disease and defect plea.
Yes, I did.
And at the top of page 2, you quoted that the jury instructions indicate that the impairment of mind that has to be there whether it's enduring or transitory, must substantially affect the mental or emotional processes of the defendant at the time of the alleged offense. And you're saying the law says, what was she like when this happened, not what she's like today?
Yes.
Okay.
So the law says at the time. That's really important for an evaluator to look at. At the time, I can't actually go into a human being's mind and become them, but I have to do my best to try to become them, in the sense of trying to understand the world the way they saw the world at the time. And the comments in the Wisconsin jury instruction say that I'm looking for whether there is an impairment of the mind, but the key words here is the impairment can be, it says, either transitory or enduring. Enduring is long-lasting, it's obvious, and it's a chronic, terrible condition. But transitory is, it can be just now, just in the moment. And the instructions say it can be one or the other. It can be that. So she was more in the transitory time, in the way that I tried my best to explain it. In that moment, it was temporary, and it was terrible, and it was a delusion that was very bad, that influenced her more than she could control. In other words, she couldn't conform her conduct to what we would expect her to conform her conduct to. As a result of this crazy connection with her friend and the fantasy of this character on the internet and everything that had to do with that.
Okay. And you also quoted some other language from the jury instruction. On page 1, towards the bottom of the last paragraph, it says that in Wisconsin, selected conditions or circumstances have been specifically excluded as not supporting the definition of mental disease or defect. Temporary passion prompted by revenge, hatred, repeated criminal or otherwise antisocial conduct, voluntarily induced temporary mental states brought on by intoxication by drugs or alcohol. And why was that significant and important for you?
Well, because I teach this so much, I know that the average American who doesn't do this work believes that 40 to 60%, depending on the surveys, 40 to 60% of people who commit crimes say, I was crazy at the time. So like I'm going to get me an attorney to help me get off, right? That's what we think. But I know from the research about it that actually only 1% of people who have committed a crime or been charged with a crime claim they were not guilty by reason of insanity at the time. And of those 1%, about a quarter, 25%, are successful. So even 3/4 of that 1% are by judge or jury not found, not found not guilty by reason of mental disease or defect. So 1/4 of 1%. So last year there were about 110,000 felony cases in this state, and there were about 400 cases where the person through the legal system said, I was not guilty because I was mentally ill at the time. And of those cases, only about 100 or so went all the way through and were successful. So very similar to the national statistic, 25-30%. So this language, I believe, is to help the court and the judge and jury understand that we are not talking about cases where people were super mad at their spouse or somebody else, or super drunk, or super whatever it is that isn't good. It's just not mental illness. It's just a terrible and unfortunate moment where something bad happens at the other end of it, where we don't want people to say, well, I didn't know what I was doing. Well, maybe you didn't, but you should have. That's different. And so this is the language to rule that out rather than to rule it in, because we'd all like to, at the time we do something terrible, have a way to get out of it, I guess, in our own mind.
Okay.
That's why it's there.
And did you consider these exclusions when you were assessing Anissa's situation?
I did, and I had to look at the one related to her case because it says a temporary passion prompted by revenge, hatred, repeated criminal or otherwise antisocial conduct, because the word temporary is in there. So was there a passion of some kind? And there was a strange sort of emotional connection there that she had with her friend Morgan, because they were friends. And she someplace here, somebody said she was desperate to have her as a friend. And so there was a peer relationship there that one had to consider, and I did consider that, and I do think that was part of this, but it doesn't account for it. It was part of this weird, they were yoked together, they were connected together in some kind of a shared way that was influential, and we know from research about the adolescent brain that peers influence each other tremendously. In other words, if she was on her own, she probably wouldn't have done this at all, but she wasn't on her own. She was with somebody else. That's the way it happened in this case. And the influence of a peer with another peer similar age is tremendously powerful in the adolescent brain that reacts to that kind of stimulation, way different than, say, a 35-year-old would, looking at the same material on the internet and having a friend to talk about it with.
So Doctor, let's talk about that. You, based on your knowledge that you've gained working as a psychologist primarily with children, does a child behave like an adult?
Sorry, I have to drink water. Sometimes they behave like an adult, and sometimes we sure wish, those of us who have kids or are around kids, we wish they would be like little adults, but lots of times they don't behave like an adult. And how do we just remember your own life and look at kids around you. They're not adults, they're kids. So sometimes we do a pretty good job of civilizing them, and lots of times we keep them within the boundaries, but we understand that they're kids, and so they don't behave in the same way as adults. Why? Because they're kids.
So is there a difference in how, from a cognitive standpoint, a child would differ from an adult, or a 12-year-old would differ from a 15-year-old?
Yes. So I'm not a neuroscientist. A neuroscientist is an actual brain specialist, so I want to say that to you, but I also know some about this, that our brain is basically a big reward system, and we react to rewards that we get. And our brain is developed from the back to the front over about 4 million years, the Homo sapien brain. And the front of the brain is what develops last. And the front of the brain is the area of the brain that has to do with judgment and decision making and making sense within whatever the rules of society are. And it takes till about the early 20s to the mid-20s to get all the way there. So that means the inner brain, the much older primitive brain, is interested in the rewards, and the rewards come in out of neurochemicals, lots of times dopamine. So dopamine is a little chemical, a neurotransmitter that squirts when the brain is excited, and the brain doesn't really have a value system, it just gets excited. So if you put a drug inside a brain, the brain's like, oh, I like that if it's a good drug. And if you put something exciting inside a brain that the brain is looking at in the world that is not a good idea, like driving a car fast, the brain likes that. And a juvenile, an adolescent, has more brain activity in things that are exciting when they are an adolescent. And there are studies that show like if you get rewards of sugar, we all like sugar because sugar candy tastes good and that stuff. The brain is more activated in an adolescent. And if you have a reward of money, because we all like money because you need money for stuff, the brain is more activated in an adolescent. The adult brain also activates, but the adolescent brain really activates. And if you put young people in front of a driving simulator to learn how to drive, they actually crash more. We know they crash more by statistics, right? They crash more when there are peers next to them because they're busy doing stupid stuff, because their brain is actually excited about all sorts of things and they're not paying attention. So these are good experiments to show us that the adolescent brain is busy developing but not ready to go. It's sort of trying to catch up to a body that may look quite adult in size, but it's not ready to go. It is really working on it. It is developing. So another way to say it is the brain of a young person has much more of an accelerator and not very good brakes. So it's like, whoa, and anybody who's honest about it knows they've been there, and maybe some people are, by the grace of God, I was like that. So we all know this, and the brake is what's developing, and it takes a long time for us to get there as an adult. And that's sort of the basic brain business that has to do with child and adolescent development.
Okay.
Now, the other question was, what about a 12-year-old versus a 15-year-old? The younger the brain, the less ability to stop oneself, to have a filtering system, an editing system, and so forth. So this is in general. Presumably the 12-year-old brain has less good breaking than the 15-year-old brain, but the 15-year-old's not so good either most of the time.
And that level of development of a 12-year-old at that point in their lives, does that affect their abilities in terms of impulse control, the ability to resist peer influence?
Yes, that's all that front part of the brain that has to do with judgment, and bad judgment is what's happening when things are going wrong there.
Okay. Is that something that you factored into your evaluation of Anissa?
I did.
Doctor, I want to show you a couple clips from Anissa's interview with the detective. And Judge, I'm going to show clip 10 from Exhibit F.
That's F1.
Oh, F1.
Well, I think F is the disc.
We have to kill Bella today. And I was like, but can't we say another night and do it tonight? Because I was still kind of scared and kind of hopeful.
Scared and kind of hopeful. What do you mean by that?
Like, I was scared because, A, I would never see my family again, and B, I was kind of hopeful to prove that I wasn't crazy, that I wasn't seeing things. Because even I saw Slender a few times. I think that was probably my mind playing tricks on me.
When was this before the party that you saw Slender? You've seen him before?
Twice. Once, well, they were both on a bus. We ride the same bus, just to and from school. So we were, talking on the bus. I look out the window and I see this, supposed thing standing like this, with tendrils, looks exactly like a tree. They're gone like that. And I told Morgan, and so I actually thought that he was real, because I saw him.
And so, Doctor, I just want to first ask you, is this the video that you reviewed of Anissa's interrogation by the detective?
Yes, it was.
Okay, and you watched that interrogation in its entirety, correct?
I did, yes.
And she says there that she saw Slender Man before the offense, right?
Yes.
And how did that factor into your opinion that she did have that belief, that delusional belief in Slender Man before this occurred?
So I can't actually tell where this particular clip was in the, I think it was about 3 hours or so.
Right.
But I have to tell you what remember I said, I don't believe a lot of this stuff. I actually have to work toward that. And what impressed me, if it wasn't this clip, it was somewhere early on that she started to talk about this crazy stuff about Slender Man. And so that impressed me, because if a person does a bad thing, they're going to reconstruct in some way where it's going to be less bad. If they can't get out of it, they're going to somehow explain it in a way that they're going to be a hero in their own story in some way. And she didn't do that. And it was really impressive to see early on she's scared. She's 12. She's scared. She's confused. She's got a detective sitting across from her now after all of this has stopped, and she's trying to explain, well, this is what happened, and of course the detective's like, me, who's Slender? What is that all about? That makes no sense in the world. So the detective's doing a nice job. What is that all about? And here's Anissa trying to explain this guy, and she says things like tendrils, and I think I saw him. I think she said out of the bus, or after she had these flash visions or something, or she wasn't sure, like that. So she's struggling with that, and that was impressive to me because it was so early. Why? Because the issue is at the time, and this is so much closer to the time than when I saw her 2 years later and read all that paperwork about her. So it mattered to me.
I want to ask you about, that design of the website. Did you get a chance to view the Creepypasta website?
I did, but it was some time later, and I added that into the report.
Okay. And did the design of the website that you saw, did that have an effect on your opinion about whether or not she suffered from that delusional belief in Slender Man at the time?
Yeah, it did.
And how?
Well, so this is just strange to say it again, but I really try to become the other person. So I tried to, in my very fumbling way, because I don't travel in these worlds in the internet, tried to imagine what that was, and I read the paragraph that was the intro at the time, and it was really creepy, but it was also, I think I said the word alluring. It's sort of, there's a part of me that was drawn in by it. Just like when we do this. We go to scary, creepy movies for the purpose of being scared. That's what we do, and I felt a little bit scared, to tell you the truth. And I could in my own mind, I'm not trying to be me, I'm trying to be her, but it's hard to be somebody else. In my own mind, I started to feel, imagining that I'm 12 and a half, ooh, there's something about this. And then what I did, because of what I read and in talking to her, is I pushed repeat a lot of times. This is what I meant when I said dunking, and they talked to each other, and they did all this a lot of times like that. And then I saw, because this tweaked me a little bit, this all became a big deal nationally, and they put a caveat, they put a little thing in there later saying, if this is okay, they being whoever does these things, there is a line between fiction and reality, and it's up to you to realize where the line is. We are a literature site, not a satanic cult. And I thought, that's interesting for me to read now, in retrospect, after all of this. And I said in my paragraph, it's difficult with the mental capacity of a 12-year-old to know the line, to realize the line between fiction and reality. I just think that's difficult. And if you're in that dunking, repetitious cycle, it gets even more so. And if you are in that with an other person who is of similar age and interest and promoting it in its own way, feeding off each other, it gets even more difficult to realize the difference between reality and fantasy as a 12-year-old.
Okay, thank you. And that warning that you just referenced, where was that warning? Where did it come from?
It was somewhere on that site.
And do you remember what came after that warning?
What I remember is there's a whole there are all sorts of links that go all sorts of places having to do with this topic of either Slender Man or characters of that ilk that Anissa and her friend were looking at.
And is that a warning that's now on the Creepypasta website?
I would not know about today, but it was then.
Okay, and that was a warning that you saw that was on there after the date of defense. I think you said that.
I believed it was, yes.
Okay. You met with Anissa again in September 26, I believe, 2016. And when you spoke with her, were there statements that she made to you, and I'll refer you to page 7, that and 8, that specifically caused you to believe that she still held on to some of the delusional belief systems that you talked about before? And that, let me correct myself, that would be on page 9 and page 10 of your report.
Okay.
Also page 11.
Is there something on those pages you want to direct me to, or?
Well, that's what I'll do. On page 11, the third full paragraph, and it says under query, could you have stopped yourself from doing all of this to Bella? She says, I could have stopped myself, but if I did, I would not have only risked being killed myself, but also my family being killed.
Correct.
And what did you take from that?
Well, so here so what's happening is the examiner's trying to understand the mental health issues there, if they are there, and looking for it, but a forensic person also knows about the law, so they're thinking about the appreciation, the ability to appreciate the difference between right and wrong, which is sometimes called the cognitive standard. So I was thinking, why don't I just ask her this? Why don't I just ask her, well, did you know the difference between right and wrong? And she said, I did, which just because she said that doesn't mean everything, but it means something. Some weight is given to that. And in the end, I said, well, I think she did, but she was, in her own mind, pinned. She was painted into a terrible corner where if she didn't continue with this terrible thing that happened, she would die or her family would die. So she was in a terrible dilemma, a mental dilemma.
And what about this next quote that you indicate? She says, when we were in the woods, I thought Morgan would kill me if I didn't do it because she would be part of Slender Man. Morgan would be a proxy and Anissa would not be, and Morgan would be sent back to kill Anissa.
Yes.
Did that have an effect on your opinion about whether she was suffering from a delusional belief in Slender Man at the time?
Yes, because the driver here in the delusional belief was that they needed to do something terrible, to kill somebody in order to become a proxy. And a proxy is some kind of a helper, some kind of a servant to the Slender Man. And that even if she did not go through with it, she says then to me, then if Morgan did, Anissa would be the first victim, because Slender Man would tell Morgan, go and get Anissa or her family. So that's what I meant about feeling the dilemma of what do I do. So she knew it was wrong, but did it anyway for fear that she would die or her family would die.
And so she made a reference to believing that she or her family would be killed if she didn't go along with it. Did you see a reference to that in any of the other collateral information that you read? For instance, any of the professionals, the doctor's reports that were completed and filed in prior years on the case?
I did. I think that was a fairly consistent statement or theme throughout many of the evaluations.
Okay, so when those other doctors saw her early on after this occurred, she was telling them that, first of all, she believed that she needed to become a proxy to join Slender Man, and we know Slender Man's not real, right?
Yes.
So that was the delusion. She was motivated by that.
Yes.
Correct?
Yes.
And she also indicated that she needed to do this to become a proxy and to save her family and herself from harm. She had reported that to other professionals shortly after this occurred as well, correct?
Yes.
I did not directly ask you this, but part of your evaluation and assessment is to not only determine if she has a mental disease or defect, but you have to determine whether or not that mental disease or defect had a substantial effect on her ability to appreciate the wrongfulness of her conduct or to conform her conduct to the law.
Yes.
And let's go over that again. What did you find, and what information led you to conclude the way you concluded?
So in terms of the conclusion, I thought that there was a mental illness here, a mental disease or defect, that mental disease or defect was a shared delusional disorder, that there was a connection between that disorder and the behavior having to do with her responsibility, which is the second part of insanity. I thought that she did know the difference between right and wrong, so she doesn't meet that prong in my opinion, but that she could not control her behavior, which in the law is called conformity, to the degree that we want her to in society, and she could did not do it because of the shared delusion. I also included as part of that, and a big part for me was her very young age, which is all about an immature brain development, which is all about bad judgment and poor insight and inability to stop or control impulses to the degree that we would like people to do.
And the opinions that you testified to today, do you hold those opinions to a reasonable degree of professional certainty?
I do.
Judge, I want to move in exhibits Y and Z into evidence.
All right, thank you. I think we've already moved into admission Y, so then Z would be the report. Any objection? All right, received.
Judge, I don't have any other questions.
All right, thank you. Cross-examination.
Doctor, I'm going to pick up right where you left off. You said a big part of this meeting was her age, right?
Yes, that was a big factor in it, yes.
And you understand that she's in the adult court system, correct?
Yes, I do.
And as a lawyer, you know that the law required she be charged as an adult with this homicide, correct?
Well, I know more than that, but I know that she's in the adult system, and that as an adult, she is an adult regardless of her age according to the law, yes.
Had you been called upon to offer an opinion, would you have given the opinion that she should have been reverse waived back to juvenile court?
I didn't evaluate her for that, so it's really not proper to speculate on something I wasn't asked to do.
Well, you know everything about the case, right?
Well, no, I don't know everything about anything. So I do recognize that the court has an ability to reverse waive, and I know that she was not reverse waived in her circumstance.
And you're not willing to offer for us your opinion on whether she should have been or shouldn't have been?
No, that's...
Based on what you know?
Judge, that's been asked and answered.
Sustained.
But at least in terms of your consideration for your opinion on not guilty by reason of mental disease or defect, for you, her age played a big part in that, correct?
Yes, it did.
I'm very confused based on your report and something Mr. Smith had indicated. You interviewed Anissa once?
Twice.
And those dates were September 29th and September 26th?
So in 2016, I messed up with one of the dates, and then a week ago, I think it was a week ago today.
Okay, let's go back to 2016. Mm-hmm. You have your report in front of you, right?
Yes.
Page 2 of your report indicates in the middle, clinical interview conducted on September 29th, 2016 for 4.5 hours in the Washington County Juvenile Detention Center. You see that?
Yes.
So you interviewed her on September 29th, right?
Yes.
And then on page 4 of your report, up at the top, the first full paragraph, it says Anissa was evaluated on September 26th, 2016 at the Waukesha, Washington County Detention Facility.
Yes, I would, and I can see below that too, the 26th. So I must have messed up on the dates, but I'd have to go back to my notes to make sure of what the dates are, but you're correct, they're not the same dates, so I understand your confusion.
And then later on in your report it said October 29th. We kind of covered that earlier, right?
Yes.
Okay. But it was just one date in 2016.
Yes, I'm sorry, yes.
And then you went and interviewed her again on September 7th of 2017, correct?
I don't have that, but yes, I believe it was the 7th.
Well, you sent a letter to the court dated September 11th, 2017, indicating that had occurred, right?
Yes.
And September 11th, 2017, that was the day the trial started, correct?
I don't know when the trial started.
Okay. And you testified that when you interviewed Anissa on September 7th, she made statements to you, right?
Yes.
And you authored no report or provided any of those statements to either the state or the defense, did you?
Right. I did send a letter saying that I saw her and that I held the same opinion.
But there's nothing in there that indicates anything she told you, correct?
Correct.
And you understand as a lawyer that statements of a defendant in a criminal case are discoverable by both sides, correct?
Correct.
And we don't know what she told you, do we?
I guess not.
You talked about Anissa was painted into this terrible corner. You remember that?
You mean today?
Right.
Yes.
And that was prior to the stabbing, correct?
Yes. Well, I would say the whole circumstance was a terrible corner of some kind, yes.
And that certainly played a part in your opinion, correct?
Yes, and trying to understand her state of mind at the time.
And you told us that really at the time is the key issue, correct?
Yes, it is.
And statements made more recent to the time of the event probably are entitled to some more weight. Would that be fair?
Yes, I generally think that the time before, the time itself, and the time after, close in time, like you're suggesting, have the most power or the most influence.
One of the things Anissa told you was, we've had some testimony about this earlier, that they had to walk 4,000 miles to get to the Nicolay Forest. Do you remember that?
Yes.
You reviewed the police reports, right?
Yes.
I'm going to show you, Doctor, what's marked as Exhibit 5. Do you recognize that as a map that Anissa had sent to Morgan?
I recognize it as a map. I can't say I remember that Anissa sent it to Morgan right at this moment.
So are you aware of the email in the police reports that Anissa sent to Morgan saying that she had found that map and they could use that to find their way to the Nicolay Forest?
I'm not specifically recalling that. I remember there was a lot of discussion through email and otherwise having to do with planning of some kind related to the Nicolay Forest and the whole story.
Well, and that map shows that it was only 206 miles, I believe, right?
Oh, yes. Mm-hmm.
I don't have any other questions. Thanks, Judge.
All right, thank you. Redirect.
Dr. Van Rybrook, I want to clear up some, what I think is some confusion. I know you are an attorney, right?
Yes, I am.
You don't represent the district attorney's office right now, do you?
I do not.
You don't represent Anissa, do you?
I do not.
Okay, you are working as in your capacity as a psychologist, isn't that correct?
Yes, that's correct.
Okay. You would turn over discovery if you were representing one of the two parties, right? As a part of a discovery requirements, if you were an attorney representing Anissa or the state, you would turn over things.
I suppose I would. I've never done that because I've never actually done that.
Okay. Your notes, if the attorney for the district attorney's office had contacted you and said, turn over your notes, would you have turned over your notes?
Yes, I would have.
If I had contacted you and said, Dr. Van Rybrook, turn over your notes, would you have turned over your notes?
Yes, I would have.
Okay. If the court had contacted you, since the court appointed you to do this evaluation, and said, turn over your notes to both parties, would you have turned over your notes?
Yes.
I think you probably would have, if either side had contacted you to say they wanted your notes, you probably would have consulted with the court first,
Probably,
right?
yes, I probably would have.
I don't have any other questions.
Thank you. Any further cross?
No.
All right, with that, Doctor, your time here is complete. Thank you.
Thank you.
You can step down.
All right.
Is Dr. Van Riebeck under subpoena?
Yes, he is, Judge.
He's released?
He'll be released.
Any objections?
No.
All right, subpoena's released. Would you like this? Yeah, I'll take these. Thank you. Very good. There we go. With that, I think this is an appropriate time to take a recess, so we'll be in recess for about 15 minutes. Do you have further witnesses this morning?
Yes, Dr. Caldwell is coming in, and I think he may be running late. When I talked to Dr. Van Riebeck earlier today, he said that traffic was very foggy coming from Madison into Waukesha, so he was delayed, and I'm thinking Dr. Caldwell might be delayed as well. What we'll do is try to contact him during the break and see where he is.
All right. Well, we'll be in recess for 15 minutes. Let's go to 10:30.
Judge, just for, I guess, further discussion for today, I'm assuming Dr. Caldwell is the defense's last witness. The state is not anticipating calling any witnesses. I would assume then the court's plan would be to finish this today.
Well, if we could, we'll have a jury instruction conference. I've passed out instructions to you, so I'm thinking we may be that may not be as long as it could be. But if we could, I would try today. If we finish, let's say we start about 10:30, Dr. Caldwell would finish his testimony possibly before noon, but certainly maybe after lunch. We'd take some time to get organized, and then there would be time to do arguments and have the jury start deliberating. Any comments from Ms. Weier's case?
That is certainly possible, Your Honor. I don't know how long the jury instructions would take to read and all of that, and if the court wanted to start with fresh minds in the morning for closings or not. I think it would depend on how long Dr. Caldwell took and how long the instruction conference was.
Well, it's something we can discuss. There's merit to doing it either way, and we can review that. All right, so yes, Mr. Smith.
There's one other issue. Exhibit E, I believe that's Anissa's interrogation. The court didn't want another copy of it provided, but the court wanted it to be referenced as the exhibit, I think, A3 from the 2016, 2017, 2015 preliminary hearing. Is that how the court wants that to be entered in this case today?
Well, what I wanted on Exhibit E, I understood Exhibit E was actually really the disc from the prior hearing.
Right.
And if that's the case, it's okay to call it Exhibit E here, but I think we ought to identify it then as an exhibit, whatever it was from that prior hearing.
Okay.
So there's a consistent knowing chain of custody, if you will, of where that exhibit's been, so we know what we're talking about, and that there should be no changes made in the disc from that early date to now.
Right. Okay.
So if you are you identifying Exhibit E then as the exhibit you noted?
Yes, it was the preliminary hearing held February 16, 2015 and February 17, 2015. It's Exhibit A3, and your clerk helped me with that yesterday. February 16, 2015 and February 17, 2015. It's Exhibit A3, and your clerk helped me with that yesterday, and I thank her for that.
All right. Any objections to that nomenclature being used from the state?
No.
All right, very good. So thank you for looking that up, and thank you to Ms. Jacks for assisting in that. With that, then we'll be in recess.
Judge, I'm going to move to the admission of number 5 that I showed.
Any objection?
Not at all.
Okay, received. All right, with that, we'll be in recess at least till 10:30. Good morning once again. We'll be back on the record and state versus Anissa Weier. The same appearances. Jury is not here. Jury is in the jury room. Let me ask Attorney Smith what the status of his witnesses.
Well, Judge, we thought that Detective Dr. Caldwell will be here this morning. We actually sent him an email asking him to be here this morning because we were moving along faster than we were anticipating. It looks like he did not receive the email, and so he's on his way, but my guess is he won't be here until after the noon hour. He's coming from Madison area.
All right. And there are, from the Ms. Weier's standpoint, there are no further witnesses.
That is correct, sir.
All right, all right.
And I
Well-
apologize profusely. I sent the email. Dr. Caldwell was very apologetic as well on the phone. He indicates sometimes they have some issues with the emails at Mendota, and that he expects that he will eventually receive it. But he is on his way. Fortunately, we had cell phone, so we were able to communicate. I should have followed up last night with a phone call as opposed to just relying upon the e-communication.
Well, we have sufficient time to be flexible, and court can address that. What that means, though, is on scheduling, I'm thinking that we'll use our time now to review the jury instructions and the verdict. Then come back at, say, 1:15. Now, he should be here by then?
He should, sir.
Well, let's be safe.
Yeah.
I mean, if you think 1:30 is a better time, I'll say 1:30.
Just to be safe with the fog, I don't know
All
whether
right,
it's lifted
1:30,
or not.
1:30.
I just remember
Then,
Jefferson when I lived there.
let's say it takes 2 hours, 3 hours, that could be 3:30, 4, depending upon how things go. I think our best approach is then to actually do the instructions and closing arguments and deliberations starting tomorrow at 8:30. Then everybody's fresh, and we'll proceed on that basis. Any comments from the state?
Yes, Judge, we're taking these jurors out of their lives for the entire week and put them up in a hotel. I would think him coming from Madison, there wouldn't be a reason why he couldn't be here by 12:30 or 12:45. We should start then. These jurors are sitting doing nothing until then, and if we did start then, I don't see a reason why it wouldn't be likely to proceed to closing arguments and get this case to that jury this evening so they can begin deliberations, so we don't take any more time out of their lives. That's the state's position, Judge.
All right, thank you. That's a valid position. If Dr. Caldwell was actually here and we knew what the timing was, it'd be my position would be a bit different. But at this point, I'm trying to maintain a consistent and somewhat calm atmosphere for the purposes of the trial. In doing that, I accept that mishaps occur with witnesses and timing. In this case, we'll take Dr. Caldwell's situation at face value. We'll address him this afternoon. I want to make the jury comfortable, and in one sense to send them, to have them stay perhaps an extra day or two they might not care for it. On the other hand, the key for the court, and I believe for the parties and the public, is that the trial be held in an efficient and expeditious manner, but at the same time in the most fair manner. And when I think about the nature of the arguments, the length of time that they could take, it may be better for the jury and for the attorneys to be fresh when they give the argument. Thus, although we've had this every day, we've had some, what one could call free time, that it hasn't been as well structured perhaps and packed in as it could be, but that is part of the realities of the court system and legal practice. I'll accept that. I'm satisfied that when I look at the big picture, looking at it from all standpoints, both jury comfort and the necessity to ensure that the trial goes forward in a fair and efficient manner, that it's best to have the jury fresh when they hear the arguments and the instructions. So I'm going to proceed with, we'll finish the testimony today, we'll do our jury instructions today. We'll start at 8:30 tomorrow morning with instructions and arguments, and then start the deliberations tomorrow. And then the deliberations will take however long they're going to take. With regard to today, without knowing for sure what Dr. Caldwell's plan is, I think we'll start at 1:15. That should be sufficient time, and if there's a mishap, we'll just address that. And then we'll go forward on that basis. I'm not going to bring the jury back in to tell them this. Ken, our jury, or our bailiff, will instruct them. They'll go to they've been switching courtrooms and jury rooms for purposes of lunch, and they'll move on to that, and then because it's a bigger jury room, and then they'll come back in time to start the testimony this afternoon. So they can be advised now as to that status. I didn't see Ken isn't in, but perhaps one of the bailiffs can advise Ken of that. And then let's do our jury instructions. I passed out the instructions to everybody yesterday, at least what I was proposing. Do we have the verdict? I don't see. Maybe it is here.
Yes.
So the state has had a copy of the instructions and has had the verdict as well?
Yes.
And the defense has as well?
Yes.
All right. So let's just go through the instructions. And then if anybody has something they want to change, we can discuss it as we go through it. Then if somebody has something we should add, we can talk about that after we've gone through each of the instructions. I'll just read the numbers. Instructions I have is instruction 100, instruction 103, 147, 148, 155, 157, 158. Now this is the one that I noted that I had made some changes to and tried to develop it so it was more about, it's an instruction after they see the recordings as opposed to one that's read to them before they saw them. Then 190, 195, 300, then 605. And again, in 605, I'd added, on what's numbered page 14, I added in the reasonable certainty definition. Then 640, 480, 160, and then my proposal is that I read the instructions before the closing arguments, and then I would stop at instruction 160. After closing arguments are complete, I then would read 460 and 515A. Then when they have, when we'd go to the verdict part, when I'd read that in the 605, my thought is to give each member of the jury a copy of the verdict, so they'd be able to see that as well. So that's what I'm proposing be the instructions. From the state standpoint, any objections to them or any additional instructions?
No, not at all.
All right, thank you. Then from Ms. Weier's position?
Judge, in this instruction, jury instruction 158, I believe you indicated yesterday that you changed videotapes to recordings. And I see that in the first line.
But not in the bottom.
Right.
Yes. I think we should change that to recordings. Yes, I'm sorry, that did not. Correct. So we'll change that to recordings as well. Thank you. Anything else?
And also, Judge, in instruction 605, page 15, the last sentence.
The institution.
Right, and that's what the state pointed out before, I believe.
That's a touchy 2 words. We can't seem to put them together. All right, we'll fix that for sure.
And then page 20, instruction 460, the second paragraph, first sentence, says you are to answer only question 1, and if appropriate, question 2. I know this is a small issue, but if the court's willing to move or remove only, and say you are to answer question 1, and if appropriate.
I can understand that. Any objections to taking out the word only?
I think it's better with the word only in there, Judge, just because it directs them that it's only question 1, and then if appropriate, question 2. I guess I just like the word only in there as it gives them more specific direction.
Perhaps if specific direction is the concern, we could say after answer question 1, only if you answer question 1 yes, then answer question 2.
Right.
I like it the way it's worded, Judge. I'd leave it up to the court.
Well, I actually prefer the wording Miss that Attorney McMahon had.
Thank you.
With the word only where it is now, and I can see the reading of that, it gives the impression that the only question to be answered is 1. If you read it further, it does say, and if appropriate, 2, but it emphasizes too much that only question 1 is to be answered. The question 1 should always be answered. The question 2 is only answered, of course, if question 1 is answered yes. So I think we'll make that change. What was your proposed language?
Question 1, only if you answer question 1 yes, should you continue to question 2? I don't know that that's exactly what I said, but...
Judge, would the court be willing to use the language in the verdict form 480, jury instruction 480? It says, if you answer yes to question 1, then answer question 2 of the verdict form. Use that same language? If you answer yes to question 1.
That makes sense. It's
Yes.
cleaner.
Yeah.
I'll use that language. That makes sense. If you answer yes to question 1, then answer question 2. All right, I'll make those changes. We'll make those changes and run it off. Anything else from Attorney Smith?
No.
All right. Then with those modifications, we'll use those instructions. Any questions on the verdict?
No.
No.
No?
All right. Well, then, as I indicated, my preference is to read the instructions first before the arguments. We'll again put them up on the PowerPoint so you see them on the screen as well as they hear it and well as see it. Any objections to that process?
No.
No, sir.
No.
All right. Then we have 4 alternates. We have to select 4 alternates. I wouldn't do that until we start the arguments. As I indicated during the voir dire, my general process is to we'll use 16 separately numbered cubes, put them in a bin, twist them around, pull out 4 numbers. Then I have the jury clerk will run a random listing of the jurors 1 through 16. And then the 4 numbers we pull will be attached to a name, and then those will become the alternates.
That would be done after closing arguments.
Right,
correct?
right,
Okay.
right. Do it after closings.
Right.
And then I haven't kept the alternates here at the courthouse. I released the alternates. Another approach is to keep the alternates. There's a process to bring jurors back in. It's a more complicated process, but I just want everyone to be aware of that. So any objections to that process?
The court basically would keep them on standby in case there was an issue with one of the 12 that remained?
Well, that's been done sometimes.
Right.
I frankly haven't done it
Okay.
in the past, but I know that that's been done in some situations. And I thought since it's been done, I'll just lay it out here. We have time to talk it through. My thought is that it's too complicated to bring in a juror, alternate juror, after the 12 have started to deliberate.
Yeah.
And there's been, our Supreme Court has approved that type of situation, but it's more complicated. And there's always questions about that. So let me put it this way, if no one has strong feelings on it or objects, I'll release the alternate jurors after they're picked. Any objections?
Obviously, the concern, Judge, is if something happens to one of the 12, we have to bring in number 13, I guess, and they've been sequestered all week, but then let go for a period of time.
Well, I don't think we'd be able to bring them back once they're released. If I release them, they'd be gone.
So the alternative
12.
then, if something happened with the 12, is we have 11 decide the case?
Well, it's that would have to be up to the parties. If there's no agreement, then it's a mistrial.
I guess we would be in favor of perhaps, unfortunately, making number 13 stay. I'd hate to see something happen to one of the 12 and this result in a mistrial after other time and expense.
If we keep one, should we keep all? And then we'd have to pick at random again who the replacement juror was. But they're not part of the jury deliberations, or kept someplace else.
Right.
Yeah.
I'm more safe than sorry, Judge, and I'd rather be safe than sorry here.
I understand that. Any objections? Then, with that, there's logic to Mr. Zupakowicz's position.
Yes, I understand the reason for it, Your Honor.
So then what we'll do is, once we pick the alternates, we then will move the alternates to an alternative location. They'll be kept here while the jury deliberates. And if there's a need to replace the juror during deliberations, we'll follow. There's, I believe, a Supreme Court case on it. We'll follow that process. All right, that's how we'll proceed then. With that, we'll make the changes in the instructions. I'll be sure we make those modifications. We can give you copies before you leave. Otherwise, we'll be in recess till, let's say, 1:15. I'm going to order that Ms. Weier be moved over to the Juvenile Center for lunch, and if she wishes to meet with her parents, that's fine. And if she wishes to meet with her attorneys, that's fine. So ordered.
Thank you.
Then court will be in recess.
Your Honor, and when the court is saying parents, I believe her grandparents and or sister may be here. Is the court...
I'd authorize meeting with family.
Thank you.
Fine. Good afternoon. We back on the record in the State versus Weier case, same appearances. We're prepared for some additional testimony this afternoon. True?
Yes, sir.
All right, anything further we should discuss before we bring the jury in?
No.
Only, sir, that I do have the printout with the timing of the clips that we have played. completed for the court. I've already provided a copy to the state. Then I would be calling Dr. Michael Caldwell.
Is just on what you've given us now, is it the same document that was previously used the last several days with the addition of for the expert?
Yes, sir, and having the time stamps for the information for the expert.
And they're all from what was the respective discs that have been marked?
Yes, sir.
All right, very good. We titled the first index, if you will, F1. I think we'll make this F2, so we have a way to identify it in the record.
Thank you, sir.
Then, with that, we'll bring the jury in. All right, thank you. Please be seated. Good afternoon to the jury. We'll note the jury's back in the courtroom and in the box. We're prepared to continue then. Attorney McMahon, do you have further witnesses to call?
I do, Your Honor. Dr. Michael Caldwell. And may Dr. Caldwell have a bottle of water with him?
He may.
Stand.
Yeah, right up here.
Swear to tell the truth, the whole truth, and nothing but the truth to help you God.
I do. Very good. Thank you. And then be seated. Pull up to the microphone, and then state your full name and spell your last name.
My name is Michael Caldwell. My last name is Caldwell.
All right. Thank you, Doctor. Attorney McMahon.
Thank you. Dr. Caldwell, there should be a couple documents in front of you.
Yes.
One is marked A1. Can you tell me what that is?
This is a copy of my current resume or curriculum vitae.
And you provided that to me, correct?
That's correct.
And did you prepare it?
Yes, I did.
And to the best of your knowledge, is it accurate?
I've since had another article accepted for publication, but otherwise it's correct.
Okay. And how are you employed, sir?
I have a half-time position as a senior staff psychologist at the Mendota Juvenile Treatment Center in Madison. And then I have a 1/3 appointment at the University of Wisconsin-Madison as a lecturer in psychology. And then I have a private practice, and in that regard, in that capacity, I have a 10% appointment at the University of New Mexico at the Mind Research Network there. And I have a number of other consultation contracts I have with University of Oklahoma and several other organizations. And then I do evaluations for courts or sometimes for the Department of Human Services.
Okay. And Tell me about your educational background to become a psychologist.
I grew up in a little farm just outside of Kansas City, so I went to Kansas State University for my undergraduate. I initially studied engineering, and then I switched into a microbiology degree and finished with a bachelor's degree in life sciences in '76. And then I went straight into a master's program in counseling psychology and finished a degree in counseling psychology, and worked as a psychotherapist then for about 8 years or so before I went back for a doctorate in clinical psychology at the University of Denver, and I completed that in 1988.
And as a part of your educational background, were you required to do any internships?
Yes, I was on both the master's level and at the doctorate level.
Can you tell me a bit about those?
At the master's level, I had a couple of internships. One was with the U.S. Army in the retraining brigade at Fort Riley. One at the doctorate level, I worked for a year at the Western Missouri Mental Health Center in Kansas City, Missouri, studying a number of things and providing clinical services in several areas.
Okay. And did any of the internships that you dealt with during your master's or your doctorate level work include working with children?
Yes, my doctorate program was included about half of the year I was on a adolescent treatment unit. And then I also, one day a week throughout that whole year, I did a rotation known as a neuropsychology rotation, where I conducted evaluations of kids that may have brain injuries or that type of thing, and analyzed the results of those tests.
And in addition to the education that you've already listed and the internships, have you done additional training?
Yes, I've done a lot of different additional training programs, and more recently I'm the one who usually is providing the training. But over the years, yes, many different types of programs.
Can you tell me about some of the trainings you've provided recently?
Yes, I've done some research in adolescent sex offender risk, and so I've done several training programs on how to assess risk in adolescent sex offenders. I also commonly get asked to present on how to treat very aggressive and callous adolescents. We have a program, the Mendota Juvenile Treatment Center, that's demonstrated, it's become internationally known for the ability, or for the program's effectiveness in treating particularly violent and difficult to treat individuals. So I commonly get asked to provide a half-day or a full-day workshop, or sometimes 2 days, on how to do those kinds of programs. And there's a variety of other small things I do.
Okay. Are you licensed to practice psychology in the state of Wisconsin?
Yes, I am.
Do you hold other certifications related to your area of practice?
Yes, I was elected as a fellow of the National Association for the Treatment of Sexual Abusers a couple of years ago. I have a certification in the psychopathy checklist, which is a state-of-the-art measure of assessing psychopathic characteristics in individuals. I have a certification for in the Association of State and Provincial Psychology Boards, which is an international organization that essentially provides, you have to demonstrate that you would meet their licensing requirements in any state or any province in Canada, and if you do, then they license you that way. I'm probably forgetting some others, but that's a summary.
Have you done any grant-funded research?
Yes, quite a bit over the years.
And any of it that relates to juvenile development or analysis of a juvenile?
Yes. Previously, I had some grant-funded research on the treatment of aggressive juveniles, on how to treat very violent and aggressive juveniles. More recently, I supervise and I'm a co-investigator on a National Institute of Mental Health funded research project where we do MRI studies of adolescents at the Mendota Juvenile Treatment Center as they go through the program, as they go through the treatment program. The program is has shown that it can reduce violent recidivism by about half, and so we're interested in whether that change also is reflected in changes in the way the person's brain functions over the course of the program. And so I've been supervising that now for several years. Those are the main ones related to adolescent development.
Okay. Now, you realize we're in adult court, correct?
Yes.
And that Ms. Weier is charged with as an adult.
At this point, yes.
And you have evaluated Ms. Weier a number of times, correct?
Yes, I have.
In fact, you have testified about the competency of Ms. Weier, and you asked the court to consider returning her to juvenile court, correct?
Well, my opinion was that her interests were best met in juvenile court, and that the juvenile court could treat her within the available time.
Okay. So we asked, but
Yeah.
your report was used.
Yeah.
But we're here now, right?
Right.
And the question that I think might come to someone's mind is, are you just saying that you evaluated her, correct?
That's correct.
And you found that she met the standards for NGI. And I'll go through that with you.
That's correct.
Are you just saying that because you can't get her back to juvenile court?
No. These are different. There's different criteria, and it's not unusual for a person to, for example, to meet the criteria for being competent, but also to meet the criteria as being not guilty by reason of mental disease, or vice versa. These are different criteria. You evaluate them in different ways, and you reach your opinions in different ways.
Okay. You already testified about your current employment, sir.
Yes.
And you mentioned that you've got another publication since your vitae, but have you published articles?
Yes, quite a few.
And again, do they reflect the interest that you've already expressed in measuring the brain's response to treatment, in essence?
Some do. Some have to do with assessment of, as I mentioned, assessment of juvenile sexual offenders. I think my first publication had to do with assessment and treatment of people with PCP, toxic psychosis. So it's been a range of things, but they tended to focus around dangerous people or difficult to treat people or adolescent development.
Your Honor, I'd ask that Dr. Caldwell be allowed to continue to testify as an expert on the grounds of NGI.
I'll permit that.
Thank you. Now, Dr. Caldwell, I had you identify Exhibit A1, correct?
That's right.
That's your curriculum vitae.
That's correct.
And I would move into evidence the CV of Dr. Caldwell, please.
Any objections?
No.
Then that'll be Exhibit AA, received.
Doctor, you met with Anissa, correct?
Yes.
And do you remember how many times?
I believe it's been 4 times.
And do you remember approximately when you first met with her?
Yeah, well, referring to my report, my first meeting with her was July 9th of 2014.
Okay. And you're looking at something. Is that a report you generated?
That's correct.
It has an exhibit sticker on it?
Yes, Exhibit A2.
And I believe the judge has asked me to renumber them to, that should be AAA, I believe?
It would be AA.
AA? Okay. So, if you would, do you have a pen up there, sir?
Yes, I do.
Would you, where it says A2, make it a second A?
Sure.
Now, is this his report or?
This is his report.
Oh, that was AB. I'm sorry.
AB? I'm sorry.
AB.
A1 is the CV.
That's true.
Okay.
So, thank you. So, from your report, you recall you met with her in July of?
2014, that's correct.
Okay. And that was approximately a month and a couple of days after the event?
That's right.
And do you recall why you were meeting with her?
Yes, at that point, the issue was whether she was competent to stand trial, and there was also a question about whether she could be better handled in juvenile court versus adult court. So those were both in my head at the time.
Okay. And we also asked you to look at not guilty by reason of mental disease or defect, whether she was mentally responsible, correct?
That's correct. I don't recall whether we were talking about that on July 9th, but it was not shortly. But it was in the mix somewhere along the line.
Okay. Now, Doctor, you were hired by my office, correct?
That's correct.
Not by the court, not by the state.
That's right.
And when you met with Anissa the first time, would you have considered her a child or an adolescent?
She was a child.
And what do you mean when you say that? Why would you say that?
Well, I consider, the way I describe it, a child is someone who is up to the point where they enter puberty. They're a child. From the onset of puberty on, I consider them to be an adolescent up to about age 18. And that statutorily, that's when they are considered an adult. So that's the terminology I use.
Okay. And how is it that you determined that she was a child?
Well, first, just talking to her and looking at her, she was obviously very young. Second, in the records, we had a physical that she had completed with her physician. Just again, referring to my report, it was dated October of 2013, so a few months earlier. And in that, as part of a regular annual physical, a physician will rate what's called a Tanner scale, which is a scale that measures how physically mature the person is, and particularly as they go through puberty. It's a 5-point scale. Point 1 is when the person has no secondary sexual characteristics at all, very young child. And point 2, this level 2, is when they're just beginning to show some physical maturation, but haven't quite entered into puberty yet. And she was scored as a scale 2 on the Tanner scale. So that's also a medical doctor indicating that she was still very immature, still had a long ways to go for maturity.
And why is it important to determine whether a person is a child, an adolescent, or an adult when you are assessing them for responsibility?
Well, there are certain common features in the thinking of prepubescent children that change as the person goes into adolescence, and there are other characteristics of adolescence that are different than the way children think, and also different than the way adults think.
How do you know this?
Well, we know this from a large body of research now over several decades, both studies of how people work out problems and handle problems in controlled situations. One of the more recent ones is how people deal with complicated, dangerous situations when driving. You put them in a driving simulator and manipulate the risk that they face and the red lights and those kinds of things. And we know that adolescents deal with those situations differently than young children, pre-adolescent children, and also adults, particularly differences in how they handle having friends of theirs in the car and those kinds of things. So out of all of that research, 3 main characteristics were popped out for changes as an adolescent, and those are the ability to control and modulate emotions, the ability to kind of reason rationally about social situations and not be influenced by other people in social situations, and then just basic planning and the ability to solve problems and think in rational terms about complicated situations. All of those change fairly dramatically during adolescence. And in some ways, children are more similar to adults in terms of their resistance to the influence of peers than are adolescents. Adolescents are more susceptible to the influence of peers. And then, of course, young children also, prepubescent children, have a weaker, what's called a sense of reality. They have a weaker sense of what's real and what's not real, a weaker ability to distinguish the difference between those things. So they're likely to believe in Santa Claus and things like that, ghost stories, that type of thing. And as the person progresses through adolescence, they develop an improved sense of reality in a normal person.
Okay. Now, you've mentioned studies involving simulators, things like that. Do we have ways of knowing actually whether the brain functions differently?
Yes, in the last couple of decades, with the development of the magnetic resonance imaging machine, this is a machine that allows for the first time to be able to look at what's going on inside of a person's brain without cutting their head open, and which has obvious limitations. And so it's developed to the point where you can actually see what part of the brain the person is using to solve certain problems and to deal with certain situations. And so that has told us a couple of things about how what parts of the brain are being used to solve social problems and analyze complex situations. But also, I think one of the big surprises is that it has shown us that the actual physical structure of the brain changes fairly dramatically as the person goes through adolescence. This is now thought of as the brain being fully rewired during adolescence, reorganized in a number of ways. And so that's all stuff that we have learned about neurological changes that happen during adolescence.
And why is it important to take that sort of information into account when you're assessing the responsibility of an individual?
Because it's not unusual for a full-grown adult who's done a crime to use very poor judgment. And sometimes the difference between an adolescent and an adult is that the adult has the capacity to use good judgment. They've got the brain maturity and the structures in place to use that. At other time, with adolescents, that's not always the case. Often their limited reasoning ability and planning and problem-solving ability is based on an actual weak capacity in their brain because it's not mature, it's not fully mature, it hasn't developed to the level of an adult.
Okay. And within the field of psychology, is there a way to sort of measure when you're looking at a person how their response is? It's not all just clinical judgment, right? There's a way to look at things and to determine what you're looking at, correct?
Yes, typically to do an evaluation, you do a clinical interview, of course, but typically you also do some testing in a number of areas to be sure that the test results confirm what your clinical impressions are, or if they don't, to try to figure out why there's a difference there.
Okay. And did you perform any such tests on Anissa?
Yes, I did.
2014?
Yes, I did.
What did you do?
I did a Wechsler intelligence scale for children, which is the most widely used IQ test in the world. I also did it's a broad kind of personality test of how the child is functioning and what sort of mental health problems they may have, called the Achenbach Youth Self-Report Scale. And then a brief symptom inventory, which is just a short symptom checklist that gives you a picture of how the person has been feeling in the last couple of weeks, so that you know whether they're having a particularly good or bad day when you interview them. And then an aggression questionnaire, which is a measure of how the person sees the world in terms of whether they see the world as a malicious place, a dangerous place, that kind of thing. And also whether they are someone who thinks that you just have to be violent periodically to achieve your goals or to defend yourself, that kind of thing. How much they endorse violence and have violent attitudes. And then the last was a Halstead-Reitan trail-making test, and it's got two parts, part A and B. And this is a brief neurological screening test that is sensitive to brain injury. That tells us, just screens out the possibility that this person has had a brain injury, and that may account for some of their behavior.
Okay. What did you learn from the Wechsler?
From Wechsler, she had compared. Now these scores compare to people the same age, so this would be compared to other 12-year-olds. She was above average. Now, if you compare her to an adult at that time, she was right about at the average. But compared to 12-year-olds, she had above average IQ, and particularly when it came to verbal skills, her ability to analyze things verbally and explain definitions of words and those kinds of things. But there was one area of weakness, and that was in what's referred to as processing speed. That's an area that's controlled by a part of the brain that's in the middle of the brain, and it has to do with how fast the person can pull together information and analyze it and produce an output. And that affects how well the person is going to be able to analyze complicated situations and problem solve when there's several things that they have to be thinking about at once. So for example, when you're driving down a road in a city during rush hour traffic, there's lots of things going on, pedestrians, lights, those kinds of things. All of those have to be analyzed on the fly with multiple changes in time. A person with very severe processing speed deficits will have trouble with that. Her deficit in that area was not particularly severe, but it was striking compared to her other functioning. It was much lower than her other functioning.
What sort of things would a deficit in her processing speed indicate to you?
There's a couple possibilities. One possibility would be a brain injury or a tumor, but the Halstead right-hand scale did not indicate anything like that. And in my interview with her, I also didn't see any soft signs of that kind of problem. More likely, in her case, would be two possibilities. One is that people who are depressed, if you've ever been a little depressed, your thinking slows down and it just becomes harder to process information. And so that's a likely possibility in her case. It's also common in people that have attention deficit disorder without hyperactivity. I didn't see any indications that she has attention deficit disorder in any other areas, and the school records also didn't show any indications of that. So the most likely explanation was that she was feeling depression at that time.
Okay. And so the Halstead you did to rule out brain injury because of the lowered processing speed.
Yes, actually, I do the Halstead or something like it routinely, just because there's been occasions where I've evaluated someone who didn't seem to have a brain injury and it turned out that they did. So I try to rule it out in every case.
Okay. After meeting with Anissa and completing the test we've just discussed, did you review other materials, or did you review them before meeting with Anissa?
I most of the material I reviewed before I met with her, but there has been a number of documents and things that have come in since then also.
Okay. Before you met with Anissa, do you recall what you reviewed?
Yes, I reviewed the medical record that I talked about before from our physicians. I reviewed the school records from the Waukesha School District and West Bend. I reviewed the police records and the petition related to this case. I also reviewed the DVD of her interrogation or questioning by the detective on the day of the incident, and also the DVD of Morgan Geyser's questioning. And then I don't recall whether I believe I saw the DVD of the victim, the interview with the victim after I met with Anissa the first time. So those were the main documents I reviewed.
Okay, so after you'd reviewed all of those documents, met with Anissa, done the testing, did you reach some conclusions regarding her?
Yes, I did.
And did you put them into a report?
Yes, I did.
And is the report in front of you, Exhibit 8E?
Yes, it is.
Now, you've already told us you found her intelligence for a child of her age to be above average with the processing speed issue.
Yes, that's right.
And it sounds like her verbal skills were probably the greatest.
Yes, they were significantly above average.
And from her personality and diagnostic measures, what did you learn?
Well, first, they were very consistent across these measures. Some of the measures have scales built in to detect if the person is exaggerating symptoms or minimizing or just being inconsistent in their answers. There was no indication that she was being inconsistent or trying to manipulate the results. And in my interview with her, I also didn't detect any indications of that she was trying to sort of con me or sway the results. But the personality, the Achenbach measure, again, the thing that popped out was consistent with her clinical presentation, which is that she was depressed. She had some anxiety symptoms. She also tends to have a little bit of a trait that is similar to a psychotic propensity, but is not actually quite not quite a full-blown psychotic disorder or a schizophrenia kind of disorder, but some loosening of her rational thinking at times. And so depression, anxiety, and also with regard to her interpersonal functioning, her relationships. She's someone who tends to be very dependent, wants close relationships, and not someone who is particularly forceful or likely to drive people off by her dominating personality or that type of thing.
Okay. After reviewing all of this information, did you find Anissa to have a diagnosable mental health disorder?
Yes, I did.
And what was that disorder?
There were two disorders. One was a delusional disorder. These were on the day of the incident. She suffered from a delusional disorder. And the second was a persistent depressive disorder, which is just a person has been depressed for an extended period of time. And those were the two key findings.
You also noted I believe you mentioned a trait.
That's correct.
It's called schizotypal, correct?
That's correct.
And that is something in the DSM-5, Diagnostic and Statistic Manual 5, that is considered part of the schizophrenia spectrum, correct?
It is, yes.
What is schizotypal?
Schizotypal, the key characteristic is the person has what's referred to as aberrant salient motivational processing. Now, all that means is that the thing that they pick out as the important thing that motivates their behavior is just very odd and sometimes sometimes can be bizarre. And so these are individuals who sometimes are, in adults, are sort of eccentric, have eccentric beliefs, believe in conspiracy theories or those kinds of things. It doesn't necessarily mean the person will develop delusional beliefs, but in a child and in an adult, it sort of predisposes the person to believe things that are delusional and to develop delusional disorders because they don't have the same capacity to analyze just the reality of certain situations, and they're likely to be motivated by something that other people would say, well, that's absurd, that makes no sense.
Okay. Now, what is the difference between, you mentioned a delusion, what's the difference between a delusion and you mentioned before, and the state has mentioned a number of times, say a belief in Santa Claus? Is there something different about those two things?
Yes, there's a couple of key features of a delusion that's different than religious beliefs, belief in Santa Claus, or anything else. A delusion includes that the person has a belief that they have a unique or special gift or special information that no one else has, and that gives them an insight into the delusional material that no one else has the ability to see. And so they believe often delusions involve a conspiracy or something like that. So if they talk to someone else about their delusional belief and the person says, that's crazy, that makes no sense, the two possibilities for them, an average person would question the delusion, but again, that's normal salience processing, that's normal thinking. For a person with this characteristic and a person who's developed a delusion, their thinking is either the person who doesn't believe it is in on the conspiracy, they're part of the conspiracy, or else they just simply don't have this special gift to see the unique characteristics that they've been able to detect. And so that's one of the key differences in a delusion versus just an odd belief, or even not an odd belief, just a belief in something that you can't scientifically prove.
Did you reach an opinion after taking a look at the mental health disorders as to whether or not Anissa could appreciate the wrongfulness of her actions back in 2014?
Yes.
On May 31st?
Yes, I did.
And can you explain to me what that opinion is?
Well, it's two parts. First, I believe that her functioning on that day was that she believed in Slender Man. She believed that she and Morgan Geyser had a special understanding of that Slender Man was real, and that no one else seemed to be able to have that insight. And a second component of delusional disorder is the person feels that they are compelled to act on the delusion. That's what makes it a disorder. If a person has a delusion and they just sit in their house and play video games or whatever and never act on it, then it's a delusion, but it's not a delusional disorder. So people with delusional disorder have a compelling need to either save the world or save their family or something like that, and they can't let that go. And so there are two components to this. One is whether she fully appreciated the wrongfulness of her behavior. I think she understood that the behavior was going to be criminal, that they could be arrested. But believing that this was an evil force that no one else could understand except herself and Morgan Geyser placed on her a moral requirement to try to protect herself and her family from this horrible thing. And it was, in her mind, I think, that she was acting out of a sense of altruism, that she was saving someone in this very difficult moral choice. So in that regard, I don't think she fully had an appreciation of the wrongfulness, even though she understood the illegality of the behavior. I don't think she had a completely intact ability to understand the wrongfulness of the behavior. Secondly, if you don't fully understand, if you don't fully appreciate exactly what it is you do, you don't understand all the consequences and all of that, if you haven't got the ability to do that because of a mental disorder, then you don't have a full ability to conform to what the law requires. You're compelled to take an action that is illegal, but you don't have the full capacity to control your actions because you don't really understand the nature of what you're doing.
And are there any changes or additions you would make to that report today?
None that I can think of.
Okay. I'd move Exhibit AB into evidence.
Any objections?
No.
Received.
Dr. Caldwell, during the time that you were trying to reach a determination about the mental responsibility of Anissa Weier, did you take a look at the Creepypasta website?
Yes, I did.
And what did you find?
It was remarkable. It was very convincing. There were medical records, or at least what were purported to be medical records of psychiatrists interviewing patients who had had contact with Slender Man. There were police reports documenting contacts with Slender Man or investigations. There was a series of memos that seemed to be from the Secret Service or some national, possibly a division of the FBI, talking about investigating Slender Man and having a project where they were investigating these things. There was a videotape of an older woman, probably in her late 60s or early 70s, giving her last will and testament and asking that her children use her finances to investigate Slender Man and to prove the reality, because she had had several encounters with Slender Man. So there were a number of part of the entire story, I guess, at the time was to try to create a sense that this was real, which made it frankly more creepy, and to try to kind of get under people's skin by presenting what appeared to be a lot of factual basis for it, the kinds of documents and information that frankly would be relied on among medical professionals or police or lots of other professionals in coming to certain conclusions. So it was very remarkable how it had been put together.
Okay. And within the Creepypasta website, there were numerous references to Slender Man, correct?
Yes, there were.
As well as Jeff the Killer.
Yes.
Slender Man was portrayed as an individual who stalked, stole, and strangled children, correct?
That's correct, yes. Over many years. And he also had the ability to teleport instantaneously, and in some references had the ability to control people's minds from a distance and that type of thing. So you would never be able to see him or actually capture him. He would just teleport out. And he apparently had the ability to teleport his proxies or his people that were under his control. He could also teleport them to different locations as well.
So the wiki itself told people that Slender Man killed. correct?
Oh, yes, yes, that was the key feature, that he would kill children, capture and kill children.
And the Jeff the Killer that I mentioned before, you heard about him from Anissa, correct?
Yes, I think I ran across it on the wiki. I can't remember whether I heard it from her first or on the wiki site.
Okay. And that was an individual actually named Jeff Woods, correct?
That's correct.
And when you met with Anissa in July of 2014, did she still believe Jeff Woods existed?
Yes, she did.
And did she still have some nuggets of the belief in creepypasta and the Slender Man myth?
Yes, I'd say she was a bit mixed. She still believed in parts of it. For example, Jeff the Killer, the story is that this was an individual who killed his family and set fire to the house and disfigured himself, and that he was now being held in a psychiatric facility in northern Wisconsin, but that he also was essentially a proxy for Slender Man. This gets into it's a good illustration of kind of the irrational component of this, because Slender Man could tell, if it was consistent, Slender Man could just simply teleport him out of the hospital, but that didn't seem to be happening. But Jeffrey Woods was one of the proxies for Slender Man, or in some way associated with this, and was dedicated to killing children also.
Okay. And you have evaluated or met with Anissa at least since to see how she's doing, correct?
That's correct.
And when was the last time you met with her?
The last time, I believe, was about a month ago.
And where did you meet with her?
In the detention center in Washington County.
Same place you met with her back in 2014?
Right, for all of the interviews, yes. And
did you still see some kernels of the delusion?
Yes. She, partially, I should say. She still believes that Jeff the Killer is a real person and is being held in a facility in northern Wisconsin. Doesn't believe he has any special powers, and she didn't when I met with her back in July of 2014, but still believed the rest of the story. She had some sort of mixed feelings about Slender Man and was thinking that he may be more just an evil force in the world, something more akin to the way some people think of the devil, but someone who may be or may not be out there influencing people to do bad things and just an evil force.
And was that consistent with the schizotypal that you had previously diagnosed her?
Yes, very much so. This kind of characteristic often is more bizarre during the teenage years, where the person's reasoning is not as mature, and then often matures into more of what might be a fairly conventional spirituality or religious belief that the devil has an influence over our lives, and that if we can stay on the right path, that we can resist the influence of evil and the devil and that kind of thing. So it can develop, and in my interview with her just this last month, it was clear that it was starting to develop into a more of a conventional kind of, maybe somewhat eccentric, but more of a conventional spirituality.
And you are aware that Anissa, for the time that she has been at West Bend, has been, at least for part of the time, meeting with a counselor?
Yes, she has.
She's not on medication, though, correct?
Not that I know of, no.
The opinions that you came to and the conclusions you came to and the diagnoses that you came to within your report, do you hold those to, are they the same conclusions you would have today?
Oh, yes, yes.
And do you hold those beliefs to a reasonable degree of certainty in psychology?
Yes, I do.
Thank you. Nothing further.
All right, thank you. Cross-examination.
Thank you, Judge.
think this might be a good time for the jury to stand and stretch.
And Your Honor, prior to additional testimony, did I...
No, we're not on the record right now, so.
Sorry. She was stretching.
We'll let everybody stretch and then we'll take any comments we have to. Please be seated. And then, Attorney McMahon, you had a comment to make?
I apologize, Your Honor. I was not sure if I had moved Exhibit AB.
You had, and I received it.
Thank you.
Very good. Thank you. Then we should be everyone set in the jury. All right, very good. Then I think we can proceed. Attorney Osborne.
Thank you, Judge.
Is your microphone on?
It is not, Judge. Thank you so much.
There you go. Thank you.
Doctor, I just want to start with a couple of preliminary questions so I make sure I understand the report. You testified today that you met with Anissa 4 times?
I believe altogether 4 times, including this one just last month.
Okay. But if I'm reading your report correctly, it says personal interviews with Anissa and psychological testing on July 9th and 14th, lasting 5.5 hours. And I'll be the first to admit that I've missed things before, but is there another indication there of the things that you did that indicates there were, I guess at this time, even 1 or 2 other interviews, or do they both come after this report?
They both came after the report.
And you didn't file a supplemental report, so is it fair to say that nothing of significance came out of that, both in terms of changing your opinion or anything that you felt needed to be reported?
That's right. I met with her once in November of 2015, I believe it was, around competency, I believe it was. And then this last one just to catch up on how she'd been doing more recently. So there was nothing of significance.
And this is not a big deal, but I just want to make sure I understand. When you say lasting 5.5 hours, is that the 2 interviews together lasted 5.5 hours, or each one lasted 5.5 hours?
The total was 5.5 hours.
Thank you. Now, and I know Ms. McMahon already went through this, but you are hired by the defense in this case, correct?
That's correct.
And on 3 occasions, you've rendered opinions about this case, and for want of a better way of saying it, on each of the 3 occasions, you rendered an opinion that was what the defense was hoping you would render, correct?
That would be favorable to the defense. That's right.
Now, Doctor, if I'm looking at your report now, I guess I want to just make sure I understand something. You talked about delusions, and then you talked about other things that someone might believe, like Santa Claus, and how they're different.
That's right. That's right.
It's fair to say, I think, isn't it, that sometimes kids, because of their imagination, see things that aren't there? They're afraid of the boogeyman, or...
Sure. Ghosts in the closet, things like that, sure.
And then, as you mentioned that, Anissa's father talked about an incident when she was 10 where she thought she saw eyes in her closet. Now, that was never repeated, never brought up to you, so I'm assuming that would just be, you would consider that more of just childish imagination, correct?
Yeah, probably. I haven't talked about that, I haven't heard about that particular item, but that sounds like just childhood imagination.
So not everything a child believes rises to the level of a delusion, correct?
That's correct.
And is it a delusion? You said that when you most recently met with Anissa, she still believes that Jeff the killer exists, but that her belief is now morphed to, and I don't want to use the word ordinary, but I'm going to use it. He's just an ordinary killer who's now in an insane asylum. He's not some supernatural being. That's, I understood you correctly.
That's correct, yes.
And is that a delusion if everything she's reviewed, you talked about going on the Creepypasta website, how they have fake police reports, they have fake newspaper articles, they have fake pictures. Is it a delusion if you've seen all that, and that's all you've seen, that you think that it's real?
Not by itself, no. That's not enough to be a delusion or delusional disorder.
So it is possible to believe in something that's not real and still not have it be a delusion, correct?
Correct.
And when we get to the next level, now we accept that, for the sake of argument, that Anissa has a delusion. That doesn't make her have to kill somebody, does it?
The delusion by itself doesn't, as once it becomes a delusional disorder, then again, as I mentioned, there's a compulsive quality to it, and that manifests in different ways with different disorders.
In this case, you found the compulsive element of it to be, as you put in the conclusion to your Exhibit AB report, you found the compulsive element to be Anissa developed a delusional belief that Slender Man posed a threat to the life and safety of children and their parents in general, and to herself and those she loved specifically, correct?
That's correct.
That's the compulsion you're talking about.
Well, it goes a little beyond that in that because she and Morgan were the only people that had this insight, it was incumbent upon them to act to defend the safety of their families from this evil force. So it's the combination of the belief, but also it includes the sense that you are the only person who can do anything about this.
Now, maybe I'm reading your report wrong, and you can tell me if I am. You concluded first that although Anissa's ability to appreciate the wrongfulness of the alleged acts was substantially impaired, she continued to remain a minimal capacity to appreciate that the alleged acts were illegal, correct?
Correct.
And then you went on to say that she lacks substantial capacity to conform her conduct to the requirements of law, and that's because of the compulsion that we were just talking about.
The compulsion and the delusional disorder, yes.
Let me put it in a way that seems to me to be correct, and you can tell me if I'm wrong. What you're saying is she understood that killing Payton would be wrong and illegal, but she felt she had to do it because of the delusion and the compulsion.
She understood it was illegal. What I'm saying is that her ability to understand the wrongfulness was compromised by the delusional disorder. In other words, obviously if you know something is illegal, there are certain circumstances where you may feel like you have no choice but to take the step in spite because there's a moral requirement for you to act in the way you understand the world to be at that moment. And that was the compromise.
What you said in the last paragraph of your discussion was Anissa's delusional disorder caused her to believe that engaging in the alleged act was the only way to protect her family and her life, correct?
Correct.
Now, you've concluded that Anissa and Morgan had a relationship that caused Anissa to have a shared delusion, correct?
I'm sorry, could you ask that again?
Sure. You concluded that Anissa has a shared delusion that basically comes from Morgan.
Right, that they developed a shared delusional disorder. That's
and
correct.
I conclude from that, and you can tell me if I'm misunderstanding it from I'm not a psychiatrist or a psychologist, but from my research, I conclude from what you said that you would believe that Morgan is the dominant in the shared delusion and Anissa is the submissive.
Well, it's partially true. Typically, we talk about a primary, the person who has the schizophrenia, and a secondary. They may not have a dominant and a submissive relationship, but the dominant or the primary person typically has a long-standing or a more severe psychiatric disorder, and the secondary adopts the delusional disorder, delusional beliefs out of an intense relationship with the primary. It may not be a dominant situation.
All right. Let's look at it. I'll use the correct words, or the words at least that you're using. You would conclude that Anissa was the secondary.
That's correct.
You've clearly done some research into shared delusion disorders, correct?
Some, yes.
They're rare. Is that true?
They are rare. That's correct.
And in fact, if we look even deeper, this particular shared delusional disorder relationship is very rare, correct? And let me be more specific before you even answer the question. I'll come back to the question. The normal shared delusional disorder participants are usually in their 40s or older, correct?
It tends to be more common in adults, yes.
In most situations, there's a familial relationship, correct?
Probably the most, yes.
Are you familiar with an article entitled "The Nosological Significance of Folie à Deux, a Review of the Literature," published in the Annals of General Psychiatry?
No, I actually can't remember if I've reviewed it or not.
Sure. What are we up to? What are we up to? Give me a copy since I have this one. No. Doctor, I'm showing you what's been marked as exhibit number 6. Just take a moment and look at that. Once you're prepared, that you reviewed it enough, let me know.
Okay.
And does that appear to be a scholarly treatise reviewing the literature on shared delusional disorder?
Without reading it in detail, yes, it does.
In fact, and so that we're all clear, though I think it came up yesterday, folie à deux is a French phrase for shared delusional disorder. I think literally it means madness of two, is that correct?
Yes, it dates to the 1800s, but yes, it's a French term for the same disorder.
And I'm just trying to get to like what I was saying, which is that it seems that this would be an unusual thing to be a shared delusion. It indicates on page 3, they looked at two groups that were analyzed between 1942 and 93, correct? And then from 93 to 2005.
Yes, that's correct.
The mean age of the primary in the first group was 48, in the second group was 52. Secondary in the first group was 42.9, and the second group was 45.9. So it is generally, at least, older people that are involved in this. Is that a fair statement based on that?
Generally fair, although in both of those, the youngest was, in one case, 9 years old, and in the other case, 10 years old.
And I respect that, and I was going to get to that. It's not impossible, I'm not saying that, but it is unusual for two people of this age to have a shared delusion disorder, correct?
It's an unusual disorder to begin with, but this age is also unusual.
And if we look on page 4, we see that in terms of relationships, in the earlier study, 9.9% were friends, and only 2.4% in the second study were friends. So it's also unusual that they're not familiar, that they're not family members, correct?
Yes, in this study, yes.
And then if we look at the length of association, we find that on page bottom of page 4. The duration of the association generally was 47 months in the first period and 32 in the second one. So, I mean, second group of people being analyzed, correct?
That's correct, and not surprising.
And in this case, the information is that Morgan and Anissa met in October of 2013, and by December or January of the next year, that's 2 or 3 months, they're already planning this event. That is an unusually short period of time for this shared delusion to develop, isn't it?
It would be compared to the results in this review.
And in fact, the indication is that they were spending, this comes from your report, 40 to 80 minutes a day together.
That sounds about right, yes.
Now, that seems to be an awful short period of time for that delusion to, I'm not saying it's impossible, but I'm saying it's an awful short period of time for that to be together, for that delusion to transfer from one to the other. I mean, we're not just talking 2 to 3 months, we're talking roughly an hour a day during those 2 to 3 months of combined time.
Yeah, I don't know that was the total sum of their time together. That was the time they rode the bus together.
Okay.
But yes, it is a short time.
And in terms of, and I think you hit upon this, in terms of it used to be that psychologists and psychiatrists believed that the best treatment for this was simply separation, correct?
Going back many years, yes, that was the thinking.
Now, more recent studies show that separation alone is frequently not enough to get over the problem.
That's correct.
That it requires either psychological treatment or medication or both to actually overcome the shared delusion. Is that a fair statement?
Well, for the secondary to not be delusional.
Correct.
Yes.
And certainly, and I know you talked about what Anissa told you, but certainly it would be unusual for the delusion to go away in a matter of hours, wouldn't it?
No, actually, this is one of the common characteristics, at least of what we see is there are certain types of shared delusional disorders. Some of them remain even after the people are separated and they are fixed. But there's a category that is very common for the secondary person to drop the delusional beliefs almost immediately after they're separated from the person. This is why, for a period of time, psychiatrists believe that all you need to do is separate them and the secondary would clear right away, because they had seen that in many cases.
And I think we've touched upon this. Even if they have a shared delusional disorder, or even if Anissa has one, does that always result in an opinion that if the person does something wrong, they wouldn't be responsible for it?
No, not at all.
No. But in this case, you believe it to be true, but it isn't always the case.
It isn't always the case, that's correct.
I have no further questions.
All right, thank you. Redirect.
Thank you. Dr. Caldwell, the article that you were just discussing with Mr. Osborne, it has some conclusions, correct?
Yes, it does.
And the conclusions indicated what?
Well, I could just read the brief conclusion in the abstract. It says, folie à deux, this disorder, can occur in many situations outside the confines of the current classification system and is not as rare as believed and should alert the clinician to unrecognized psychiatric problems in the secondary. So the conclusion is simply that there's more variation than it may be that this disorder has been missed fairly often. And I think that may, in my 40 years of clinical experience, I guess I've thought back on several cases that I worked with where the primary came in with a delusional disorder and had a close relationship with someone. We never brought that person in to assess whether they were a secondary, whether that was a shared delusion. And right now in the field, there's a suspicion that a lot of those people who are living in close proximity or have intense relationships may have a shared delusional disorder as well. So it could be more common than we think.
Okay. And you have worked with a lot of children over the years, correct?
Yes, I have.
You still work with children.
Yes, I do.
And many of the children that you work with are at Mendota Mental Health, correct?
That's correct.
And so I think it would be fair of me to assume that many of them have diagnoses, correct?
Yes, virtually all do, yes.
Would you consider all of them not guilty by reason of mental disease or defect?
No, the overwhelming majority don't meet that criteria.
And if you had felt Anissa didn't meet that criterion, we probably wouldn't have you here today, correct?
That's correct. I would have probably made a phone call, and then I'd be back at work today.
Okay. Dr. Caldwell, you, in your course of work at Mendota, have also supervised persons who were considered NGI, correct?
Yes, I have.
And have you made, in what capacity?
My first position at Mendota more than 20 years ago was as the staff psychologist on the admission unit for people who had acute mental health problems. So they were civilly committed from the community for being mentally ill and dangerous. And over the about a year that I was there, we had about 400 admissions, so I evaluated 400 people in that capacity. And then I ran the unit for the 14 people who were the most aggressive and difficult to manage criminally insane patients in the state. And I did that for 2 years, and of course there were a lot of individuals who had a variety of diagnoses in that capacity.
And in that capacity, did you have to do evaluations about whether that person was safe to leave your unit?
Objection, Your Honor. The state asked no questions on cross-examination about the doctor's background or prior work or anything else. This is clearly beyond the scope of cross-examination.
The state implied that the doctor only testifies for individuals who pay him.
I'll overrule the objection. I'm satisfied that it's appropriate to redirect in this type of case.
That's fine, but I object to that last way of putting my questions, because I don't think I said that in the least, Your Honor.
Well, we'll note that in the record. Thank you.
Dr. Caldwell, you've testified about whether people need to leave the facility, correct?
That's correct.
And as someone who was working in the facility, it was your job to evaluate to make sure people were safe.
Yes, that's correct.
Or dangerous and needed to remain.
Yes, it's a fundamental part of that kind of a setting.
Okay. And when you mentioned civil commitment at the intake unit, that would be under the statute chapter 51, not guilty by reason of mental disease or defect evaluation, correct?
Correct. That's the mental health code, which has nothing to do with criminal behavior or police or the courts or those kinds of things.
Okay. And you have at times supported persons not being found not guilty of mental disease or defect, correct?
Very often, yes.
And that was when you were evaluating them when you were at Mendota or privately?
Both. I've had times both in my private practice and at Mendota where my opinion was that they were criminally responsible for their actions. And
your report, while it takes into account Anissa's age at the time in 2014, your conclusion isn't that she was a child, so she's not responsible, is it?
No. It is, her immaturity played a role in the development of her delusional disorder, but the issue is that she had the delusional disorder and that impaired her ability to appreciate wrongfulness, as I've described, and ability to control our actions.
And if I understand it correctly, a delusional disorder is different than simply a delusion, correct?
Yes, I would say so, yes.
So a person with a delusional disorder has a delusion, but a person with a delusion might not have a disorder.
That's correct. For it to be a disorder, the person has to do things that are maladaptive, that cause some problem in their social world or some kind of serious problem.
Thank you. Nothing further.
Further cross-examination.
No further questions.
All right, very good. That concludes then Dr. Caldwell's testimony. Is he under subpoena?
Yes, sir.
May he be released?
Yes, sir.
Any objections?
No.
All right, you're released, doctor. Thank you for being here. Do you have any exhibits with you? I do. Very good, thank you. Then does Ms. Weier have further witnesses or evidence to call or to place in evidence?
We would rest, Your Honor.
Okay, then Ms. Weier rests. Then the burden moves to the state. Does the state have any evidence or witnesses to present?
No, Your Honor, the state does not.
Okay, then the state rests. That would conclude the testimonial and the evidentiary part of the hearing. We've discussed off the record scheduling of the case to decided to have the arguments and instructions tomorrow morning beginning at 8:30 to give you the full day, the jury, the full day to process the case and deliberate. As part of that, keep in mind that there's 16 of you, and that it'll be a jury of 12. There'll be a selection process of picking the alternates after the conclusion of the arguments. With that, then, we'll release the jury at this time.
You'll bring your notebooks with you, guys. Put them on the chair at the end of the hall.
Very good. Please be seated. I wanted to discuss the issue of the alternates for a moment, but are there any other issues the court should address before moving into that?
Yes, Judge. On Anissa's behalf, I'm going to make a motion for a directed verdict, and that's based upon what the evidence has shown through the presentation of the evidence at the trial. And Judge, I'll start by saying that what we know is that Anissa met Morgan in October 2013, and it was at that time that Anissa developed that interest in the creepypasta characters and the creepypasta website shortly after that. She then introduced Morgan to the creepypasta characters, that website. She didn't know this at the time, but Morgan had what is clear symptoms and a history of schizophrenia. When Morgan became introduced to the creepypasta websites, the characters, she developed what appears to be the delusion that the characters were real. Anissa also became obsessed with the character when she and Morgan started to share back and forth information and evidence that they found online on Wiki that confirmed that characters that they were aware of, Jeff the Killer, Slender Man, Zalgo, Hoodie, Maskey, they found evidence that those characters were indeed real. And that was due to their becoming obsessed with the creepypasta website, exploring what they could find on Wiki and the internet about those characters, evidence that they discovered that was authentic, real-looking pieces of what we would consider evidence of fact. They found newspaper articles, they found what the doctor described as transcripts of police reports that seem authenticate the reality of people observing those characters in the real world. And they shared that information back and forth with one another, and that obsession morphed into their delusional belief that Slender Man was real. That delusional reality ultimately led to their belief that they could become proxies and do that by killing a close friend. It also included in their delusional belief system a belief that they needed to kill that friend to protect themselves and their families. All those things became a part of their delusional reality, Judge. We have 3 experts in the field of child psychology who evaluated Anissa, and they evaluated her for the appropriateness of the not guilty by reason of mental disease or defect plea. 2 of the experts, Judge, were court-appointed. There was unanimity in what they found in terms of Anissa suffering from a delusional disorder at the time that she committed this act. She was under the command and control of that disorder. That disorder motivated her involvement in participating in the stabbing of Payton. Based upon the evidence, Judge, that was presented over the past 4 days, no reasonable jury could decide that we have not shown by a reasonable certainty based upon the greater weight of the credible evidence that Anissa did not suffer from a mental disease or disorder. When we presented evidence from 3 well-respected psychologists in the field of child psychology, they all agree that she suffered from a mental disease or disorder at the time that this occurred back May 31st of 2014. And that mental disease or disorder, that shared delusional disorder, caused her to lack the substantial capacity to appreciate they all agreed that she lacked the substantial capacity to conform her conduct to the requirements of the law. They don't all have to agree that both prongs qualified here. They have to agree that one of the 2 prongs qualified. All 3 of these well-respected doctors concluded that that's what happened here. That's what motivated her behavior, Judge. No reasonable jury could decide otherwise, Judge. So I'm asking that the court direct a verdict in Anissa's favor.
All right, thank you. Any motions from the state and or argument from the state?
Your Honor, the state believes you should direct a verdict, and it should be in the state's favor. The defense has presented 3 expert witnesses, and all 3 have clearly directed an opinion that is formed on the basis of incorrect information. All 3 of them are opining what they're opining because Anissa believed that Slender Man was a threat to herself or her families. Even though Anissa, as we pointed out in Detective Trussoni's testimony, pleaded for the jury, Anissa's first thing she says early on in the interview is, silly thing is, I didn't even know I was in danger until Morgan told me afterwards. It's her own words that she didn't know about the Slender Man threat until the crime was over. All 3 doctors rely upon that. Their opinions, therefore, are so suspect, since they're so reliant on that belief that didn't exist at the time, that their opinions have no validity. With no validity, the defense has not met its burden. That's all I have.
All right. Any Any rebuttal argument?
Judge, the doctor said, and I think all three of them were asked this very same question. In order for them to support their belief that she was not guilty by reason of mental disease or defect, do they have to be convinced that Anissa believed that her family was in harm or she was in harm when she acted? They said that is not necessary for their opinions. What they said is she was operating under the delusional belief that Slender Man was real and she needed to do it for Slender Man. And they said that was the delusion that motivated her. There's no dispute to that, Judge. And that's why the court should direct the verdict in Anissa's favor.
All right, thank you. Now, the state had a motion as well, so any rebuttal argument from the state?
Your Honor, all three reports are clear that the reason why the compulsion, if you look at Dr. Calder's, is probably the best. He says in prong 2 that she's minimally aware of what she's doing is illegal, but then talked about, I asked him this, she was compelled to do this. She was compelled to do it by the belief that Slender Man was going to become a danger to herself or her family. And we know from the evidence she didn't believe that at the time of the crime. She didn't come to that opinion until after the crime was over. So it could not have formed that compulsion. Dr. Calder went into great detail about how you needed a compulsion. Not just a delusion, you needed a compulsion. The compulsion did not exist at the time of the crime. That's all I have.
All right, thank you. Well, these are both motions to direct a verdict at the close of all evidence, and so the court looks then to determine whether there's sufficient evidence on either side. There's two motions pending for a reasonable jury to reach a verdict that supports either of the two positions in the case. In this court's analysis, I look first to, there's two instructions jury instructions that set what the law is and assist the court, are instructive to the court in deciding a motion such as this. The first is instruction 605, and that's on the substantive issue of not guilty by reason of mental disease or defect. In the instruction, it sets forth the two questions that are critical. Question 1, at the time the crime was committed, did the defendant, Anissa Weier, have a mental disease or defect? There's testimony on that. The second question is that you only answer if you've answered yes to the first question is, as a result of the mental disease or defect, did the defendant, Anissa Weier, lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? Now, there's evidence that's in testimony that's been received on that as well. In some respects, the issue centers substantially on how the jury perceives the opinions rendered by the three doctors that testified. They're experts. I'm satisfied they're experts in their field, and they're certainly qualified to render the opinions that they do. However, there's another instruction that plays a role in how the court looks at a situation such as this. And I refer to the instruction because they're solid, accurate, correct statements of what the law is. And that's instruction 640 that addresses expert opinion. The arguments of both sides of the state as well as Ms. Weier address factual situations that have been pretty well litigated and set forth during their testimony. And in some respects, although there may be a disagreement about what Ms. Weier said and what impact it has, generally the circumstances are fairly well known. It's the expert opinions that come in, and that are opinions. The court has to recall that and consider that. But the instruction says the following, and this is a correct statement of the law in Wisconsin. The opinion evidence was received to help you reach a conclusion. You are not bound by any expert's opinion. So although the experts may have all testified in one way and all had a basis for their opinions, the jury doesn't have to rely on any expert. The jury could disallow the expert testimony totally. They could do it on all questions or any one of the questions, depending how they process the case. So when I put those two together, the questions that the jury answers, the type of evidence that came in, I'm satisfied that a reasonable jury could reach a verdict for either of the parties, either for the state or for Ms. Weier. It's a matter of how they perceive the evidence, how they analyze it, and they evaluate it. When I address the issues raised by each of these motions with the facts as I've outlined them briefly, as well as the law as I've outlined it, I'm satisfied that I deny each of the motions. It's a jury case. The jury is in the best position to decide it based upon the instructions that the court will give to the jury tomorrow. So I'll deny both of the motions. So ordered. Then, just to move on a bit, the instructions, we made some modifications, typographical modifications to the instructions based upon our jury instruction conference this morning. We should have distributed those out to everyone. There was instruction 158, and then I corrected the word institution in 605. So from what was said earlier today, the instructions with those modifications and are without objection from either of the parties. Parties reviewed the proposed verdict. There was no objection to the verdict. We'll, unless there's some objection now, we'll proceed based upon those instructions and verdict tomorrow morning. On the issue of alternate jurors, during the break I did some further research just to be sure we were all on the same page with regard to how the alternates are used. And I passed out two cases. One is State versus Avery is a Court of Appeals decision, and it's a 2011 WIST App 124. Then all the way State versus Lehman, Lehman, State Supreme Court decision at 108 Wisconsin 2nd 281. Both of those cases address the issue of alternate jurors in a criminal setting. 972.10 sub 7 is a statute addressing alternates in a criminal setting. 805, section 805.08 sub 2 is a statute that addresses alternate jurors in a civil case. Now the case goes forward in many ways like a civil case. It still arises out of a criminal prosecution. So I haven't found anything that says what the answer is exactly to the questions that may arise as a result of the alternates. In my view, in reading the decisions, the court decisions, and the statutes, is that in a criminal case, the Avery decision clearly says that the alternates can be substituted in if the defendant clearly consents to that occurring. That's what happened in Avery. In the civil aspect of the case, it's 805.08 sub 2. The statute was amended. It calls almost precisely for the substitution of jurors by alternates. And in the comments to the statutes, the Judicial Council comments, it says that that's permissible to do. The initial law, or the statute in the criminal case, or the criminal law 972.10 sub 7, says you can't, that once the jury's picked, the alternates are taken off, then they're discharged and they go home. The case law permits you to do the substitutions. I'm thinking the reasonable approach is that that a reasonable approach, and what we talked about this morning, is to pick the four alternates, hold the alternates back in a separate location, and at tomorrow morning or when necessary, have Ms. Weier consult with her attorneys and determine her consent to the process of substitution. I think I would do that only if there is a need to substitute a juror. And at that point, we pick the I would suggest we pick the alternate to be substituted if that happens by lot, again, at a random selection process. But I gave you the cases, perhaps you've read them already, but I thought if you wanted to, you'd read them over the evening if you'd like, to be sure we're all on the same page. Layman is a shorter case. In Avery, the key paragraphs are 51 through 67. And Avery is the most recent statement on it. It's 2011, and there hasn't been any other litigation since then. So I'm thinking that Avery on the criminal side is a clear statement of the law. So I'll ask for comment from the attorneys. I'll ask from Ms. Weier's attorneys. Any thoughts at this point, or would you like to review the matter tomorrow?
Our initial thoughts are we'd like the court's idea of holding the alternates and having them available if something does happen. We'll discuss that again tonight, and we'll let the court know for sure tomorrow morning our position on that.
All right, thank you. Then from the state, what's the state's view?
State agrees.
All right. Agrees with the defense or agrees with my statement?
I think they're both the same, so I agree with the concept of holding the alternates back, Judge, and keeping them available.
All right, and then if you have any issues on how we do it, we can discuss it tomorrow morning.
Yes.
All right, well, very good then. With that, we discussed the timing issue. I know the timing issue is earlier than I anticipated, but it will give everyone a chance to be fully prepared and to present vigorous arguments for the jury, and the jury will be well rested and be able to vigorously pursue the deliberations in the case. With that then, if there's nothing else, we'll recess for the evening. We'll be back here at 8:30. So that's so ordered. We'll be in recess. From that standpoint, I will order that Ms. Weier return to her residence unless her attorneys want to meet with her again.
If we could meet with her for a period of time, Your Honor, she had questions about the purpose of the motion and discussion about what tomorrow holds.
All right, well, it's 10 minutes to 3. I'll order that she be transferred to the juvenile facility to meet with attorneys and family members if that's available, and then return at 4 o'clock, leave at 4 o'clock for West Bend.
Thank you.
So ordered.
All right, so that concludes testimony. Both sides have rested. Of course, the directed verdict was denied. So now we're going to get into jury instructions, which are only 11 minutes long, which is not bad. And then we're going to get to closings. And what's really interesting was this whole jury deliberation. I can't wait to see because I was just reading a report on that, an article on that. So we'll talk about that when we get to it. All right, welcome back, Mallory. So what would you guys vote? Would you vote not guilty reason of insanity, mental defect, or would you guilty with no mental defect? Well, we'll have to hear what the jury instructions are for sure. I guess I went a little quick on what was on the table for them. So let's hear what the actual jury instructions are. All right. Jury instructions coming up.
I'll call it. Case of State of Wisconsin versus Anissa Weier, same appearances as previously noted. I note the jury is back in the jury box, prepared to proceed. So good morning to everybody. We'll begin with the jury instructions. Then the attorneys will make their closing arguments to the jury. After the closing arguments, we'll select the alternates. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be,
You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only evidence received during this trial and the law is given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. Evidence is first the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested certain information might be true, ignore the suggestion and do not consider it as evidence. Lawyers for each side have the right and duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Recordings are proper evidence and you may consider them just as any other evidence. Some parts may be hard to understand. You may consider the actions of a person, facial expressions, and lip movements that you can observe on recordings to help you to determine what actually was said and who said it. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice if any has been shown, possible motives for falsifying testimony, all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. You have just heard testimony about the defendant's mental condition at the time of the offense. You will now be asked to determine whether the defendant is not criminally responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. One, at the time the crime was committed, did the defendant, Anissa Weier, have a mental disease or defect? Two, as a result of the mental disease or defect, did the defendant, Anissa Weier, lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? You would be asked to answer the second question only if you answer the first question yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence. The answer to the question should be yes. Evidence has greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. The first question is, at the time the crime was committed, did the defendant have a mental disease or defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because of the unnaturalness or the enormity of the act, or because a motive for the act may be lacking. Temporary passion or frenzy, prompted by revenge, hatred, jealousy, envy, or the like, does not constitute a mental disease or defect. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? If you answer both of these questions yes, the defendant will be found to be not criminally responsible for the offense. And in lieu of a criminal sentence or probation, the defendant will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or others if released under conditions ordered by the court. In deciding whether the defendant is criminally responsible, you are to consider only the issue of the defendant's mental condition at the time the offense was committed. Ordinarily, a witness may testify only about facts. Then, however, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the expert, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. The following verdict with two questions will be submitted to you. I'm going to have Ken distribute to you a copy of the verdict form so that you'll understand what the nature of the verdict is, and you can retain those during the argument.
The following verdict with 2 questions will be submitted to you for your consideration concerning the defendant, Anissa Weier. First question. At the time the crime was committed, did the defendant, Anissa Weier, have a mental disease or defect? If you answer yes to question 1, then answer second question. As a result of the mental disease or defect, did the defendant, Anissa Weier, lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? We're now at that stage of closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. We'll now begin the closing arguments.
All right, Missy, thanks for joining us. Have a wonderful rest of your evening and a fantastic weekend as well. All right, so here's the, and thank you for joining us. Here's the jury form. So at the time the crime was committed, did the defendant have a mental disease or defect? If you answered yes, then you go on to, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? All right. So there is the said jury form. All right. All right, so now we are going to, okay, so that was the jury instructions. Now we're going to get to closings. So the defense goes first because it's their burden. So defense goes first. And something really, really interesting happens while they're deliberating. I didn't realize this. I just did some quick research and then read it, and then I found what do you call it? A video for it. So I'm so glad that I saw that in that news article. I would have never known. We would have skipped that. Sorry. All right.
Weier said, "Don't be afraid, I'm only a little kitty cat." Go ballistic, go crazy.
That is the Anissa Weier we are talking about, a 12-year-old child shivering in an interview room with a trained detective. Not the young lady that sits in court today. Those shades of that child you heard yesterday still remain within her, needing help. While Anissa couldn't stab Payton, in her broken mind she knew it had to be done. To prove to the unbelievers, to prove she wasn't crazy, and to protect her family from the tall, tentacled figure she and Morgan had seen in the woods near their homes while they were on the bus, in the woods near their friends, and in the woods near their families. She knew that there was danger, and she knew this because, as she told Trissani, the wiki told me. Over and over again, that's what the internet told me. That's what the wiki told me. The wiki, as if the wiki was a person telling her what there was. It doesn't matter what or when Morgan told her about the deal she made with their personal devil, Slender Man. The wiki had already told her that he could read her mind, that he was always watching, that he could be anywhere in the blink of an eye, that he stalked, stole, and strangled children and their families.
8 to 14 feet tall. He's, like I said, a tall guy who constantly wears a suit with a red tie. He doesn't have a face. His skin is white. And at his own will, he can exploit these tendrils from his back and strangle his victims. From what the creepypasta wiki said, he targets children most. Okay. So I was really scared, knowing that Slender could easily kill my whole family and 3 seconds.
As Detective Trusani said, wow, this sounds crazy. Because it is. This belief was the product of a mental illness, a shared delusional disorder grown between two troubled children whose loose ties to reality had been undone by fake news on the World Wide Web. Together, they drifted deeper and deeper into this belief until, sucked down by the whirlpool of the web, their unformed minds, and their mental health disorders, it eliminated their ability to control their own behavior, to see the strangeness and the wrongfulness of what they believed. You've heard from 3 different doctors that Anissa was suffering from a shared delusional disorder, and that while rare, a shared delusional disorder is a recognized mental health disorder contained in both the Diagnostic Statistical Manual 5, which is current, and the Diagnostic Statistical Manual 4TR. No wonder they call it the DSM. It's been recognized, diagnosed, and talked about since the 1800s when it was described by the French term folie à deux, the madness of two. It develops between 2 or more people involved in a very close relationship, one having a psychotic disorder, and the other eventually developing delusions consistent with the more ill individual. We know Morgan Geyser is schizophrenic, has schizophrenia, one of the most terrible and difficult psychotic disorders known to our society, one that in Middle Ages would have labeled her a witch and burnt at the stake. But we're not in the Middle Ages anymore. We do not treat sick children that way. Morgan's delusions were shared with Anissa over time and grew and grew during their close relationship. Anissa told Trusani and the doctors that she saw Morgan as a sister, and she clung to her for dear life. These 2 children, very alone in the new school that they were starting in, found each other, found shared interests, and those shared interests fueled the fire in Morgan's mind and spread to Anissa. They had time together on the bus, 40 minutes each morning, 40 minutes in the afternoon. They lived in the same condo complex. They played in the park that poor Bill Weier could see from the door of his home, not knowing what was happening. But there's another place where they met, and where many of our children meet. On the internet. With emails exchanged back and forth, as Detective Casey said, at every hour of the day and night. Just because a child is not physically present with another child doesn't mean they are not in communication. It may not be the Vulcan mind control that Morgan Geyser spoke of, but it's an almost instantaneous connection between young people that is beyond, oftentimes, the sight of their parents and their teachers. Morgan's outreach about Jeff the Killer and letting go of logic and accepting Slender Man and Jeff the Killer and this creepypasta wiki as real tells of the development of this disorder in Anissa. Payton's observations of Anissa when she was with Morgan and when she was not also speak about what was happening, as did the report of K.N. on his friend from Flight Academy, who came in and told the terrible secret that she heard. The terrible secret that Anissa was planning on becoming a proxy and needing to kill a friend. Not you, don't worry. But she was worried. And she did what any child would do. She reached out to an adult who said what adults do when children say things that frighten us. Just a kid. Quirky. A joke. Not serious. K.N.'s sister, S.N., heard the conversation between Mom and K.N. and went to her counselor,
She sees a counselor several times a week at school because of her own issues. She told her this scared her it might be a joke. There were warnings, there were signs, and as adults we whistle past the graveyard because we don't want to see that a child is sick. We want it to be a phase. We want to look away. We don't want to see it because it frightens us too. Because we can't protect them at that point. We can if we react, if we step in, but so often we don't. A parent doesn't want to see it. A teacher doesn't want to tell. It's hard and it's hidden, but we need to be more open about mental illness in our society. We wouldn't be here if we were. You've heard from the 3 different doctors that Anissa was suffering from a shared delusional disorder. You've heard that this isn't just about her being a child, that this isn't just about her having been lonely. This wasn't just a lonely girl giving into peer pressure, but a delusion strong enough to kill for. Many children have someone they can turn to when dark images and dark thoughts disturb them, someone who can help guide them through. Payton was a perfect example of that. She turned to her mom, and her mom was able to sit down and surf the web with her and show her this isn't true. Don't worry. Nobody's coming in your window to kill you. But Payton was 12. She still locked her window, slept far away from it, just in case. Anissa's family was not at a point where they could be that resource for her. You've heard about the pain and the emotional bombshells that had hit that home over and over and over again in the 2 years before this occurred. Anissa's father and mother separating and then divorcing, something that disturbed her enough at school that she sought out help in a support group. Mr. Weier's understanding was that she had sought it out herself because she was in pain. Not only were her parents suffering through this divorce, dealing with the stress and the pain, that even parents who try very hard to keep it away from the children, you can't hide it from them. They know you. They feel the pain. They see the separation. And their pain is there too. But they can't show it because you're hurting. Anissa's older brother and sister were hurting too. Not because of the divorce between their father and his second wife, but because their mother was suffering the last stages of a terrible illness that had plagued her since she was in high school. She was told you won't make it till you'll be lucky if you make it to 40. Well, 1 week short of her 41st birthday, she succumbed. Annie's older sister had actually skipped out of school. Mr. Weier told you about that. Contrary to his wishes, she skipped school so she could care for her mother in her last illness, and who could blame a teenager for that? And then that pain and that loss is present in Annie's world. In addition to the loss of her nuclear family, her brother and sister are suffering a pain that she can't help. Her father pleads with the younger ones, you have to help them, you have to make sure they feel comfortable, that they're okay. How can she tell? How can she reach out to them that are hurting so much that she's in pain too, that she's lost too? Instead, Annie, when she was at Prairie, reached out to an adult. You heard Mr. Haynes when he came in here. She spent her lunch hours and her recesses talking to him, crying, talking about problems with children, talking about her life. But once she got to Horning, he wasn't there. And Mr. Taggy, clearly, based on the tears at the end of his testimony, clearly cared about this child, but he hadn't had the years-long relationship. He didn't have the connection to Anissa, so this wasn't someone she could reach out to about something other than math problems. And so, all adult ties are missing for her. And she tried. Always the quiet girl, always the good girl, who worked hard, got good grades. The girl who wanted to learn to dance, but when her father told her he couldn't afford to send her to the dance classes, what did she do? She turned to the internet, to YouTube, and practiced dance moves alone in her room, just as she had on her own sought out the depression group at school. She tried to help herself. And as the sadness and darkness within the home grew deeper, and in Anissa grew deeper, she turned further for comfort to the web, to Morgan, and so to Slender Man. Even without an expert, all the evidence tells you this was madness, that this girl could not understand what was going on with her, what was wrong, nor could she stop it. Then when you think of the events of the day, the plan, the description of it as it morphed throughout the day, this meticulous plan that had been crafted over somewhere between 4 and 6 months. We'll use duct tape to close her mouth when she's sleeping. The only duct tape was what Payton brought as a present. Oh no, let's not do it now, we're sleepy. But they still had to do it. Let's try in the bathroom. You heard Dr. Westendorf talk about the incidents in the bathroom and how, again, it was conditioned on getting Payton to go to sleep, because that way you wouldn't see yourselves in her eyes. And the final incident in the woods where Payton was stabbed. Horrible, yes. Meticulous? No. Madness? Yes. Again, when you think of that day and the intense planning that we've all heard about through prior reports, you think of what they took with them. A purse, 2 water bottles, kudos, a peanut butter crunchy bar, and pictures of their families. Why did they take the pictures of their families? Because they truly believed they were never coming home. When you think of the testimony of Detective Casey when he was on the stand talking about the note that was found on Anissa's phone, that he saw as a suicide note when he read it, that's really what it was. She was leaving her family, leaving everything she had to them, wanted them to remember her as she was. She was going to a place in her mind that was dark and dangerous, a place where they needed protection against the other people who would be there. The only protection from Slender Man was, as the list you saw in Morgan's science notebook said, run like hell. They knew that this creature was out there. They believed him to be a danger to themselves, and that's why they had their defenses list. And they believed him to be a danger to any child that was out there and their family. Again, this is delusional, and they acted on the delusion. The difference between a simple delusion and a delusional disorder is that the delusional disorder compels you to act upon it. And it's clear they were compelled to act. To harm a friend, to kill a friend, and to walk all the way to the Nicolay Forest. Years later, when speaking with a doctor, Anissa defined it as about 4,000 miles. We know when she spoke with Trasani, she said she knew it was a long, long way, and that she'd done an internet search that showed it was 200-some miles and would take 2.5 days to get there. A 12-year-old child sitting in the interview room knows it's a long way, doesn't know what the number is. 15-year-old child talking to a doctor doesn't either. The 3 doctors who evaluated Anissa to assess her mental responsibility each brought different experience and evaluation tools to bear in this analysis. Dr. Caldwell, with years of experience evaluating and treating violent youth, brought internationally to teach other countries how to take care of their children. Does objective tests, studied tests, to determine a good objective viewpoint of the 12-year-old child who sat before him. She was smart. You can be mentally ill and smart. She was smart. She had a processing delay that made understanding complex information difficult. That fits in well with Ms. Reinder's description of how hard she worked, but how she had difficulty decoding, I believe was the phrase she used, accessing information within things that she read. It also fits with Mr. Tagi's description of the extra time Anissa took in processing redirection. Unlike other children, she would have to sit, her face would go blank, stew on it, and then do what had been asked of her. Dr. Caldwell also saw diagnosable mental illnesses, depression, an underlying schizotypal disorder, which left her vulnerable to delusional beliefs and the developed delusional disorder. And keep in mind, Dr. Caldwell saw her a month and a few days after her arrest. Saw her at the West Bend Detention Center. All the doctors, I think, were clear that they saw her at the detention center. Mr. Zapakowitz even asked, that's where you saw her. So they saw her while she was being... They saw her, Caldwell saw her in 2014 there. Westendorf and Ben Rybrook saw her in 2016 there, and Caldwell and Ben Rybrook saw her in 2017 in the West Bend Secure Detention Facility. Dr. Caldwell brought the experience of using actuarial instruments to talk about cancer. Dr. Westendorf, who's worked in prisons and detention centers and mental health facilities, has a practice that is now specializing in looking at the effect of technology on our children, which I think we all can agree played a role here. Dr. Van Rybrook, the director of Mendota Mental Health Institute and a UW-Madison professor who teaches not just psychologists, but who teaches lawyers what the meaning of not guilty by reason of mental disease or defect is. Also familiar with adolescent brain development. Dr. Van Rybrook and Dr. Westendorf were appointed by Judge Foran to take a look at Anissa and determine her mental responsibility. Both are duly trained as doctor and lawyer. Van Rybrook's familiarity with the development of a child's brain led him to describe how the early stages of adolescent development when Anissa was 12 years old created a whirlpool of impulsive judgments, swirling her deeper and deeper into the delusion, not allowing her to withdraw from its hold. Dr. Westendorf noted that as the internet searches for proof increased, so with the information the web would vomit back into their feeds, further evidence that fueled their delusions. All three experts had access to the police reports and the full recorded statements of the girls, both Morgan and Anissa. They had the reports generated about Anissa regarding her competence early in the proceedings, whether or not she could understand legal process, and the reverse waiver reports. The state asked about that. The doctors, they had access to that, and that information about Morgan as well, to give them the full picture of what was going on with these children. All three interviewed Anissa, and all three, independent of each other, found the same disorder, a delusional disorder. Found that this behavior was driven by mental illness, and all three agreed that the delusional disorder kept her from being able to conform her conduct to the requirements of law. Dr. Caldwell, who saw Ani a month and a few days after her arrest, also found that while she might have understood it was illegal, her need to protect others was so strong she could not understand the action was wrongful. Dr. Van Rybrook and Westendorf felt she couldn't conform her conduct, in part because she saw herself as serving a greater good, the protection of her family. And I think when you look at those conclusions, that factors in not just all of the information they received about Anissa and Morgan, but the fact that, as you heard Dr. Caldwell and Dr. Van Rybrook testify, they went to the websites that these girls looked at. They looked and saw the proof that Anissa and Morgan had relied upon. Dr. Caldwell referred to it as being the same sort of information that when he's looking at reports, when he's trying to create a report, the same sort of information that he would expect to look at. Police reports, doctor's reports, witness accounts. All of these fake news floating out there on the web. If we as adults can't figure out what's true when we look at the web, how much harder for a mentally ill child? You all know this is an unusual case. You've been asked not to determine what happened because Anissa told Trasani what happened. And she entered a plea in front of Judge Boren in the first phase of this case. Now, you've been asked to come here and determine why Anissa did this, and based on that, what we as a people think should happen to her. The jury instructions that the judge just had up on the screen tell you that I must show you to a reasonable certainty by the greater weight of the credible evidence that on May 31st, 2014, Anissa Weier had a mental disease or defect, and that because of that mental disease or defect, she either lacked substantial capacity to understand the wrongfulness of her conduct or to conform her conduct to the requirements of law. And yes, I am reading that off a paper because, like the full diagnosis that Dr. Westendorf gave for Anissa, I can't just spit that out. If I'm trying to think about what reasonable certainty means, though, I look at it in a medical context. If I went to a doctor and he ran tests and he told me I had cancer, I might want a second opinion. In fact, I would want a second opinion, and I'd want to hear that that was wrong. But if I went and got the second opinion, and that doctor said, no, you got it, he's right, I think I would understand that I needed to start treatment. But if I didn't, and I sought another evaluation, and that third evaluation told me, yes, you have cancer, I would hope I would have the common sense to be reasonably certain that I'd best start dealing with it. You have 3 doctors, well qualified by both education and experience, to make this opinion, and that's what they've told you, looking at everything, not just what the police looked at, but also looking at the information on the web to understand where these children's minds were at. We know the police had access to that. You saw the list of websites, the list of links that Detective Casey had Detective Carpenter pull up for him. Both of them admitted that wasn't all that was there, but that's what they bookmarked, but didn't go to. The doctors did look at that and factored that into their analysis. Evidence has the greater weight when it has more convincing power than the evidence opposed to it. That kind of makes sense. As long as it's evidence that fits with reason and common sense, it tells you it's worth believing. In this case, the only evidence you have is that Anissa Weier meets the standard to be found not criminally responsible by reason of mental disease or defect. 3 doctors have diagnosed her with a mental disease or defect, a delusional disorder. They explained that the delusion was so strong, it prevented Anissa from conforming her conduct to the requirements of law. Dr. Caldwell, who saw her less than 2 months after the offense, also believed that while she knew it was illegal, in the bigger scheme of things, she did not understand the wrongfulness of it. The doctors came to these conclusions after reviewing all the information, including the entirety of the recorded statements. And again, as I said, perhaps most importantly, they also looked at what was feeding into these children's head while they were learning about Slender Man, about creepypasta, about life at Slender Mansion, in the Nicolay forest that they were walking to that. They knew what was said by both girls. They knew from the police report, and I believe Dr. Van Rybrook, or it might have been Caldwell, saw also the statement of Payton. They had all of that evidence. They're not confused about it. They looked at the whole picture. Their conclusions are based on all that was a part of this offense, seen through the eyes of training and experience in evaluating children. The fact that the state doesn't like their conclusions isn't evidence. The state doesn't agree with them, but that isn't evidence. There is a natural tendency when a child is hurt, as Payton was, to want vengeance. But vengeance isn't justice, and we are here as a part of the justice system. Vengeance is an appeal to passion and prejudice, an appeal to ignore the facts and the law. The state is asking you to do that. And the judge has told you, you cannot do that. You must apply the law and the facts as you've heard them in this room. Vengeance is understandable desire here, but justice is what we as a society have decided is the right thing. Justice balances the needs of all to come to a result that as a people we have decided is good and right. That's why we have a law that says when someone commits a crime because they have an illness that makes them unable to either stop themselves from doing the wrong thing or even understanding that the thing is wrong, that we commit them and place them in an institution for treatment. Judge Boren has told you that you have a choice to either convict and criminally punish or confine to an appropriate institution. There is no walking away for Anissa. There is no loophole that she gets out of. There is a consequence. There has been for the past 3 years. And it will continue one way or the other. But it is your choice which is the right consequence. And the evidence has shown you that the right thing is to find her not criminally responsible and commit her to an institution. Thank you.
All right, so that was the defense closing. So now let's get to state closing. Remember, they don't have any burden. State doesn't have any burden whatsoever.
Good morning. Thank you also. You've taken a week out of your lives. As Mr. Osborne said in his opening, that's what makes the jury system work, and we truly appreciate it. Thank you. Ms. McMahon, kind of at the close of her argument, used a word, vengeance. The state is not prosecuting Anissa Weier for vengeance. No one is here looking for vengeance. What this is really all about is the truth. That's what we're looking for. Ms. McMahon, in her opening few remarks, stated that this had to be done. Anissa knew there was danger. And when Morgan told her about, well, Slender Man might get us or our families, it doesn't really matter. Yes, it does. It absolutely matters. Mr. Smith told you in his opening statement, Anissa could not conform her conduct to the requirements of the law because she needed to protect herself and her family from immediate and inescapable harm from Slender Man. They told you they would prove to you that that was the case. The only problem is it's not true. There is no evidence to show that it's true. She did not believe it at the time they tried to kill Payton.
So I think it's not just what I didn't know I was willing to
The silly thing about this was, I didn't know I was in danger until after Morgan stabbed Payton. The whole defense here is premised upon the fact that they had to kill Payton or Slender Man would kill them or their families. It was kill or be killed. It's just not true. The silly thing about this was, I didn't know I was in danger until after Morgan stabbed Payton. That's what she told Detective Trussoni within hours of this offense happening. Detective Trussoni told you that Anissa was very calm and composed during the interview. She told Detective Trussoni she wanted to prove the skeptics wrong. Not we were in danger, not that Slender Man was going to kill me, not that Slender Man was going to kill my family. She told you that Anissa told her that in December or January, Morgan said, "Hey, Anissa, we should be proxies." And Anissa said, "Okay, how?" "Well, we have to kill Payton." Anissa said she was surprised by that, but also excited. Let's look at some of the things that she told Dr. Westendorf about this. She told Dr. Westendorf that in October of 2013, she was desperate for a friend. And I don't agree with any of the things that Ms. McMahon told you about Anissa's home life and parents' divorce and how that affected her. But it's the relationship that grew out of that with Morgan that played a large part in what happened here. She told Dr. Westendorf that she met Morgan. She clung to Morgan for dear life. Anissa was the one that introduced Morgan to creepypasta, but what she told Dr. Westendorf was that in February of 2014, Morgan told Anissa that they should become proxies, and they should kill Payton to become proxies. Anissa told Dr. Westendorf that she didn't want Morgan to feel crazy, so she said yeah. So at least when Morgan first tells Anissa this, she thinks it's crazy. But she doesn't want Morgan to feel that way. Anissa wanted Morgan to trust her. She didn't want to alienate Morgan. Anissa didn't think Morgan was serious. They wouldn't literally try to kill Payton. They began planning. Anissa told Dr. Westendorf it was exciting to talk about, like discovering something new. They spoke about these plans almost every day. There were times Anissa thought about calling it off, but they were too far in. Morgan was planning this whole thing out. Morgan was building this up. Anissa didn't want to pull the rug out from under her. She just followed Morgan because Morgan was doing most of the work. Said again, I didn't think we were going to try to kill her. Does this sound like a kill or be killed situation? That they killed Payton because Slender Man was going to kill them or their families? That's not what was going on. There's no evidence of it. You have the opportunity to review all of the doctor's reports if you want, and nowhere in Dr. Westendorf's report does Anissa tell Dr. Westendorf that this was kill or be killed. It's not in Dr. Westendorf's report. And I want to talk about what the doctors have said, because as Mr. Osborne told you in our opening statement, we do disagree with the doctors. We believe their conclusions are faulty because it's based on faulty information. We'll start with Dr. Caldwell because I think he did a really good job of explaining a delusion versus a delusional disorder. What he said was that what makes a delusional disorder is the compulsion element, feeling that you have to act. And he stated, and here, Anissa felt she had to kill Payton because of the threat to the life of her and her family. And it's this compulsion that led them to conclude that Anissa was not able to conform her conduct to the requirements of the law. Dr. Westendorf in her report uses the same terminology of compulsion. She says on page 24, they struggled psychologically with the internal conflict of intellectually understanding that their behavior was wrong, but feeling compelled to perform the alleged act for their own safety and the safety of their families. So it's this compulsion, this feeling that you have to act. And Dr. Van Rybrock talked about the same thing. He talked about how Anissa was painted into this terrible corner, and that the only reason she didn't comply was this need to protect herself and her family. It's not true. It's simply not true. The silly thing about this was, I didn't know I was in danger until after Morgan stabbed Payton. This is not kill or be killed. This is not, I have to act. This is, as Mr. Osborne stated in opening statement, a want. Ms. McMahon said she had to. It's not the case. It was a want. As I indicated, what they told you that they would prove here, and that they would make you reasonably certain of, was that Anissa believed she needed to protect herself and her family from immediate and irreparable harm from Slender Man. Is this immediate? Kill or be killed? Well, let's see. It started in December, January, February. I'm not exactly sure, but we have February. They didn't try to kill Payton in February. We have March. They didn't try to kill Payton in March. We have April. They didn't try to kill her in April. We have all of May, except the very last day, and they didn't try to kill her. We have May 31st. They go, actually May 30th, I'm sorry. They go to Morgan's after school. They don't try to kill her in the late afternoon. They go to Skateland. They don't try to kill her at Skateland. They come home. They don't kill her then. They go to bed. The plan is we're going to get up in the middle of the night and then we're going to kill her. But they don't do that. They wait till the next morning. The next morning, they don't kill her at Morgan's. They go to the park, play on the playground. They don't kill her there. They go in the bathroom. Don't try to kill her there. Finally, they go into the woods. We have this knife being passed back and forth. That's when it happens. Kill or be killed. Immediate and inescapable harm. It's not true. State's position is not based on vengeance. It's based on what's true. Ms. McMahon mentioned the statement to KN that Anissa made. KN's the only other person that Anissa told about what was going on. What did she tell KN? To become a proxy, we have to kill someone. Don't worry, it's not you. She never tells KN, I gotta kill Payton or Slender Man's gonna kill me or my family. Doesn't tell Payton or doesn't tell KN that this is kill or be killed. We want to become proxies. We learned from one of the teachers that Anissa was a tattletale at school, to some extent. If there was a problem, she had no problem standing up for herself, going to a teacher and saying, you know, these girls are giving me a hard time, or they're bothering me, or... You think if she truly believed then that Slender Man was going to kill her or her family, she wouldn't have told somebody? It didn't happen because she didn't believe it at that time. Let's look at what she told Lieutenant Moorman. Remember Lieutenant Moorman? He was the sheriff's deputy wearing the brown uniform. He took the stand and testified that he was the one that took Anissa into custody, and she was scared at the time. And the statement she made to him was, some people were going to kill my family unless I did something very bad. Well, she told Detective Trussoni that she had learned that from Morgan after the fact, when they were on this hike, this walk, this plan to go to the Nicolay Forest. During that walk, Morgan had said, oh, Anissa, by the way, I made a deal with Slender Man, and if we didn't do this, he was free to kill our families. That scared Anissa. Absolutely. Same way Morgan was trying to scare Payton, giving her emails about creepypasta stuff. That's when Anissa became scared. And it was because of that that she told Lieutenant Moorman, some people were going to kill my family unless I did something very bad. If she truly believed since December or January that Slender Man was going to kill her family, if that's what motivated her, then after they stabbed Payton, she had no reason to be afraid. They did what Slender Man was requiring. He wasn't going to kill him because they killed. She didn't know whether Payton was alive or not. There was no reason for her to make that statement to Lieutenant Moorman, because they had satisfied what Slender Man wanted them to do. There was no more reason for her to be scared. The reason she made that statement to Lieutenant Moorman is because it was after the fact that Morgan scared her. And it further shows that this was not done out of some fear that Slender Man would kill her or her family. You also need to take a look at how cold and calculated this plan was, especially on the morning of May 31st. You heard Detective Fisher testify about what Payton, the victim, told her. They were playing quizzes that morning at Morgan's house, and Anissa quizzed her. What if someone came up to you and started to try and stab you? This was preparation. This was planning. This was an effort on Anissa's part to find out how's Payton going to react when we start to stab her. This is cold, calculated planning at that time. This is not somebody who at that time can't comply with the requirements of the law. Please don't forget in all of this that this was a brutal crime. Payton was stabbed at Anissa's direction 19 times. She was in the hospital for days. As she stated, I could have died. Anissa, after the stabbing, led her deeper into the woods so she would die. Payton said, I'm pretty sure they wanted me to stop moving around and talking so people wouldn't find me. They left her there even though their houses were only a few blocks away. Payton got out of the woods only to collapse on the grass. She couldn't move, she couldn't breathe, she couldn't see. Anissa ran away because she wanted to prove the skeptics wrong. They wanted to become proxies, but Anissa wanted to keep her friendship with Morgan. Again, this really, if you boil this whole thing down, it's very simple. It comes down to, did she have to or did she want to? If you find she had to, if she really believed Slender Man was going to kill her or her family, well, then maybe she couldn't comply with the requirements of the law. But this wasn't a had to. This wasn't a kill or be killed. The silly thing about this was, I didn't immediately know I was in danger until after Morgan stabbed Payton. That's what she told Detective Trussoni. That's the truth. It was not kill or be killed. It was a want. And because it was a want, she could comply with the requirements of the law. It was a choice. A want is a choice. And it was a choice that she needs to be held criminally responsible for. The defense has not proven in this case that this was done at the time because she couldn't comply with the requirements of the law. There's no way you can be reasonably certain about that based on this evidence in this case, despite the fact that 3 doctors testified and gave their opinion that she couldn't comply. Their opinions, again, are based on their belief that this was a compulsion. And it's just not true. Thank you.
All right. Yeah, no, Payton did not testify. Well, we watched all of Morgan's, and now we've seen Anissa's, and Payton did not testify. She didn't want anything to do with this, as far as I can see. She wanted to be far away from this, put this in her rearview mirror, leave these girls in the dust. All right, so now we're going to get to defense rebuttal. You almost got me there, Richard. That was the state. Now we're going to the defense again. So this is the defense rebuttal. Hi, Paulie. What's up? What's up, kiddo? You want to say something to the crowd? Want to say something to chat? Nope. Hi. Okay.
It's what they call rebuttal. And If I seem stilted in it, please excuse me. Normally, they get rebuttal, but because I have the burden of proof, I get the last word, which I think a lot of people would tell you I like. And I do. Anissa Weier believed that she could become a proxy of Slender Man, an internet demon that existed. In her mind, he existed. She became, over a period of about 6 months, convinced that he existed through her close relationship with poor Morgan Geyser. You saw that child, Morgan, singing in the room with Detective Casey. He seemed to think she was lying to him. I think my eyes tell me something else. Just as the recounts of her at school, playing with blood on her desk, being told to clean it up because she might be stigmatized, chasing children, barking on the playground, playing with Voldemort and Snape on the playground. The children all came and said to the teachers, "This is happening. Something's wrong." And the adults all said, "Quirky. Wants attention." Anissa wanted friends. Do you think that the choice to remain with Morgan helped her in that quest? We know from her teachers that other children kind of liked her. She had a few friends in Flight Academy, and with those friends she also shared her interest in creepypasta, none of which got shared with the teachers by any of the students, because kids don't talk about those things. And people who are in a shared delusion don't share with outsiders. It's like the old Brad Pitt movie, Fight Club. It's the first rule of Fight Club. You don't talk about Fight Club. When you are in the control of an internet demon who can teleport and read your mind from wherever his eyeless face is, you don't tell people. Because what will happen? The internet, the wiki tells you what will happen. He will come. And you will die. All three doctors were asked if the fact that in her interview, Anissa said that Morgan told her about her deal with Slender Man after the offense changed their opinion. All three of them said no. This girl was under the control of a delusion that had developed between herself and Morgan. She was afraid to be crazy. She didn't want to be crazy. And she didn't want Morgan to be crazy. No one wants to be crazy. That makes sense. But a delusional system, to those who are not a part of it, doesn't make sense because it's crazy. Whether it's a pain in your toe that you believe the alien put there, the CIA monitoring your brainwaves, all of the different things you hear about over time, all of the different examples the different doctors gave of delusions. When you confront someone with a delusion with factual information that should pop the bubble of the delusion, the response is to believe that you are part of the conspiracy, or, I think in Anissa and Morgan's case, that you can't see the danger, that they have this special connection and you don't. And because of that special connection, you also create a risk for the people around you, because if you spill the beans, he will come. And they had both seen him. One of the most telling moments for me when Anissa is talking with Detective Trissani is where she says, I needed to prove he was real because I saw him. I saw him before and after the offense. This was a real being to this child, and she needed to protect those around her. Separating herself from her family was one of the most painful things she could do. She brought pictures along, as did Morgan, of their families because they thought they would never be able to see them again. She talked about asking Morgan, couldn't we wait another day, because she didn't want to leave her family, but she felt she had to. Because that special relationship, that connection, if you spill the beans, or if Morgan went ahead with the plan and went to Slender Mansion without you, would result in harm. And I know when in the statement Anissa said that to Detective Trusani, but we have a traumatized 12-year-old talking to a detective. Again, I don't think it matters when Morgan told her, but I don't know that her timeline is entirely accurate because she's 12. But to me, it doesn't matter because, as the doctor said, the delusional belief was in the existence of Slender Man, this demon who could teleport, who could read your mind, who would know if you told because he always watched. You saw the pictures from Morgan's locker and the always watches written in the back of Anissa's Spanish notebook, not quite to the last page where someone might look and not with her homework, but in the middle where no one would find it. He's always watching. And her friend is now always watching, and they're feeding into each other. And one of the things that I think tells you just how frightened and confused she was is if you look at the exhibit I've put on Exhibit 2. Detective Casey testified about this shortly before the party, May 23rd. Anissa hadn't turned in a choir assignment. She was in trouble. And her mom wasn't going to let her go to the party. What was Morgan's response? If your mother keeps you from coming, I will crawl in the window and add her to the list of bad people. What do you think that meant to Anissa? When you think of the emails that have been sent to Payton about how they would come through the window to get her, Anissa knew her family was in danger. Anissa knew she was in danger because her very thoughts could cause this demon to come. At 12 years old, she had no way to protect herself from this except to follow Morgan's advice. And they swirled down into madness together. The state asks you to ignore the 3 doctors because they don't like what they say. And I think in part they don't like what they say because it's frightening. We don't want to believe children are sick, and we don't want to believe we miss it. You have the opportunity to fix what was missed. The evidence, all of the evidence that came in tells you that Anissa Weier was suffering from a mental disease or defect, that the combination of her mental health issues, the schizotypal, the depression, and particularly the delusional disorder, combined with her young age, kept her from being able to do the right thing, kept her from being able to understand that this was wrong and led to this terrible event. When you look at the verdict form, all of the evidence tells you that she suffered from a mental disease or defect. And all of the evidence tells you that she could not conform her conduct to the requirements of law. And I believe when you look at the evaluations that were done of her by Dr. Caldwell, particularly because he saw her less than 2 months after this event, but she was still that 12-year-old child, I also believe that she could not understand the wrongfulness of this. Did she know it was illegal? Yeah, sure sounds like it. But there are things that are illegal that are maybe not wrong. Or there are things that are illegal that in the moment that you are dealing with are not wrong. I believe, given everything that had overwhelmed her broken mind, this child could not see the difference between right and wrong and was compelled to participate in this. The judge has given you the opportunity to place this child under commitment and to give him the authority to place her in an appropriate institution. She's been held for long enough. Let's place her where she belongs. Thank you.
Thank you, Attorney McMahon. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You are not to be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind, and as upright citizens to render a just and true verdict. If you answer yes to question 1, then answer question 2 of the verdict. Any consequence of your verdict are matters for the court alone to decide and must not affect your deliberations. Case law provides that the verdict must be agreed to by 5/6 or more of the jury. Any verdict returned by the jury shall be agreed to by at least 10 of the jurors. I ask you to try and be unanimous if you can. When you retire to the jury room, select one of your members to preside over your deliberations. That person's vote is entitled to no greater weight than the vote of any other juror. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. At the foot of the verdict, you will find a place provided where the dissenting jurors, if there be any, shall sign their names. Either the blank lines or the space below them may be used for that purpose. Now, we've used numbers, I've said signatures, so for your purposes, signatures are numbers. So instead of signing your given name, you'll use the juror identification number previously assigned to you. We're going to select the alternates in a minute, but at this point I want to swear the officers who will be in charge of securing the jury.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or speak to them yourself, except to ask whether they agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberation or the verdict they agreed upon? So help you God.
I do. All right, thank you. Now we'll select the alternate jurors. In complex trials at length that can last a period of days, it's been my practice to always select alternate jurors. In this case, we had four additional jurors. The law says this case shall be decided by a jury of 12. So we had 4 extra people that were brought in as jurors. We don't know who the alternates are. We will in a minute. Of course, I think everybody involved in the trial, any trial, but certainly this one, respect the time that you've all spent in hearing the case. And in some respects, then, the 4 alternates are deprived of the final ability to participate. In thinking about it, it's somewhat like having a book from the library on your Kindle, and then the time expires and you're almost done, but the book evaporates because it goes back to the library. That is the unfortunate circumstance of being the alternates. What we are doing, though, just due to we're going to select the 4 alternates. We're going to have those alternates stay here at the courthouse, though, in a separate jury room in the event there's a need for an alternate sometime during the deliberations. So we'll first, we'll first identify the alternates, and then those alternates will be released to follow the bailiff to the location that they'll be at. And then the other to 12, then will be released to go to the jury room to begin the deliberations. After you arrive at the jury room, for those that are deliberating, I will provide a set of instructions as well as the official verdict, which is blue-backed. The official verdict is the same as the one you have, with the exception that it's got a blue legal folder on it. Now, as I indicated when we selected the jurors, we use this bin to select the alternates. That's how we used to select jurors. Little pieces of paper with names were put in there. They'd be twirled, and then we'd pick the paper, read the name off, and they'd come out and have a seat to begin the process. In this manner, we have 16 numbered blocks of plastic tabs, each one with a number on, 1 through 16. There's 16 jurors. We've asked the jury clerk to run an ad to list the jurors at random, 1 through 16. So it's been a new computer run, a random run. We'll have the attorneys twirl, and we'll have the attorneys, one of the attorneys do the twirling, one will do the picking, and then one doing the picking, or they can alternate. We'll pick 4 blocks out. We'll correlate those numbers with the listing on the at random list, and we'll call those names off by the clerk. The clerk will then will have those 4 be released. I do it this way not so much for the drama, although it's sometimes interesting to watch, but because I want you to know, and I want the parties to know, that this is as random a process as we can do to select the alternates. So that being said, I'll ask one of the attorneys from each of the sides to come up, inspect. No hesitation. And verify we have 16 blocks, plastic blocks with numbers, and that the bin is empty. It looked well twirled. And you just read off the number.
Number 5.
Somebody has to pick another one. You can just pick them now. Pick them all.
Correct.
All right, so we have 5, 15, 2, and 6. Thank you to the attorney taking seated. Now, what I'll ask, as the numbers are called off, I'll ask you to stand, and then once standing, Ken, you'll take care of that issue. Okay, very good.
9902 4854 1881 10749.
I will thank you for serving as jurors. You'll be alternates then, and you'll follow Ken, and you'll stay here during the course of the trial until the jury reaches a verdict, and then we'll be brought in at that time as well, but it'll be for the jury verdict. So thank you, and we'll talk to you later. You are released. Okay, we have 12 jurors that are left at this point. The jury will be released and to begin the deliberations. Please stand. All right, thank you. Please be seated. From the standpoint of Ms. Weier, any objections to the manner in which the instructions were read?
No, Judge.
Thank you. From the state standpoint, any objection to the manner in which the instructions were read?
No.
All right, very good. Then we'll provide a set of the instructions and the verdict. All right, very good. Good. Then we have to talk about exhibits. What I'd like, one, we have to decide if there is a request for an exhibit, which exhibits go in. If there's determined that all exhibits go in, or whatever it has to be, but we have to go through it. Attorneys should consider that carefully so we can make that decision. Once we decide what are the available exhibits that should go in, then we have to decide if they ask for an exhibit, does only that exhibit go in, or do they all go in? Or do we send all of the exhibits in at the beginning? The issue over the CDs and the recordings, of course, those CDs will not go in. And in the event there's a request to have something played back, I'm going to add on the CDs. We rely upon the CD as being that testimony. So I can give you a few minutes to review that issue if you'd like, or if you'd want to even confer among yourselves how to address the issue of which exhibits are available going in. Can I see the official exhibits? What's it on? Oh, I'll look at it. With that being said, then, from Ms. Weier's standpoint, which exhibits did you make a decision from your standpoint which exhibit should go in?
We did, Your Honor. We would not have any objection to any of the exhibits being sent. However, we think F1, and I believe there's an F2, which was the follow-up.
Yes.
Unless they're requesting the DVDs, it doesn't make sense for that to go back. Or even if it is, it seems it sort of has our titles on it, so maybe we keep F1 and 2 out.
So you're stating then that from your standpoint, on Ms. Weier's side, that all of your exhibits would go in, or can go in, with the exception of exhibit E, F, F1, F2.
Well, Your Honor had indicated that you did not intend to just send the DVDs back.
Correct.
So, yeah, but if they do request the DVDs of the statements, I guess we'll, as you said, address it as a request for readback.
All right. Now I have, did the defense move in, or rather, did Ms. Weier move in exhibit AC? That's a report summary of Anissa's goodbye note and will.
Yes, I believe I did.
That was moved in. We don't have that listed as being moved in.
Your Honor, I guess.
That was the one on the
Summary of it?
Oh,
AC.
we did not use that.
All right, so AC.
We had a
although
typed
marked,
up
is not
version
been
from
used.
the
All right,
detective's
that's what I
report.
wanted to know. Okay, that's correct. All right. Now, before I'm going to ask from the state standpoint on your witnesses, or rather on your exhibits, any position on those?
Actually, I think the position that Ms. McMahon was the neutral position on all exhibits.
All right, so,
Correct.
okay, so all exhibits may go in with the exception of exhibit E, F, and then F1 and F2.
Yes, sir.
Yes.
All right, very good. Then, so that'll be the rule for this proceeding. Now, do we send the exhibits in without anybody asking for them? Do we wait for them to ask, and then if they ask for an exhibit, do they get just the exhibit or exhibits asked for, or when they do that, do they get everything? So let's first ask, should all exhibits go in now?
The state's normal position is that when requested, they should go back, and we've already addressed this. You don't have to call us in chambers, but if they don't want them, that there's no reason to send them back, but.
All right.
And that was our thought as well. If they ask for them, we should send, and even if they ask for just a specific exhibit, I believe we agreed that perhaps it would make sense to send all back at once.
So then the exhibits will be held here. The ones that go back will be held until they ask for exhibits. And if, correct?
Correct.
Any objection to that? And if they ask for an exhibit or exhibits, all go back.
Yes.
Yes.
All right, very good. That'll be our rules then. That's how we'll follow. Now, I urge the attorneys to look at the exhibits then that are going in, if asked for, to be sure they're in proper order and that they're properly here. I say that because I had one experience one time when I was a practicing lawyer. We missed something, and of course something went into the jury room that shouldn't have gone in. So I just be sure you look at it. Attorneys are responsible to be sure that the exhibits are properly marshaled together.
Okay.
Okay.
All right. Then if we will, if we have any questions, if they ask for exhibits, we'll let you know they asked, but we're just going to send them back. If they bring other questions to the court, we'll, I won't act on them until you've had a chance to come in the court and look at it. And if we have any other issues that come up, let us know where you're going to be. If you're here at the courthouse or if you're leaving, certainly be able to be back within 10 minutes of a call. So be sure we have your cell phones, or if you're staying here, your office extensions.
Will you have Ms. Weier wait at the juvenile center? Or
Well,
will you have her wait here?
I haven't thought about that. What's the transportation time?
That was our plan.
That is the plan. All right, that's what will happen. And she'll wait at the juvenile center then. And then be brought back. She has to be brought back, of course, for any questions that come up, any type of activity in the courtroom. Ms. Weier has an absolute right to be present.
And will her family be able to go there and visit with her?
I think that may be a little complex at this time, just from the standpoint of how things could operate. So I think at this point, I'll say no. We'll just have Ms. Weier over at the juvenile center at this point. With that, then, we'll be in recess. Court will be here. Thank you. It's a good case presented by all parties. Thank you for your professional approach.
Thank you,
and
sir.
good luck.
All right, so here's where it gets interesting. So the jury goes to deliberate, and I went to go check to see how long did the jury take to deliberate, right? Because we always ask, how long did it take? How long did they take? Well, guess what happens? I'm going to play it because I'm not going to explain it per se. So let's watch it in real time. Because they come back with a verdict, but something happens.
And thank you, and good evening. We have the jury has reached a verdict. We've been told that they had the verdict at 7:47 p.m. As previously noted, we're asking have the alternates who have been here for the process to come into court. We'll now bring the jury in. All right, thank you. Please be seated. We have the jury in the courtroom. I'll ask juror 4161 if you're the presiding juror.
Yes, sir.
Okay, and has the jury reached a verdict?
Yes, we have.
All right, thank you. Then I'd ask you to deliver the verdict to our bailiff. I have the verdict. It is with dissenting jurors. I'm going to provide the verdict to the clerk. Ask her to make copies of the verdict and provide it to the attorneys. There's an issue on the verdicts that I want to discuss with the attorneys. So for that, to be off the outside the presence of the jury. So I'm going to excuse the jurors.
All right.
The jurors are returned to their jury room, respective jury rooms. All right, thank you. Please be seated. Without, at this point, reading the verdict, I wanted to review with the attorneys the issues of the dissenting jurors. There's 2 dissenting jurors on each of the 2 questions, which leaves a verdict of 10 out of 12. The dissenting jurors, however, are different for each of the questions. One juror is the same dissenting juror on each question. Then there are 2 other dissenting jurors, one in each question. Now, that is a potential inconsistent verdict. However, my reading of the law indicates that although that's an inconsistency, that there are sufficient jurors with a consistent verdict to then have that be the verdict. I want the parties to be aware of that potential challenge. That's my reading of it. If you want to take a moment, this is all on a 5/6 verdict with 10 out of 12. There's potential for this to happen, and it's been a litigated issue. I copied one case, pertinent parts of the case, 163 Wisconsin 2nd, 439, Zentek, Zintek versus Perchik, Perchik, with the pertinent discussion in it. If you wish to take a moment to read this, I'll provide it for you to read it before we go further, and we'll be in recess for a few moments.
Certainly, sir.
All right. I determined at times we'd have a sidebar conference, and we have a way to administer that, but I thought this is a better way to address the issues. That's why I asked the jury to be excluded at this point. So we'll be in recess for about 5 minutes. I'll give you an opportunity to read the case. Doing that, I am concerned that with the inconsistency. So I'll look for suggestions.
Judge, I'm very concerned as well. I don't believe, under the circumstances here, a juror can vote no for question 1 and yes for question 2. I don't believe that's jurors following the law under the circumstances. I don't believe this can be a valid verdict. The Zentek case doesn't, in my opinion, really touch on this issue, given the separate defendants in that case, and I think the issues are just very different. Again, I don't think, given the mandates of the law here, that if you answer question 1 yes, then you answer question 2. If you've answered question 1 no, I don't see under any circumstance how you can then answer question 2 yes. That's completely inconsistent, and I don't believe that juror's vote should be counted as a yes to question 2, and that does not leave 10 yes votes to question 2.
Attorney McMahon?
Your Honor, I think actually that Zentek would apply. And, Your Honor, the jury instruction does not state that the jury instruction gives instruction to the entire jury, not to individual jurors. And if 10 people have found that my client is mentally ill, then the question for the jury becomes, was she able to conform her conduct? Or was she able to recognize the wrongfulness? I believe that the analysis of Zentek, that you need the requisite number of jurors for each question, is appropriate here. Again, jury instructions are not specific to each juror. It is to the jury as a whole.
I read Zentek to state on the matter of inconsistencies in this type of verdict that it must be the same 10 jurors on each of the questions. And what I'm concerned about as I analyze the vote is that it's not the same 10. And that to me is the inconsistency in the verdict. Zentech addresses that issue. There's another case cited in that. I think it's Montgomery, Easy versus Montgomery Ward, that goes into more detail about that issue. So that would make it would bring about the inconsistent verdict issue. There is when I reviewed our jury instructions, the part of the jury instruction that discusses the 5/6 verdict does not include the language contained in instruction 180, which I'll send down. There's maybe a situation where the court would be in a position to give 180 and 520. 520 is the Allen instruction.
Well, and again, Judge, for the record, my concern is one juror dissenting on question 1, but answering yes to question 2, because it clearly states that if you've answered question 1 yes, then you answer the following question. So a no vote to question 1 does not allow that juror to give any other type of answer but a dissent to question 2.
No, I believe that issue is addressed in, if not in Zantek, in the other case that I cited. That my view of the law is that if the same 10 within a package of questions, in Zantek case there was a civil liability case, 2 doctors, malpractice case. There was a dissenting juror in each, but different for each of the 2 doctors. There they found that wasn't an inconsistency because the same, for the liability questions for each defendant, there was the same dissenting juror. So I'm reading that analysis to mean that if there's the same 10 jurors on each question in a package, and I see this as a package, both questions 1 and 2 are necessary to decide the case, that inconsistency can be overcome because it's the same 10. If it is the same 10, my concern is that in this case it's not the same 10.
Well, and this is somewhat even different than Zintek because the questions here are such that you don't get to question 2. It's dependent upon your answer to question 1.
Correct. No, I understand that, and it's and you may be right. I haven't fully analyzed your argument, but I'm satisfied it's an inconsistent verdict. My suggestion to cure it is to give an opportunity for curing. Maybe it can't be cured. That's for the jury to decide. Is to provide them with the 180 instruction, which more clearly states the law on the 5/6 verdict, and to do read the 520, which asks them to go back and continue to deliberate. So any comments on that solution?
I have no objection to that solution, Judge, at this point.
Your Honor, we're maintaining our position that the jury instruction on not guilty by reason of mental disease or defect does not specify that a juror who dissented on 1 cannot vote on 2. The jurors, clearly there are 10 jurors who felt that there was a mental disease or disorder. And the question then for the jury is, looking at that, do you find that the person can either not conform their conduct or lack substantial capacity to appreciate the wrongfulness? It's not directed to each juror. It is directed to the jury as a whole.
Well, again, although I appreciate the state's position, I'm reading the law to require the same 10 on each question. And this is not the same 10.
I understand that, Your Honor, but I don't believe that that is required, because in mental disease or defect analysis in question 2, they don't require unanimity on what the jury finds there, just that it be found. You could have 5 that believe that the person couldn't conform their conduct, and 3 that believe they couldn't conform their conduct and they couldn't understand the wrongfulness, and a couple who just believe that they couldn't understand the wrongfulness. It doesn't require that.
I'm going to take a minute to review Zantac. Section 805.09 of the statute, sub 2, says a verdict agreed to by 5/6 of the jurors shall be the verdict of the jury. If more than one question must be answered to arrive at a verdict on the same claim, the same 5/6 of the jurors must agree on all questions. So the issue then, as presented by Attorney McMahon, is, does question 1 and 2 constitute, as I called it, a package or a claim? I'm satisfied in reading the statute and looking at the nature of the questions in this case that you can't have a completed verdict unless a jury responds to both questions 1 and 2, with the correct number. And we don't have that in this case. They have the opportunity to answer yes or no to both questions, and in order to have that yes or no be sustained, it has to be the same 10 on each question. So again, my proposal and my thought is that I will read 180 and instruct on 520, which is the Allen instruction, and they have the jury go back and continue based upon those additional items. So that'll be the order of the court, so ordered. With that being the case, we'll bring the jury in as well as the alternates so they hear the instructions.
All right.
All jurors are back in the jury room, or back in the courtroom. You may be seated. The alternates are as well. The court reviewed the verdict. The verdict wasn't read in court. However, I did discuss the answers and the dissenting jurors with the attorneys and determined that I should re-instruct you on a portion of the verdict and have you go back and deliberate further based upon all of the instructions, including the new instructions that I'll give you at this time. So with that, then the alternate jurors are here so they can hear the instructions as well. And then we'll have copies for the 12 jurors who will be returned to the jury room. With that being said, I have the packet of instructions that you came in with along with the verdict form to be returned to you. Agreement by 10 or more jurors is sufficient to become your verdict. Jurors have a duty to consult with one another and to deliberate for the purpose of reaching agreement. If you can do so consistently with your duty as a juror, at least the same 10 jurors should agree on all the answers. I ask you to be unanimous if you can. At the bottom of the verdict, you'll find a place provided where dissenting jurors, if there be any, will sign their names, in this case use your juror numbers, and state the answer or answers of the verdict with which you do not agree. Either the blank lines or the space below them may be used for that purpose. You jurors are competent to decide the disputed issues of fact in this case. You jurors are as competent to decide the disputed issues of fact in this case as the next jury that may be called to determine such issues. You are not going to be made to agree, nor are you going to be kept out until you do agree. It is your duty to make an honest and sincere attempt to arrive at a verdict. Jurors should not be obstinate, they should be open-minded. They should listen to the arguments of others and talk matters over freely and fairly, and make an honest effort to come to a conclusion on all of the issues presented to them. You will please retire again to the jury room. With that, then, we'll give you these additional instructions, plus as you have before, return the jury to the jury room for further deliberations, consistent with the instructions I've read to you. So, jury's excused.
All right.
All right. So that was really interesting. So what happened was you have to have 10 out of 12. You have to have, the law requires 10 and it has to be the same 10. So what happened was, here's the jury form again. So what happened was one juror said yes on question 1, but no on question 2. Hold on. So one juror says no to question 1 and yes on question 2. So you had 2 dissenting jurors on each question, but the jurors are different. So one juror said no on question 1 and yes on question 2, and I think another juror said yes on question 2 and no on question, or yes on question 1 and no on question 2. It's very confusing for sure. But the law requires it's the same 10, and in this case it wasn't the same 10. So you had 2 different jurors having 2 different responses. You know, one said yes and no, the other one said no and yes. I think that's the way I understood it. So if you have yes on question 1, then you go to that next question. So clear as mud, right? Yep, clear as mud. All right, so they were out for 11 hours. Actually, they were out for, okay, so the jury's verdict came after some 11 hours of deliberations, and then about an hour after it had appeared to reach a verdict, it was rejected by judge. So it was rejected, and then they are sent back to deliberate further, to which we now have, another verdict, I guess. Now let's see what they say on this one. Oh, and then I found a juror who spoke, but it was anonymous, but it won't play, which really stinks. So I can read I can read what this juror said, but anyway, we'll get to that when we get to it. All right, let's go here.
All right, very good. Thank you. I'll ask our clerk to make copies of the verdict to provide to the attorneys. I've read the verdict, I've reviewed it, I'm satisfied that both questions are answered, and there are 2 dissenting jurors on each question. There are the same 2 dissenting jurors on each question. Court will read the verdict. We, the jury, find as follows. Question 1. At the time the crime was committed, did the defendant have a mental disease or defect? Answer is yes by 10, 2 no. If you've answered question 1 yes, then answer this question, question 2. As a result of the mental disease or defect, did the defendant lack substantial capacity to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? Answer yes, 10 in the square 10 for yes, 2 in the square for no, 2. I note that the answer, or the word yes, is circled in answer to each of the questions. I'm satisfied that the answer is yes to each of those questions. There are 2 dissenting jurors to each of the questions. They are the same jurors. I'm satisfied the verdict is consistent and proper. At this time, I'm going to have the jury polled. This will be just polling the 12 who decided the case.
Juror 8420, was this then and is this now your verdict?
Yes.
Juror 4161, was this then and is this now your verdict?
Yes.
Juror 5723, was this then and is this now your verdict?
Yes.
Juror 852, was this then and is this now your verdict? Yes. Juror 6590, was this then and is this now your verdict?
Yes.
Juror 9694, was this then and is this now?
They follow the provisions of and the rules of the sheriff and being returned to your location to be released and to go home. It goes without saying that this has been a long week. You've done tremendous service at being part of the jury. I consider it to be an honor to be on a jury, and this has been a very honorable effort on the jury's part. So I want to thank each of you for that. I'm happy to meet with members of the jury after I've completed some other work in the courthouse. However, usually that happens at a different hour. So I'm happy to meet with members of the jury singly or as a group at some time in the future. You can call my office to make those arrangements. When I have these meetings, I don't talk about the case. I talk about the legal system and the jury process and how it operates. For you to know how the case progresses, you can call my clerk to follow up on what's happened with the case, and otherwise you may be able to read about it in the papers as well. Again, this has been an interesting case, a long case. You've been away from your homes for a long period of time. I understand all of the issues you've had to the extent that I can, but I haven't been away from my home for this period of time and in a hotel without contact with people or papers and books and so forth. So thank you very much. I appreciate everything you've done. Have a great rest of summer, a great fall, and a great life. To our alternates, thank you for being so diligent and really so much on point with everything too. We appreciate that totally. Have a great evening then.
All right.
Actually, I have one more. Let me read one more instruction to you. You can be seated while I do this. Your service in this case is completed. Many jurors ask if they are allowed to discuss the case with others after receipt of the verdict. Because your role in this case is over, you are not prohibited from discussing this case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss the case with anyone, you should then I would suggest you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. It is in the public interest that there be the utmost freedom of debate in the jury room and the jurors be permitted to express their views without fear of incurring the anger of any litigants or the criticism of any person. Please respect the privacy of the views of your fellow jurors. With that, keep in mind that we've gone to lengths to maintain your safety and your security and your privacy. That's with the jury questionnaires are confidential. They will not be disclosed. The use of numbers to create what's called an anonymous jury was to respect your privacy and to be able to preserve that. So keep that in mind as you go about your daily lives as well. Have a good evening then. Thank you. All right, thank you. Please be seated. Mrs. Mann, your motion is?
For judgment on the verdict, sir.
All right, thank you. Any motions from the state?
No.
court will grant the judgment on the verdict so ordered. Based upon that, I will find that Anissa Weier was found not guilty by reason of mental disease or defect to the crimes charged: attempted second-degree intentional homicide, party to the crime with the use of a dangerous weapon. Satisfied that one of the crimes is a felony that occurred after July 30, 2002, with a maximum penalty with enhancers of 35 years. Court has previously advised Ms. Weier of the provisions with regard to possession of a firearm and possession of body armor. With that, I will order that she be committed to the Department of Health Services. I will order further that there be I'm going to order a predisposition investigation. Will order that predisposition investigation report be furnished to the court no later than October 2. I'll set a hearing with regard to the receipt of that report and to determine a disposition at such time as that report's received, and then we'll schedule a hearing. My intent is to set a review hearing within 10 days of filing of the examiner's report pursuant to statute. Court will sign the necessary orders.
Your Honor, until the dispositional hearing, will she remain at the West Bend facility?
I'll order that she remain at the West Bend facility, subject to review by the Department of Health Services, and the court will follow any recommendations they make for a transfer of residence.
Thank you, Your Honor. And if she is remaining in the West Bend facility until the dispositional hearing, will the court allow her to maintain the visits that she's been having and the time she's been having at the Waukesha Juvenile Detention Center?
Yes, so ordered.
Thank you.
With that, anything further from any of the parties?
No.
Anything further from Ms. Weier's attorneys?
Did the court wish to set a date for the review hearing?
No, I said I'd set it
The
after I
disposition.
received.
Oh, sorry.
After I receive the predisposition report.
Thank you, sir.
All right. But we'll be in contact and work out the best date. I'll order that Ms. Weier then be returned to her residence in West Bend pending further proceedings. So ordered.
Thank you.
Court is in recess.
All right, so now I'm going to play some news, which might help us understand what happened. Because it doesn't sound like it has to be unanimous first and foremost, but it does have to be unanimous in dissenting. Those that say yes and those that say no has to be unanimous. So if you had 10 saying yes and 2 saying no, they have to be the exact same 10 saying yes and the exact same 10 saying no. And what happened the first time around was that it was different. It was different. That's the first time around. It was different people saying yes and different people saying no. That's what caused the confusion. It has to be unanimous in that regard. All right, here let's check out here's some news. I got 2 news clips.
A full day of deliberations, a verdict was finally reached. The jury finding Anissa Weier was not criminally responsible in the Slender Man case. 3 years ago, Weier and Geyser told investigators they needed to kill their classmate in order to please the fictional character Slender Man. The victim survived the attack. The defense argued Weier was mentally ill at the time. Late Friday night, the jury agreed. Weier's attorney said it was an emotional verdict for everyone.
I'm very thankful to the jurors for taking the time to look closely at what really was happening with my client. I know her family is relieved. It's hard to say when you're talking about the commitment of a very young child that you're happy, but of the options that were there, this is truly the best one and the right one.
The prosecution declined to comment. Weier will be sent to a mental treatment facility. A judge will determine the length of stay, but she has agreed she will stay for at least 3 years. Reporting in Waukesha County, Ashley Sears, Fox 6 News.
All right, so that didn't really help me too much there. Here, hold on. Let me see. I got another one. Maybe this will help. We'll see. I have another news clip.
We begin tonight with breaking news. A jury's reached a verdict for one of the 2 Slender Man stabbing suspects.
But the judge says the jury's decisions were inconsistent and told them to continue deliberating. The jury's deciding whether or not they believe 15-year-old Anissa Weier was mentally ill. Authorities say Anissa was with her friend Morgan Geyser when Morgan stabbed a classmate 19 times back in 2014. The girls were 12 at the time. Detectives say both Weier and Geyser said they felt they had to kill the other girl to please Slender Man, a fictional character. Anissa took a plea deal.
She shook tonight as the judge decided what to do. If a jury finds her responsible, she could go to prison. If not, she could go to a mental hospital. The other girl charged in the Slender Man stabbing case, Morgan Geyser, will go to trial next month.
All right, well, that didn't help us either. All right, I wanted to play this. You guys were kind of talking about juvenile, what do we do with juveniles here in the States? And I'm going to play this, then we'll get to her sentencing. This is I've got 2 clips, and this I thought might help us. It'll help me kind of understand the situation too.
And after children are arrested.
So I have 2 news clips, and they're short. They're only like 2 minutes long. But this is a look inside. One is Texas as well. One of them is a juvenile detention center in Texas.
And after children are arrested for allegedly making school threats, they're booked into the county juvenile detention center. We wanted to know what it's like in there. 13 on your side's Carla Byron. We got inside. Look at the center today. Carla, what was your impression?
Well, what stood out to me, Val, is a lot of simple things that kids take for granted. They have to earn while at the center. For example, they have to earn a pair of comfortable shoes and junk food. The purpose of being at the center is about learning structure, improving social skills, and behaviors. This is where a child enters the Kent County Juvenile Center for admission.
From the moment they come in, when we're getting the information about them, we do have them stand here in their clothes that they came in on, and we get their height and take a mug shot of them and a side photo.
This is a holding cell kids are placed in when there are multiple admissions. It looks like the regular rooms.
If we had a young person come in and they were very violent and belligerent and not cooperative, we may place them in here until they're able to calm down.
Once they're processed, they head to the showers and then put on detention gear.
One of the main reasons we have juveniles wear our juvie clothes, while they're in here, there's no gang representation, you know. We prevent from any of that because they're all wearing the same gear.
They're seen by Network 180 and a medical team. Then they're placed in a quarantine unit for 10 days per COVID rules.
I think the worst of the consequence is that they're being removed from their home. They're no longer with their parent, they're with us, they're in this strange place, not sure what is going to happen, how long they're going to be here. So, you know, kids tend to come in crying.
They get one phone and Zoom call by a parent or guardian every week, and they have to do their own laundry and wash their own clothes, among other responsibilities. The hope is the kids will learn social skills and how to make positive changes to their behavior. And another thing I learned, if they're misbehaving, they can get a 5-minute timeout or they're sent to their room to process what they did. Juliet.
All right. So that's a little look into that detention. Now, here's the one that I think is from Texas. So, of course, Richard, I thought of you. So this is from Texas.
When young people are arrested, if the crime is serious enough, they could. When young people are arrested, if the crime is serious enough, they could end up in the juvenile detention center. We don't know how the Midland Christian case will play out for the young man arrested, but Jonathan Polasic is here to give us an idea of what the process looks like in general. Jonathan, how does it work?
Hey, Crystal, yeah, every case is different, but what we do know is that in Texas, kids between the ages of 10 and 16 can go to a juvenile detention center if they commit a Class B misdemeanor or worse.
Adults aren't the only people that can get arrested. Minors can too, and sometimes they can go to juvie if the offense is serious enough and possibly stay there for a little while.
At that time, we look to see if the kid is known to us, if they're already on probation, those kinds of things. Then once the law enforcement agency has completed their paperwork, whatever the charges are, then they call our intake officer back, and we either detain the kid or it's a process and release.
If the minor is detained, law dictates that they go in front of a judge quickly.
Once the kid is detained, then they have to go in front of a judge within 48 hours. So we have detention hearings 3 times a week to accommodate those time frames. Okay? Those kids that are processed and released still have charges pending. Those charges go to the district attorney's office for review with us.
An average stay at the Midland Juvenile Detention Center is right around 10 days, but they can last much longer.
But we do have kids occasionally that are here for very serious offenses, maybe going through a transfer hearing, transferring their case to adult court. We've had kids here for over 300 days occasionally.
And there are some instances in which a minor can be tried as an adult.
A kid that's 14 or older that commits one of the more serious of offenses, murder, attempted murder, deadly conduct with a weapon, those really serious kinds of offenses. There's a process in Texas for a transfer hearing.
Now again, let's be very clear, every case is different. This is just a general idea of how the juvenile detention center process plays out. At this point, we do not have word on the fate of the Midland Christian student that was taken into custody. Crystal?
All right, now here's the article about a juror speaking out. I don't know if it's going to play or not. So we're going to find out. I may have trouble. Yeah, it's on a website, and I don't know if I'm going to be able to get it to play. Of course, there's an ad, so just hold on. But I'll read the article. I'll at least read the article. I'm hoping that this plays. There's an ad going on right now. Just hold on. Yeah, this is all I get. That's all I can get. It just spins and spins and spins. All right, well, let's see. Doesn't seem like it's going to play, but we can at least... Just ad after ad after ad. All right, one of the 10 jurors who determined Anissa Weier is mentally ill when she participated said parents of all 3 girls involved bear responsibility for the tragedy. I wish we could have put the parents on trial. Unfortunately, we can't, the juror said Monday. I do think the parents failed them. I think the teachers failed them. I think in general, society failed these girls. After a week of testimony, 11 hours of deliberation, the jury determined should be sent to a mental institution instead of prison. A total of 12 jurors heard evidence last week, but only 10 needed to agree on a verdict. It was a process the jurors said was driven by cool discussion and absence of emotion. There was no emotion in the discussion. It was very level-headed, the juror said. There were no voices raised. They're not identifying the juror out of an abundance of caution after potentially threatening comments about the jury were posted on social media. Wow. In their deliberations, the jury had specific questions about what Anissa told investigators and when certain things were said. To better establish a timeline, jurors asked to see a video interrogation in its entirety. The defense is showing us very specific things they want us to see, the juror said. Are they taking things out of context? Through the viewing of that video, jurors were able to determine a key statement made by Weier came at the beginning of her comments to investigators. I think the quote was, I didn't know we were in danger until Morgan told me after, the juror said. We thought she had said that toward the end of the interview. We didn't realize that was one of the first things she said. Most powerful, the jurors said, was the testimony of medical experts. They painted the picture of a disturbed young girl who followed Morgan Geyser's lead. Their portrayal of Weier's mental state was made more credible by their independence. The first two doctors we thought were completely unbiased. They weren't hired by the defense. They weren't hired by the prosecution. They were appointed by the court, juror said. While Payton Leutner's family has been critical of the verdict, this juror deflected blame back to the victim's parents. The jurors said the Leutners could have rejected any attempt to strike a plea agreement. The family was the ones who agreed to this. They had agreed to the plea deal. They approved it for both girls, the juror said. After a week of sequestration, jurors emerged from the courthouse late Friday to hear mixed reactions to their work. Comments on social media read by this juror were critical of their verdict and occasionally threatening. Seeing some of the comments, it's tough, the juror said. We knew one way or the other we were going to be unpopular. When you see it, it kind of sinks in. All right, so that's that. So interesting that they were getting threatening. What do you call it? Threatening posts on social media, right? Not the victims. No. Wait. Oh, wait. The victims. Yeah. Payton's family was not happy. Payton's family wasn't happy. Oh, wait, yeah. Why Payton Leutner's family was critical, the juror deflected blame back to the victims. Jurors said the Leutners could have rejected any attempt to strike a plea. So that's what the juror is saying. They didn't have to. The family was the one who agreed to this. They had agreed to the plea deal. They approved it for both the girls. So they are. This juror is saying the Leutners did not have to accept the plea deal. Interesting. All right. Let's get to the sentencing. Let's get to Anissa's sentencing. And then I'm going to go feed the kitties.
What I thought I'd do is just make some opening statements that set the historical basis for why we're here today and how it developed, setting the stage for the hearing this afternoon. The matter before the court today is based on a two-phase proceeding. At the time the case was commenced, there was an initial plea of not guilty to the charge in the original information. Then there was a second plea of not guilty by reason of mental disease or defect. The matter was set for a jury trial on both of those pleas. On August 21, 2017, Ms. Weier entered a plea of guilty to the charge in the amended information, which was attempted second-degree intentional homicide, party to the crime with a dangerous weapon. The phase on the not guilty plea by reason of mental disease or defect would continue on to a jury trial. The maximum sentence on the amended charge of the second-degree attempted homicide is 30 years imprisonment, which breaks down to 20 years of initial confinement, 10 years of extended supervision. The dangerous weapon enhancer constitutes an additional 5 years of confinement. Thus, the maximum sentence on the criminal charge is 35 years of imprisonment, meaning 25 years of initial confinement and 10 years of extended supervision. Based upon the plea that was entered to the attempted second-degree homicide charge, the circumstances after the plea, at the time of the plea, were as follows, and both the state and the defense, Ms. Weier, agreed to these circumstances. If the not guilty by reason of mental disease trial what resulted in a verdict not in Ms. Weier's favor, she would be sentenced on the state's recommendation on the criminal charge of 20 years imprisonment, meaning 10 years initial confinement, 10 years extended supervision. If on the jury trial for the NGI plea, the jury found Ms. Weier was not guilty by reason of mental disease or defect, then the case proceeds on that verdict. The state would, at the sentencing hearing on that portion of the case, agreed to that the commitment, and Ms. Weier agreed to this as well, that the commitment would be to institutional care and that she would not seek conditional release until July 1, 2020. That was the basis of going through to the trial, and ultimately the jury trial came back in the not guilty by reason of mental disease or defect phase and found that she was not guilty by reason of mental disease or defect. In doing that, the jury answered two questions in the affirmative. First question was, at the time the crime was committed, did the defendant have a mental disease or defect? The jury said yes. The jury also found affirmatively that as a result of the mental disease or defect, that Ms. Weier lacked substantial capacity either to appreciate the wrongfulness of the conduct or to conform her conduct to the requirements of law. So that's the basis that brings us here today for a sentencing on the commitment portion of the case. From that standpoint, does the state have anything to comment upon or state with regard to the sentence?
I think what you stated was correct and accurate, Your Honor.
All right, thank you. Does the defense agree with my comments?
Yes, sir.
All right. Then does the state wish to make any statements as to the sentence?
Yes, Your Honor, thank you. As you just pointed out, in return for the amendment, the agreement is that the defendant will agree to institutional care not to seek conditional release until July 1st of 2020, which really, and in terms of the institutional care, as you know, because you have in front of you, the predispositional investigation also agrees that institutional care is appropriate. So I don't think there's much of an issue there. The only real issue that's left remaining is how long should the commitment be. As you know, the maximum commitment is the maximum period for which she could be confined, so it's 25 years. And that would date back to the date on which she was taken into custody, which is the date of violation in this matter, so back to May of 2014. So then we'd be looking forward to 25 years, or looking forward, 25 years from that date would be the maximum term of commitment. You have received a victim impact statement from the victim's mother, Stacy. I can tell you that no one from the victim's family wishes to orally address the court at this time. They're all relying, they believe that Stacy's statement is accurate and accurately reflects their feelings also. So it's, even though it's signed by Stacy, it's more of a family-wide victim impact statement, I guess is the best way to put it. So then, as I said, we're left with the question of how long should the commitment be. The state believes that the maximum commitment of 25 years is appropriate. That would take us to 2039 at a point in time when the defendant would be 37 years of age. I guess my first thought is that considering the nature and gravity of this offense, being supervised until the age 37 is not all that long, given all the facts and circumstances here. It may be a long time in some respects, but it's not a long time in terms of the fact that Payton is looking at a lifetime of scars and psychological scarring, physical scarring, that she's going to have to deal with. So saying that 25 years is a long time pales in comparison to that. As you know from Stacy's letter to the court, Payton still suffers. She can't leave her drapes open. She can't leave her windows unlocked. this still affects her. But yet, in spite of that, and in spite of her young age, she believes, which is, as was noted in that statement, and why the reason we agreed to this plea agreement, she believes that Anissa needs institutional care. Well, I don't know, frankly, how much time Ms. McMahon is going to argue for. The state's thoughts on this is real simple. The maximum commitment, considering the lifetime of suffering that Payton looks forward to, will help her to derive a modicum of solace, knowing that at least for those 25 years, or what's left of those 25 years, that someone will be looking over Anissa's shoulder so that she doesn't have to worry that Anissa is looking over her shoulder. Frankly, I think it makes sense. And I understand, because it's come up over and over, this argument about the juvenile brain and how it's not formed, and etc. But the fact of the matter is, we don't know that, in effect, Anissa is going to age out of this type of behavior, which I assume is part and parcel of an argument for less than the maximum commitment, is that, well, you know, once she gets that mature adult brain, this won't be an issue. We don't know that. What we do know is what she did now. We do know that she was susceptible to a shared delusion. We have no way of saying whether she's not susceptible to a shared delusion in the future, whether that be 3 years from now, 22 years from now. The fact of the matter is, Judge, we believe that the only real that I can think of, once at a certain point, assuming for the sake of argument that Anissa is doing better, she's going to be released from unconditional release at some point. If she's doing better, her supervision will do nothing more than making sure that she continues to comply with her treatment recommendations and making sure that she's not backsliding. The state doesn't see how that could be a bad thing, Your Honor. And in fact, if she's not doing well, which would be an argument, I guess, we don't want her locked up for 25 years, but if she's not doing well, that's exactly why she should be locked up for 25 years. So really, if she's doing well, this shouldn't be a big problem. And if she's not doing well, then she absolutely should be. She would be a danger then to herself or others, which is exactly why she should be locked up for 25 years in an institution. And I probably shouldn't use the word locked up, but I think we all know what I'm talking about. But if she's having problems, she needs care. If she's not having problems, this commitment will be very easy for her. She'll just simply prove to her supervising agent, that she's doing well, that she's doing the things that are required of her, and that she's not having any problems. If she's not doing well, as I said, that supervision will become important, both for the victim as well as for the community, and as well as the defendant. Because if she's not doing well, that would mean she needs help. And the only way we can ensure that she gets that help through this case is the maximum commitment. So we're asking that you impose 25 years of commitment in this case. And that's all I had, Your Honor.
What position do you take on medication?
Your Honor, the state's position at this moment is I don't know that. Well, straight. I believe that if she needs medication, if we're going to see her improve, if we're going to see her hopefully get released at some point down the road, that she would have to take that medication. So the state believes the court should order that she be required to take all medications that are required of her.
Thank you. Then Attorney McMahon, how do you wish to proceed?
Your Honor, I have some statements from the family that we've recorded. I would like to play those first, if the court would allow me.
All right. Now, are the when you play them, are they videos or are they?
It's a video, sir.
All right.
And I have, if the court wishes, a copy of it on a flash drive.
Well, before we start, then we should have the flash drive then filed with the court.
Certainly.
And that'll become an exhibit. As an officer of the court, you're representing that the flash drive, it contains a true and accurate copy of what you're playing in court.
Yes, sir.
All right. Now, on that basis, when we do something like this, the court reporter need not take the transcript down. We rely then upon the true record of wording, what's said then on the video. Very good. You can proceed.
When we first started going there, she was a little girl. She was 12.
Now, excuse me.
She had no concept
We have to
of how
identify who
serious
this is.
this matter was.
His grandfather.
She would talk about
Well,
what
let's
she was
stop
going
it.
to dress up for as Halloween costumes.
Now, we have to identify who is the speaker, and perhaps you should start from the beginning then. And this will, of course, be on the record.
The first speaker will be John Weier, same spelling as Ms. Weier, her grandfather. Also present in most of the scenes with him will be his wife, Melody, I'm sorry, a little nervous. Also speaking will be William Weier, father of Anissa, and Sarah Weier, sister of Anissa.
So what we should do then, just to be sure that our record's clear, that when the senior Mr. Weier is complete, and then the younger Mr. Weier testifies, we should have it. You should state that.
The problem, Your Honor, is
It's a continuum?
It's a continuum.
All right, so the three people speaking on a video, that's a continuum, and you've identified who they are.
Sarah Weier.
4 people. All right, very good. Proceed.
And where she was going to be trick-or-treating that year. It was very difficult to sit there knowing that she wasn't going anywhere.
When she would first come in to the room, she would be happy to see us, but there were times during our conversations where she would look almost blank. I think that she probably was thinking, I wonder what my grandparents think of me now. There have been times when she said, I don't know why I would have done this. I can't figure it out. And that would bother her an awful lot.
She says, I take this one day at a time. That's how I get through it. I keep myself busy with my schoolwork. I keep myself busy with helping with whatever I can do.
She's almost taken on this role of pod mommy, as some people call her. You know, she knows how things function there. She has helped other kids learn the day-to-day routine.
I'll use the term more like a teacher's aide now, where she's been through these courses, she knows, and she's very instrumental in helping other students with their schoolwork and their learning.
She advises other kids, or sometimes counsels other kids when they're having a bad day, trying to give them different perspective. She's very good at letting people know that you know, there's light at the end of your tunnel, so don't get down, don't let juvenile detention define who you are.
I think this experience with her will give her an inside path to others who will need this kind of guidance.
Because of her experiences in West Bend, she's talked about going to school and becoming an advocate for children in her situation. She was taking online courses while in West Bend. She read, she did the work, she learned, she got through it, she got a good grade, and you know, she wants to continue that. She wants to get her high school diploma. She wants to go on to college.
She goes, someday I want to get married. I want to find a guy that loves me and I love him. And I want to get married and have kids. And she goes, and then I think to myself, do you think that's going to work? Will my kids disown me if they find out what I did? Will my husband leave me?
All the psychiatrists and psychologists who testified had said that the chance of recidivism is nil.
3 of the doctors that testified all told the court that they feel, based on independent reports, that Anissa poses little to no threat to society, and her treatment would be best served with probably 2 years of talk therapy.
She's grown mentally and physically in the last almost 4 years. She knows what she did was wrong. I hope with the judge's sentencing of Anissa, he takes into consideration what he's learned in the last 3.5 years.
She will have had time to talk through what's been going on in her head and try to get some sense of why she allowed herself to get involved in this situation.
I know for a fact that she wants to come home, and I know that she's tired of sitting, but I know that she knows that she needs the help, and I know that she's okay getting the help. I miss having her around because it's just, she's got a really good energy. She's a good person, like deep down, honestly, she really is. Every time I talk to her, she's just always got this like light in her face, and she's just so happy. Now she's counting down the days until she can come home, because that's like one of the main things that's keeping her afloat.
Every day of our lives we think about, why did this happen? Is there anything we could have done?
I think about them every day. I think about how they're doing. I think about their opinions of Christy and I as parents. I think about their opinions of Anissa. I hope that they can find it in themselves to see that Anissa is a good person and accept the apologies from the family for everything that all of the families involved in this tragedy have gone through over the last 3.5 years.
Memorial Day 2014 is a day not one of the families involved in this tragedy will ever forget. I cannot fathom the shock, fear, and anger that the Leutner family experienced that day. To send one's child off to a sleepover with friends only to have her attacked is something no parent should have to experience. I would like to offer my heartfelt apologies to the Leutner family for having this thrust upon them. Thankfully, Payton survived. It's something we gotta live with the rest of our lives. It'll never go away. But seeing her with the attitude she has and how upbeat she is and making the best of this situation helps us to get through this ordeal also. When we first started going there, she was
Mrs. Weier was unable to make the filming, and I don't know if she has anything she wishes to add.
I didn't hear what she said.
I agree with the family statements.
All right, thank you. Appreciate that you're here. Thank you.
I understand what Mr. Osborne has suggested to the court, and had we dealt with a fully formed individual who had involved themselves as a party to a crime in this stabbing, I could understand that as the court sentence. But we're dealing with someone who was 12 at the time. What he's asking for, in essence, Your Honor, is for you to commit her for 2 times as long as she had been alive at the time this happened, plus a year. To me, that doesn't make sense, and perhaps it's because I also work, as Your Honor has at times, in the mental health portion of our court system. So I'm aware that if there is any evidence of future dangerousness when one nears the end of an NGI commitment, that there are options available to secure treatment, to require medication, to require hospitalization. So I don't share the fears Mr. Osborne has, and I think in our country we see any deprivation of liberty, whether it is for a meritorious purpose such as treatment, or simply for punishment. We don't do that without reason and without measure. And one of the important reasons behind limiting the amount of time one controls a person is, frankly, the other persons to whom you expose them. The evidence-based practices that have become common in our criminal justice system have come over from the human sciences because of important information, like the more you expose someone to more seriously criminal individuals, the more likely you are to harm that person and harm their behavior, not help it. That's why in criminal cases, probation is the presumptive in the beginning. And that's why our probation departments have begun dividing up who comes on what day to their office to avoid exposing low-risk offenders to high-risk offenders. Because as our mothers told us, it's not you I don't trust, it's your friends sometimes, and the choices you make when you're around them. The reality is, Anissa is going to be in a hospital setting for quite some time. And when the state asked us to stipulate to that, when within the statutes there are provisions for people seeking release and is supposed to be based upon doctor recommendations, our young client was the one who said, no, they're right. I need that. She talked about how she had been away from normal society for so long that when her parents were allowed to bring a treat in to a visit that required the use of a fork, they had to teach her how to use it again. Because in secure detention, that's not a utensil they have access to. When you look at that, this child sat there and explained to us that she needed help learning not only to deal with the nightmares that don't allow her to sleep, with the fears and the concerns she has about, could I ever do this again? What do I need to do to make sure that nothing like this ever happens again? She felt she needed that time in the hospital. Your Honor has perhaps more information about this young woman than most persons who will ever come in front of you or any other judge, given the reverse waiver hearing, the competency evaluations, the Miranda Goodchild hearings, looking at both her functional abilities, her intellectual abilities, her mental health issues, and her behavior while maintained in a secure detention facility without medication for 1,301 days now. Many children slack off.
How many days did you say?
1,301 if you count today.
All right, thank you.
I noted that one of the media outlets reflected that my client had developed quite a sense of humor when you had asked her about school one time, and she informed you quite proudly that she went to school every day. The court is aware, and those of us who work with children who are incarcerated know that sometimes, depending on where you are, if you're incarcerated and you refuse to go to school, it counts as a mark against you, but they don't force you to go. She chose to go because school is important to her, because learning is important to her, and she knows it's important to the court. She, when trying to figure out where her life will take her from now, she knew that there were two options. One would be a hospital, and she knew that Winnebago, because she discussed it with us, was where generally females are sent on NGI, or Copper Lake, until the adult system. She researched and found that while she was now doing online schooling at West Bend, and they put that program in place so that she could expand her abilities to learn, she also learned that neither place uses computer schooling, so she worked with her teachers to create a curriculum that would transfer no matter where she was going, because she wants to be future focused and she wants to excel at whatever the court asks of her. The statements that her father made about the things Anissa wants to do now are things that Mr. Smith and I heard as time went on, as Anissa was in secure detention and saw some things that troubled her. She was very thankful, as were her family, for the professionalism and really the kindness of the staff, both at our secure detention facility and at the West Bend secure detention facility. She jokingly refers to the staff there as her step-parents, because for 3.5 years, in essence, they've been in loco parentis. But she saw that many children come into secure detention who, in her opinion, didn't need to be there. Children who were placed there because there was no place else to put them. Because as children grow older in our juvenile system, it's hard to find a foster home that wants to take them. And until that is found, sometimes that was the only option. It bothered her a lot. She talked with Mr. Smith and me about how she wished that this wouldn't make it so that she couldn't someday be either a foster parent or run a group home for children who had a run history or had a delinquency that made it so that foster homes didn't want to take them, because she had learned, getting to know these children during the short stays they had, that they were good children. They just needed someone to believe in them and someone to have their back. That troubled her a lot. It still does. I think it troubles a lot of us who work in the juvenile court system. But to have this child who was facing so much on her own see how unfair that was to other people, that was impressive to me. And it also reflected a change in who she wanted to be and what she wanted to do when she was older. She did a little pamphlet when she was, I believe, in 4th grade. She was 10 years old when she did this. It's called My Life. And I have a copy for the state and for the court, simply because it gives you a picture of Anissa Weier 2 years before this happened. She could have been anyone's child. In the end, she talked about her future, the last page of it. It was going to go like this. 10 years from now, I'll be 20 and training to be a zoologist, parentheses, person that works at a zoo, close parentheses. In 20 years, I'll be 30 and have a husband and a big lazy dog. In 30 years, I'll be 40 and be a zoologist until I retire. That's my future. Well, many of us have changed what we wanted to be from the time we were 10. Some of what Annie wanted for herself is still the same. And some of it has changed. She wants to give back and help kids. She still, as the court knows from all of the reports she'd received, is worried about endangered species, climate change, things that affect the planet. But she knows before she can do any of that, she needs to seek help and make herself the healthiest person she can be. Your Honor, I think if the court is looking at what makes sense, when Your Honor was making the order at the end of, after the arguments at the reverse waiver hearing, you focused on what we knew about brain development and what we've learned over time, and that generally between 21 and 25, we have a very good picture of who this person is as an adult. 21 to 22 if you're a female who hasn't experienced significant trauma and mental health. Anissa's participation in the stabbing of Payton, as well as the time that she has spent taken from her family and separated from them physically would qualify in psychiatric terms as trauma that can affect the maturation process. In some ways, it's made her much more mature than a lot of children, but in many ways, it's left her still 12 years old, not having had the formative experiences of high school that other children have. So there's sort of a mix there. I don't think, Your Honor, that we need to look at committing this child beyond her 25th birthday. I think that is what makes sense here. That would allow a period of time at the hospital and then time on extended release if it were appropriate. And that would be up to the doctors. I don't believe within the report that the doctors opined that Anissa was not competent to make her decisions regarding medication. I think that's a decision we should leave in the hands of the hospital. If they feel that she needs to take medicine and she's refusing it, they will seek an order. The court knows that, I know that. We have a young girl who's been on this earth since November 10th of 2001. I'm not really good with numbers, but I like when I can quantify something. That's 5,885 days, 1,301 of which have been spent in West Bend Secure Detention. She spent almost a quarter of the life that she's lived in custody. So it's time to move her to the hospital. And it's time to let her move forward. But I do not think we need to hold her twice the length of the time that she had been on this earth before this terrible incident. I want to thank Mrs. Leutner for her letter. The terrible pain it expresses for their family. I know that my client is beyond sorry for, and she knows that she can never fix what happened. She can never change what happened, but she can work to make sure she's the best person that she can be to honor Payton. I particularly made sure to share with Anissa the last paragraph, the fact that Payton wanted her to go to the hospital. That the reason the family was willing to accept what we had talked about as a plea deal was because their daughter wanted these two girls, not just Anissa, but Morgan too, to go to the hospital and get help. It tells an awful lot about what a wonderful child Payton is, and is something that I think was probably one of the kindest things my client has heard in 3.5 years. It made her cry, but it, I think, was healthy and healing for her to be able to hear that that was what Payton wanted. And she knows that it is unlikely that Payton would ever want to have contact with her again, and so she will stay away from her. She has, in the past, after we had talked with her about some of the options the juvenile system offers, one of which is oftentimes victim offender mediation, that's been used also in adult systems at times. If the Leutner family ever wanted that and felt it would be healthy for Payton, she needs that or wants that. Anissa is more than willing to participate in that. She knows it's not likely, but if that was something that would help Payton, she would do it. So, Your Honor, I am asking you to consider the amount of time already that she has had in custody. Mr. Osborne says, well, we don't know who she is, who she's going to be. But we know for 3.5 years, in very difficult circumstances, that she has managed to follow the rules and not allow herself to be influenced by some the other persons that she was placed with for a long period of time. She has worked hard and done what was expected of her in a situation that very few children have ever been in, being in custody that long. Now, there are children who go to Lincoln Hills or Copper Lake and may be there for that length of time, but they have access to the outdoors. It was only after about 260 days, maybe longer, when Your Honor authorized the visits here in Waukesha that Anissa had any access to natural light. As the court may recall from the testimony at the reverse waiver hearing from Nicole Sakek, who runs the West Bend Secure Detention Facility, their natural light requirement is met by a frosted skylight in the day room. The only glimpses of the outside Anissa had were on trips to court until she was allowed to go shoot baskets in the courtyard of our secure detention facility. That same amount of time, from the date of May 31st, 2014, until our first visit at the Juvenile Detention Center, were also time spent without physical contact with her parents and without any contact with her older sister, her older brother, or her younger brother, because they were not allowed on the visitors list because they limited to parents and grandparents. When we look at things that in the criminal system would be seen as indicators that the person is likely to respond well to supervision and to respond well to societal expectations, one of the primary things we look at is support. Is there a pro-social family behind this child? And the answer is yes. Not only are they hardworking people, they have spent, I believe, every day, there may have been 1 or 2 days that were missed, but every day since May 31st of 2014, they set up a visitation schedule, and between her mother, her father, and her grandparents who spoke, they visited her. They were careful to avoid school hours because Anissa didn't want to be taken out of her classes. But that sort of devotion and that sort of willingness to stand with the child no matter what, I think is another thing the court should take into consideration when determining the length of time needed on a commitment. Her family, knowing now what they know, knowing that she has a disorder, and knowing that particularly with a delusional disorder, it was Dr. Kavanaugh at the reverse waiver hearings testified that given the lengths a person will go to protect the delusional structure, that they would not have notified parents. They wouldn't have done things to show them what was happening. They know this now, and they can watch, and they will. And I think they will probably be far more and long-standing support for Anissa to keep her on the right path. So, Your Honor, given how long she was spent in custody, how young she was at the time, the remorse that she has shown throughout this, I would ask you to consider allowing the commitment to end on the 25th birthday. I think that makes sense. And I'm hoping that you will do that.
All right, thank you. I appreciate your comments. Then, Ms. Weier, do you want to say anything?
I just want everyone involved in this to know that I do hold myself accountable for this, and that I will do whatever I have to do to make sure that I don't get any sort of delusion or whatever again. And I want everybody involved to know that I deeply regret everything that happened that day, and that I know that nothing I say is going to make this right, Your Honor, and nothing I say is going to fix what I broke. I'm just hoping that by holding myself somewhat accountable and making myself responsible for what I took part in that day, that I can be responsible and make sure this doesn't happen again. I'm never going to let this happen again. I'll do whatever I have to do to make sure that this doesn't happen. And I know you've heard that before and you're probably going to hear it again, but it's the truth. And I'm sorry.
And well, thank you for your comments. I appreciate them. Anything further from the state?
No, Your Honor. My comments stand. I don't think that, obviously, they're not the same as Ms. McMahon, but I don't think she said anything that I really needed to comment on. Other than the one thought I did have is that 25 is not a magic number in this whole case. To say we should go till 25, maybe an average day when the juvenile brain is fully developed, but it's just a day. So I think, though, that the supervision that would go till age 37 is much more appropriate for all the reasons that I mentioned.
All right, thank you. Then Ms. McMahon, anything further?
No, Your Honor.
All right, thank you. As was noted, the court did receive the letter from Payton's mother, Stacy Leutner, and I've read that and been distributed to the parties, so I'm aware of its content. The court also, at the time of the jury verdict on September 15th, I did order a predispositional report from the through the statutory process, and Wisconsin Correctional Service is the one that prepares that report, and they did submit the report on November 3rd. It's a rather detailed report, very thorough, at least appears thorough. It's 7 pages in length, and it discusses the Ms. Weier's current status or current situation, things that had happened at the West Bend Detention Center, and what their recommendation is and how the case should proceed from their standpoint. So I read that, and the parties have each had that as well. The court follows the statute. This type of case is in court under section 971.17 and in of the Wisconsin statutes, and specifically when the court arrives at determining the commitment, the court looks at 971.17 sub 3 sub a, which gives the court the authority to issue the commitment and gives the court the authority to and criteria that the court looks at and thinks through in deciding what the commitment should be. So I reviewed that statute, and I have that in mind as I review the case today. As has been discussed earlier, the nature of this case is that the maximum period of the commitment is the maximum period of confinement that's available under the criminal charge. And as I indicated earlier, that's 25 years. And that's why that number has been discussed by the state and presented by the court in my initial comments. There was, as I indicated initially, as part of the plea, and when there's a plea is entered, it's a plea negotiation in a case, that plea agreement is presented to the court. The court has to approve the plea agreement, but the court's never part of the agreement, so I'm not bound by it. But there are parts of the agreement that do bind the defendant in this case. And one is that there was an agreement that she would not seek conditional release for a period of time, that she agreed that the initial commitment would be institutional care. And I'm satisfied in reviewing all of the documents at institutional care, looking at reports, what I know about the case, listening to the comments, that institutional care is the appropriate type of commitment. So I recognize that Ms. Weier has agreed to that, but I also find by clear and convincing evidence that the conditional release of Ms. Weier would pose a significant risk of bodily harm to herself and others. Thus, the commitment will be to institutional care. As part of that agreement, she also agreed to not seek conditional release, which is a way to be released from the commitment institutionally. It's not a release from the commitment itself, but it allows you to go out on the street, if you will, not to make that request for till July 1, 2020. Under the statute, someone who's committed under 971.17 can seek release every 6 months if they have the necessary reports and file that petition. So in their plea agreement, to which she would be bound, she has agreed not to seek that type of release until July 1, 2020. Now, looking at the circumstances of the case, it's in reviewing the matter, as I indicated, I have the courts in any kind of a criminal case, courts concerned with what the impact is on the victim's family, and society as a whole. Criminal acts occur against people, sometimes property, but generally people, but there's always an impact in the community as well. It's really a broad impact that occurs. The letter received from Ms. Leutner describes very well the impact it's had on Payton and on their family. In some respects, and that type of impact, the nature of the impact, flows out to the community and impacts everyone really with what happened. The dynamics of this case are simply tragic. Young people involved in what started out as a good time turns into tragedy. Someone is almost killed. Just not a good situation, but that is what happened in this case. In recognizing the impact to Payton, the letter has been distributed and has actually appeared in the news. Parts of it were reported in the newspaper, and I believe on the television media as well. But there are aspects that really go to the nature of what happened that I think it's important that the court keeps in mind, because the court has to be cognizant of the nature of the crime that occurred in this case. The part of the letter states that, this is Ms. Leutner's letter, states the 19 stab wounds that Payton endured that day left 19 very visible scars on her arms, her legs, her hip, her torso, and her chest. The nearly 6-hour surgery and other medical treatments to repair her heart, diaphragm, liver, stomach, and pancreas left 6 more scars. 2 of these scars span from just below her neck to just below her belly button. It goes on to discuss some issues with regard to the scars, but then it talks about something that's almost a very practical result of those type of injuries, and that is shopping for homecoming dresses leaves only a few options because far too many dresses will show off her scars. Beach vacations are harsh reminders that swimsuits aren't made for young girls with 25 scars. So we have the physical injury, but then you got this other part of it, that it's what always reminds Payton and her family, would remind others of what happened. The scarring and how to disclose it or shield yourself from it, shield others from it. Letter goes on to discuss Payton's wounds being far more than physical, beyond physical, and then discusses the emotional trauma, fear she has, difficulty she has as a result of what happened. Letter emphasizes that Payton, from one standpoint, from an outside casual observance, appears to have recovered well. She's back in school. She's gone to school activities. She's been actively involved in things. Letter points out that she's more reserved. She's more cautious. All of which isn't surprising when you look at what happened. Talks about impact to Payton's brother and what happened. His reaction. It talks about the impact, the marriage of Payton's parents. And then, as was Attorney McMahon noted as well in the last paragraph, Ms. Leutner talks about what brought him to today and what brought her to writing the letter. And it talks about, it says, the reasons for agreeing to accepting the plea deals for Morgan and Anissa. First, because we believed it was the best thing to do to ensure Payton would not have to testify. Traumatizing her further didn't seem worth it. It's a very practical result, but that's certainly true. Just as you walk down the street and somebody looks at your scars, to come back in and relive everything verbally would be traumatizing, and it would be a new injury to her and to the family and also to the community. And second, because Payton felt placement in a mental health facility was the best disposition for both girls. While Payton believes a mental health facility is the best place for Morgan and Anissa, she still fears for her safety. She still sleeps with her windows closed, locked, and with security latches engaged. She still refuses to open her curtains. So that's, I think a very, very emphatic statement of the impact to the victim, to the family, and in a sense in how it reflects back on the rest of the community. That's a factor the court keeps in mind, is what was the nature of the offense and what happened. In the presentation today is that Ms. Weier, not just today, but in all other circumstances. I find her to be mature in her presence in court. I think she has empathy for what occurred. I do see remorse in what she said. You look at her coming up, growing up, undoubtedly a good family, doing well. The brochure that Ms. McMahon presented says a lot about a happy little girl of 10 years, as she wrote about her life. Undoubtedly, that's the same with Payton and her family, but with Ms. Weier, it's certainly reflective. She's had, as Payton has had, the Leutner family and friends have been here all of the time, and has the Weier family been here all of the time in showing support. So you have two young people that get involved in a tough, nasty situation that will impact everyone for a long time. I think what Ms. McMahon said about what happens when Ms. Weier is married, has kids, or her kids, how do people around her react to what she was involved in on May 31 of 2014. Those are long-standing, deep wounds that I doubt will ever heal. The same is true for the victim as it is for the perpetrator, for both of them. When the court looks at a sentence, or a commitment in this case, I look at what I've talked about, the impact on the parties, impact on the victim, impact on the defendant. I look at the nature of the offense. It's a critical part. To some extent, I've talked about that. In looking at the predispositional report from Wisconsin Community Services that wrote the report, I think Wisconsin Correctional Services earlier. That used to be their name. It is Wisconsin Community Services Incorporated. The writer presents really good background and detail on what happened, the planning for the offense. We have to, in addressing out what the offense was, and forgetting about even who the victim is and who the defendant is, who the perpetrator was. This was, according to the report and according to the evidence that we have, this was an offense that was planned. The offense occurred on May 31, but the planning apparently started sometime in December of 2013 or January of 2014. So this wasn't that spur-of-the-moment offense that all of a sudden people get excited and they do something that they regret. This is a planned offense. It was a planned murder. Can't forget that the effort in this case, the goal of this matter, was to kill the victim. It wasn't to wound her, it was to kill her. And of course the report talks about the situation with Slender Man, and it's really been much of the sort of the media focus of the case and the media drama of the case is what happened with Slender Man and how that had an impact on what happened with the offense. But the report goes into some detail about the planning and how everything came down the 30th and the 31st. What the report, and that's been in the news and been the subject of much discussion, but it's only something I have to keep in mind, and when I decide what the commitment has to be, I look at the nature of the offense, what happened. The planning part of it is important. The serious part of it, the serious nature of it, a planned murder by kids. Now, I can say a planned murder plan for months, and it sounds like I'm talking about some organized crime operation, but these were kids doing that. The impact is the same, but it's still got to keep in mind the age of the parties, and I certainly do when I reflect on what the best commitment is on Miss Weier's young age. In the report goes on to begins a review of the Miss Weier's current psychiatric emotional status, and does so by first looking at the three reports that were three expert witnesses that testified at the jury trial and their various opinions. The report goes on to look at Dr. Michael Caldwell, opined that Miss Weier was suffering from delusional disorder, persistent depressive disorder. Her delusional disorder was more likely by her underlying schizotypal disorder. Miss Weier exhibited a cohesive system of delusions about the existence of a supernatural evil things that would control the thoughts and actions of others and commonly killed children and their families. That certainly was part of the case and came out repeatedly about the delusion, the impact that the Slender Man character and process had on both Miss Weier as well as Miss Geyser. And then we go on, and the writer talks about Dr. Melissa Westendorf, who was another expert that the defense brought in, as to her view. She found that there was she shared the concept of the dual delusional disorder. Miss Weier's in that relationship between two people, that Miss Weier is considered the submissive recipient of the shared psychotic disorder. Dr. Gregory Van Raybach testified as well as a third expert. He shared the opinion that Miss Weier suffered from a shared delusional disorder. He found and wrote that she became ensnared in a false belief that was constantly reinforced within her relationship with her friend, and could not at the time of the crime distinguish between those false beliefs and reality. So those are the reports that were part of the jury trial. They formed the basis for the jury verdict in this case. But that's the psychological, psychiatric, mental health background that brings us here today. The significant, what I found of much of what I read in the report, I knew, and I knew from prior hearings. So there are parts of the report which were new, and to some extent startling about what has been going on and what the situation has been at the West Bend Detention Center. In a section titled Psychiatric History, of course, Miss Weier reported that she struggled with depression since around 10 to 11 years old when her parents were going through a divorce. For about the last year and a half, now that's the letter, this report was written in November, so it's going back to 2016. For the last year and a half, she's been meeting with a therapist from Waukesha County Health and Human Services. In therapy, they work on managing anxiety and practice breathing techniques. Ms. Weier denied ever hearing Slender Man talk to her and denied ever feeling like he was in control. She denied any history of auditory hallucinations. Then the report goes on. Reports confirm that Ms. Weier has been meeting with therapists from Waukesha County since May 20, 2016. At intake, Ms. Weier's primary complaints were related to having difficulty coping with her incarceration and guilt about her offense, difficulties in her relationship with her mother. Ms. Weier has worked with Ms. Weber on mindfulness techniques and dialectical behavior therapy. In December 2016, Ms. Weier told Ms. Weber about having made a homemade Ouija board in the jail and that some evil spirits were let out. Ms. Weier believed that the evil spirits were pushing down on her bed at night, was worried that the spirits might kill her, and had difficulty sleeping, and had dreams in which God told her that Slender Man and the evil spirits were actually demons. To address this, the therapist planned to work with Ms. Weier on distinguishing the difference between reality and fantasy. However, since about January of 2017, it appears they did not continue to talk about Ms. Weier's superstitions and delusional beliefs, but instead focused on difficulties within her family. I'm concerned when I read that, one, that there is an opportunity for therapy and it didn't really take place about the big issue for us, and that's Slender Man and the attempted murder in this case. And that the Ouija board came into play. That's a game in some respects, but in other situations is a very serious situation. That she was allowed to do that at that institution and allowed to have some other issues that will develop about what one could classify as delusional characters. She acknowledges that she believes that Slender Man is, in a part of the report, she told the writer as well as the therapist that she believes Slender Man is real, sees him as a demon, tries to address him in that fashion. The writer of the report ultimately recommends institutional placement and believes that she, and quote, the conditional release team recommends institutional placement for Ms. Weier and believes that she still poses a risk of harm to herself or others at this time. Under the shared delusional belief with her co-actor that Slender Man would harm her or her family if she did not carry out his wishes, Ms. Weier took part in the violent stabbing of a childhood friend. Ms. Weier continues to believe that Slender Man is real. She also stated that as recently as July 2017, she believed that an evil spirit was pushing down on her bed after the spirit had been let out of a homemade Ouija board and that she'd been playing with. She has continued to be easily influenced by peers. She has been convinced by another inmate who was a devil worshiper that her co-actor, meaning Ms. Geyser, is possessed. And the report goes on to discuss the comments by Dr. Raybeck, the Van Raybeck, from his November 2016 report, where he states, quote, today Anissa appears to be in full remission from the delusion, but is in need of treatment about its ramifications. She will need treatment concerning the genesis of the behavior itself, and the trauma and distress about attempting to take the life of another human being. Now that's the end of the quote. Then the writer goes on to state, unfortunately, none of these issues have been addressed in any therapy of any length. Thus, she, meaning Ms. Weier, still exhibits some of the same characteristics that factored into her offense. The report continues that the team believes that placing Ms. Weier in an institution for an extended period of time would be beneficial to her without the distractions of the community setting and much less risk of harm to herself or others, and discusses a safe setting of a mental health hospital. In looking, I went through the report in detail because it has significant comments that certainly have an impact on what this case is about and what the commitment is about and what direction that the commitment should take. It certainly looks at the nature of the offense, at the nature of the crime that occurred. It talks about the safety issues and get a sense for the safety issues that are involved in a case such as this, and what the community has to do and the legal system in this case has to do to ensure that based upon the nature of the jury verdict, that Ms. Weier has that opportunity to heal, become a safe member of the community, and function just as she wants to do in the future. There are a lot of roadblocks to Ms. Weier, most of which that Attorney McMahon talked about. It's going to be difficult for Ms. Weier to to move ahead just in the long term. Even if she gets over the day-to-day issues, the long-term memories, just like they are for the victim, will always be there and have that impact. She has served a lot of time in custody, 1,301 days. It's a long time for many people, and especially somebody so young. It's a good portion of her life. But the court has to be concerned with looking at all of these things. What's the best for the community? Things may be what's best for the community may not be what's best for Anissa Weier. We have to be careful about that. The long-term impact of this case has to lead to a conclusion that it doesn't happen again. We don't have any repeat activities. As much as we can sit back and say, I will never do that again, and I think it's sincere, I'm not criticizing her for saying it, we don't know. You know, there's enough history here, especially with what's most recently occurred at the detention center, as related in the report, that delusions still occur, and that type of, if you will, evil delusion is still out there, perhaps in another form, leads the court to be concerned about a short commitment period. I think the court has to look at one that's longer and has a more permanent impact in protection. There are other factors that the court looks at in determining commitment. If Ms. Weier is released, where does she live? How will she support herself? Those really don't have a direct impact on what we're talking about today. Have to have assurances that if she's medicated. Today she receives no medication that I know of, other than if she has a cold or some other issue. But from a psychiatric, psychological, mental health standpoint, she doesn't receive any medication. You have to be concerned that if there is medication in the past, in the future rather, that it's always available, and protections to be sure that that medicine is taken. What are all of the arrangements for treatment, as well as medications? When I look at all of this and try and put all these circumstances together, and I weigh the youth of Ms. Weier, the naivety of her when the offense was committed, I look at the nature of the offense. I've talked about that, and I don't want to overemphasize the nature of the offense, but yet, if you think about it, it's almost like iron filings with a magnet. You can't really discuss this case with the disposition of it without looking at what happened. Then you have to look at what impact that has had on people, and what does the future hold. When I look at and read the report, the predispositional report, I'm very concerned about the near future, with comments about the Ouija board and the delusions and the demons. That tells me that Ms. Weier still has issues that we have to be concerned about. The recommendation from the state is that I commit her for 25 years. That's a good portion, good amount of time. I think it's twice how long she's been alive ultimately, from looking at the nature of the offense, a long time. The Attorney McMahon argues persuasively that the court should look at a shorter period of time and look at to age 25, which would be obviously 12 years less than the state talks about, but still a long period of time for someone to be supervised and watched. One of the concerns this court had at when the court made the decision about whether the case should be turned to juvenile court or remain in the circuit court was that the juvenile court jurisdiction was short and would end, and we'd have no assurance of community protection after essentially age 18. That when keeping the case in the circuit court, which is where it is today, allowed the system to go forward as it has with this jury verdict, and allows for long-term supervision and control. Although the commitment is long that the state proposes, and that actually that what Ms. McMahon proposes as well, both are long times within a system. The person that's committed has the ability to ask for conditional release as her system and as her mental health situation improves. There are many people out on our streets today that are released on that have conditional releases. They have mental health issues. They've been committed through the criminal process, not through Chapter 51, but through 971, and they're out on the street on a conditional release. They're watched, they're supervised, they go to work, they function, many of them raise families. So the long commitment isn't sort of being confined to the black hole of Calcutta for as many years as the commitment is. But it says supervision, it says control, it says monitoring. When I put that together into the mix, I'm satisfied that the maximum commitment is what's necessary in the case for all of the reasons that I talked about. I'm not going to go back and relive those circumstances, but I believe to maintain safety, to maintain protection to the community, to maintain protection for Payton so she has the resources of the community to assist, or rather for Ms. Weier, that she has the resources available to protect her in the future, be sure that it keeps her out of trouble if there's going to be trouble, and if it's not going to be trouble, that can be resolved through the system. But it gives the community assurance of safety and protection. It gives Ms. Weier that opportunity to, I think, to proceed and to become a functioning member of the community. The purpose of our legal system, in particular a process such as we're in today, isn't simply to put somebody away and not permit them to grow and to live and to adjust. I'm satisfied that Ms. Weier can do that. She will do it. But she has to do it keeping in mind, as I think she knows, of what happened and the community's perception of what happened. So I'm satisfied the 25-year commitment is appropriate. I'll order that. So ordered. There's a request for 1,301 days credit. Any objection to that?
No, Your Honor.
I don't want to wake anybody up, but no. All right. Then I'm going to order 1,301 days credit on the commitment. I raised the issue of medication as one of the issues I have to address that should be addressed at this fact. It must be addressed. The statute says I have to address the issue of medications. The state says I should order the medication. Ms. McGann states that indicates that I should not. From Attorney McMahon's perspective, there is no medication in this case. There never has been.
Correct, Your Honor, and so no doctor has sat down with her and explained the benefits and detriments of medication and made a determination whether or not, as is required under our laws, whether she has the ability to make that decision herself. And until such time as that happens, I don't think we should order it. If the hospital needs that order, they are not shy about seeking it.
Any comments from the state?
No, Your Honor.
For those that don't know, in a situation such as this, if a person's prescribed medication and it's for their mental health and they don't take it, the court can order that they be compelled to take the medicine. That's the medication order. The statute says I have to review it at this time. As I indicated, there's never been medication administered in this case. There's no outstanding, if you will, controversy about the use of medication. So I'm not going to order a medication at this time. That it be administered against her consent at this time. It'll still may be administered. If there is an issue, the institution will bring it back. With that, then I commit Anissa Weier to the Department of Health Services for a period of 25 years, subject to the credit that I've provided, subject to the order that I'll issue. I'll order that she be transported to the Winnebago Mental Health Institute today.
Your Honor, I don't know that Winnebago Mental Health has an opening today. I tried to reach their intake unit to determine that. I spoke with Matt Ziegler, who did the report for WCS. He indicated that generally what he has seen is there's approximately a week wait time. They're in part, I think, because they generally need to make sure that blood draws are done, things like that, to make sure that the person is medically stable to come into the hospital.
You may know more than I know about that topic. What I do know is that the court did speak with one of the officials at Wisconsin Community Services, and with the thought that that the court would at least follow the recommendation through the plea agreement that would be a commitment to Winnebago, that if it, regardless of the length, she'd have to be taken there. And we were told they would expect her today, and I think the sheriff is prepared to transport her there.
Okay.
Now, that doesn't mean I want Ms. Weier traveling about the state, because I know that's happened in the past. We've ordered people to go to Winnebago or other institutions. They get there and the institution won't take them. So we will fax the orders to Winnebago as soon as the hearing is complete, and we'll verify that it's appropriate. Does the do you want to meet with her family and her today?
If we could, Your Honor, I do have to run over to Branch 3 for a matter, but then I could join them over at the Juvenile Center.
Well, I'm going to order then that as an interim matter that Ms. Weier be transported to the Juvenile Center. She can meet with her family as she has in the past, and that she'll stay there till 4 o'clock. At 4 o'clock, then she'd be transported, and we'll verify what the location is.
And if Winnebago does not have the opening today, we had anticipated that she would go back to West Bend, and that's why West Bend didn't send all of her things with her today until she could be taken to Winnebago.
Now, they didn't bring all of her things with her?
No.
No, all right. Well, then maybe it's bad. Well, we'll verify with Winnebago what the approach is, and we'll take that. Otherwise, the order is that she be transported to the juvenile facility here to meet with her family and attorneys, and then by 4 o'clock leave to either return to West Bend or to go to Winnebago.
Thank you.
Now, you'll explain to Ms. Weier her appeal rights?
Yes, sir.
All right. With that, then, anything further from the state?
No, sir, thank you.
Anything further from Attorney McMahon?
Not at this time, sir.
All right. Well, thank you, everyone, for being here. Have a good day.
Bye. I'll see you in the lounge, and then your hands can go.
All right, and with that, she is sentenced to 25 years. And that was in 2017. So now let's fast forward to 2021. Fast forward to 2021.
It's nearly
and
7 years since Waukesha.
Let's see what happens from 2017 to 2021.
It's nearly 7 years since Waukesha 12-year-olds Anissa Weier and Weier and Geyser were first in court, charged with stabbing their classmate Payton Leutner. They said they did it to please the fictional boogeyman Slender Man. Payton nearly died.
We're here today on a petition for a conditional release that Ms. Weier filed.
Anissa Weier is now 19, asking to be released from a mental institution where she's been since a jury found her not guilty due to mental illness. In a letter to the judge Wednesday, Weier wrote in part, quote, "I hate my actions May 31st, 2014, but through countless hours of therapy, I no longer hate myself for them." And she continued saying she's ready for release. Quote, "I have exhausted all resources available to me at the Winnebago Mental Health Institution. If I'm to become a productive member of society, I need to be part of society." The judge will make a decision in June. Anissa's attorney tells us all 3 court-appointed psychiatrists who've examined Anissa say she's ready for release.
The doctor's reports all support conditional release.
Are you pleased to hear that?
Oh, yeah, I was very happy.
And you're confident as her attorney that she's progressing as she would need to?
She's always applied herself to anything that's been asked of her, and it's very important to her. If you look at her letter, you'll see it's very important to her that she continue to improve throughout her life and use her experiences to help others.
Both sides will spend the next few weeks putting their arguments in writing and submitting those to the judge. He says he'll make a decision when everyone returns here in 3 months. At the Waukesha County Courthouse, Nick Bohr, WISN 12 News.
Family members of Anissa Weier and Payton Leutner were in court today but did not comment.
All right, so that was March 2021. Now we're going to fast forward to September 10th. So remember, she wrote that letter. She was asking to be released. So now, let's go see what happens. All right, so this is from September 1st. This is release hearing. All right, so this is the release hearing from September 10th of 2021.
All rise. Okay, thank you. Please be seated.
I didn't even have a chance to go back to my office and pick
I think everybody is here today. The court will call the matter of state of Wisconsin then versus Anissa Weier, case number 14-597. Who appears for the state?
Judge of the state by Ted Sapakowicz and Kevin Osborne. Seated behind me, Judge, are Shannon Steidaher from the Department of Corrections and Nicole Slauson, the forensic case manager, whose signatures on the plan that was provided.
All right, very good. Thank you. Good afternoon as well. Good afternoon. And then who appears for the defendant today?
Ms. Weier appears in person and with counsel, Attorney Joseph Smith and Attorney Maura McMahon.
All right, thank you. Good afternoon as well. This is a matter that came before the court. Previously, the court authorized a conditional release and then ordered the department to prepare a conditional release plan, which has come in. It came in on August 30th, 2021. I believe the state's had it and had a chance to review it.
Yes.
The defense has had a chance as well.
Yes, sir.
All right. Thank you.
I note that the author of the report, that Ms. Slauson is in court. Do you have anything you'd like to add to the report or emphasize any portions of it?
Not at this time, sir.
All right. Does the state have any questions for the author of the report?
No, I don't have any questions, Judge.
All right, thank you. Does Ms. McMahon, as well as Attorney Smith, have any questions for the author of the report?
I don't believe so. It was very thorough, Your Honor.
All right, thank you. The report does recommend that Ms. Weier be released pursuant to the plan to reside with her father at the father's residence. The court has previously ordered that the report remain confidential due to the nature of the report and the various medical conditions that are set forth there. And however, there is not a statutory basis to maintain its confidentiality. So after the hearing, I will release the report and it'll be available through CCAP.
Your Honor, I would ask if the court is going to do that. The Department of Corrections has requested, and I would second the request, that there be, that Ms. Weier's home address be excised from the report.
All right, thank you. Any objections from the state?
No.
That'll be the order of the court then as well. Then, does the state have any comments to make with regard to the report?
Judge, one request. There are a number of things within the report that are things that are a condition of her release that allow for the termination of that condition at the manager and agent's discretion. I'm looking specifically at the request that she be tracked 24/7 by GPS. And the report indicates until removal is deemed appropriate by the manager and agent. The state is asking that they need or be required to get court approval and that there be some sort of hearing before that 24/7 GPS, before those hours are modified in any way. We're also certainly concerned that notice be provided to the victim and the victim's family if a change like that were to take place. So we're asking that you modify the plan to include language to that effect, that such a change as that would need court approval.
I read it in the report, but now I'm trying to find it. What page is it on?
It's near the bottom of page 4, the third from the bottom paragraph.
I see it. Very good. All right. Thank you. Does Attorney McMahon or Attorney Smith have any comments to make in response?
Your Honor, I certainly understand the state's request. However, I would note that given the nature of this case and the amount of attention that has been focused on it over the years, that the Department of Corrections is not likely to make that decision lightly. And I believe that it would be more appropriate to leave that in the hands of the case manager.
All right, thank you. Then I know that Attorney Dunn is here from Victim Witness. Does Victim Witness have any comments with regard to this issue or with regard to anything else we'd be talking about up to this point? And Attorney Dunn can come forward if she'd like.
Certainly, I would just say that in my meetings and communications with the family, Deputy District Attorney Backowitz's remarks are in keeping with their wishes.
All right, thank you. Do you have anything from the victim witness from the victim standpoint? Do you have anything else you'd like to add in response to the report?
No, I mean, I can certainly ask if they'd like to be heard on anything, but they've had an opportunity to discuss it with both myself and the agents.
All right, very good. Thank you. And I'll call on Attorney Dunn to determine if any members of the family wish to make any statements to the court. But first, with regard to the issue of the 24-hour tracking with the GPS system, there's a lot of it goes without saying, this is a serious case, serious issues. The matter has received a lot of attention. An issue that for the court always to be aware of is public safety not only of the victim but of members of the public, as well as Ms. Weier herself. That court scrutiny is appropriate in cases such as this. The court doesn't want to delegate the court's approval of any actions without first having a specific review of it. So I will note that if there is a decision made to remove the GPS requirement and the GPS monitoring, that the court be notified 30 days before the removal is to occur. So there's an opportunity then for the attorneys involved to review it as well as the court. And that gives then the victim's family as well a chance to review that issue. That'll be the order of the court, and that'll be included as an amendment then to the conditional release document. Let me ask Attorney McMahon, then or Attorney Smith, would you like to make any statements with regard to the report?
Ask Connie if she wants us to tell the judge that we support the returning to Winnebago until Monday.
Your Honor, she does want to. Yeah. The report is very thorough. The one thing that Ms. Weier wanted us to make sure to advise the court of is there was a request by the Department of Corrections that she be returned to Winnebago Mental Health until Monday and be released from there on Monday in order that there may be more complete services available, as obviously we're coming up on a weekend. She supports that. She discussed that with Ms. Steidehar. She feels that that is a very prudent and appropriate way to proceed.
All right, thank you. Thank you. Let me ask Attorney Dunn, does the family of the victim wish to make any statements to the court?
No, they indicated they did not, and they confirmed that they agreed with what I asserted earlier.
All right. Let me look then to the state then, Attorney Packowitz. Does the state have any objections to the report?
No, Your Honor. I did have one other request that the agents actually made or wanted me to make of the court, and that would be that you allow the evaluations that were done by the doctors for purposes of the conditional release decision to be released to Waukesha County providers that will be providing service to Ms. Weier. They would like to have those available for those providers. I think certainly that's reasonable and necessary in Ms. Weier's treatment.
All right, thank you.
Yeah.
Any objections from the defense to that?
No, Your Honor, that makes sense. Ms. Weier appreciates that request.
All right, I'm just going to take a moment to review the report. Then Ms. Lawson, who's the case manager, will then have the responsibility to monitor and be in contact then with Ms. Weier. True?
Yes.
The medical, psychiatric, and psychological services will be provided by Waukesha County's Department of Health and Human Services. Is that true?
Correct.
So it's it would be the Waukesha County Department then who would receive these the medical and psychological reports that were submitted on behalf of the conditional release. Is that what you're asking for?
Yes, sir.
All right. Now there was, let me just look back at the documents. Shut your microphone off as well. Press the little button that should be able to take care of matters. For is just to identify there were three doctors prepared reports for the court to review for purposes of the conditional release report, and those are the three that I believe have been addressed. There was actually two other reports that the court received that centered on Ms. Weier's status at Winnebago, and those were submitted by Winnebago by Dr. Pope on March 3rd, and there was a supplemental letter then submitted on June 28th, both of 2021. Are those to be included in the documents to be released? I discuss that because those are otherwise confidential and for use of the court.
Do you want those two?
You can come up to sit at the council's table if you'd like, so we can be sure that we can hear your response. And ma'am, you're not Miss Lawson, so you can state your name, please.
Shannon Seidahar Schultz.
Now you should move toward the microphone.
Do I need to push the button back on? It's on. It's on. Okay.
And just state your name and spell your name, last name.
Shannon Seidahar, STYDAHAR-Schultz, SCHULZ.
And what's your position?
I am a probation and parole agent with the Department of Corrections, and I supervise conditional release for Waukesha County.
All right, very good. You have a response.
I do, Your Honor. If the court could release all of those records, I believe Winnebago will be can submit the records directly, but with your permission, we would appreciate that being on the record.
All right, so you're referring to then the conditional release report letters of, I think, dated March 1 and dated June 28th.
Correct.
All right. Any objections to those being released?
No, sir.
Any objections from the state? No. Okay, well, I'll include that in the order then, and I'll authorize Winnebago to release those documents and to submit them directly then to the Waukesha County Department.
Appreciate it.
It'll be the order of the court then so ordered. All right, thank you. Any objections from the defense with regard to the terms of the report and these additions that we've put into it?
No, Your Honor. Ms. Weier and I had the chance to review the report. I had the opportunity to read the most recent version of it to her yesterday, discussed the conditions that were listed in there. She was already aware from her conversations with her supervisory team what was going to be expected of her, and she looks forward to moving on into a productive life.
All right, thank you. Is there anyone else that among the parties to the case, either the victim office, the victim, the state, or from the defense through the attorneys that wish to make any statements to the court? I see no one coming forward, then the court will proceed. The court's, of course, familiar with the case based upon the court's involvement in the matter. I've read the conditional release report and the conditional release plan. I'm satisfied with the additions we've made to it, in particular addressing the GPS system, that it's a fair report, it's reasonable. It, of course, provides for the protection of the community, it provides for the protection of the community as well as the victim. Also, it provides protection as well than for Ms. Weier. It's important we consider all of the individuals involved in such a report. I'm satisfied it's reasonable. It provides good protections as far as the community is concerned. It also provides a good plan for rehabilitation then of Ms. Weier. So I will approve the plan. I approve it with each of the modifications we've made to the plan today, including the authorization for the release of the reports. The plan does provide, then as one of the recommendations, that Ms. Weier be transported back to Winnebago and be released from Winnebago on Monday. That's been commented upon a few minutes ago, and I approve that, and so I'll direct that she be returned to Winnebago for release on Monday according to the terms of the plan. Also, so it's clear, I'll order that in all aspects of the case that in these court documents and other documents that Ms. Weier's residential address be sealed. I think that's appropriate. Thank you. For her protection, but for the protection of the community as well. That'll be the order of the court, and the clerk's office will ensure that occurs as well, as long as we have control over the court documents. With that, I'll sign the order today. That should be the end of our hearing, and I'll order that Ms. Weier be returned to Winnebago. Anything further from the state?
Just, Judge, I know there's a form. I don't know if that's what you're referring to as the order, that there's a form.
I have it. You mean the form order?
Yes.
Yes, I have it here.
That's all, Judge.
All right, well, that's the document I'll be signing. It's really pretty clear and succinct as legal documents go, right? Anything further from the defense?
No, Your Honor, thank you.
All right, well, thank you all. Have a good afternoon. Then, Ms. Weier, good luck to you. Have a good day. Court's in recess.
All right, so there's that. We're not done just yet. So hang in there. I have a few more things to show you. So this is some news about her release. So there might be a press conference or something in here. Let's see. I haven't watched this yet.
Out 5, it's a case that...
All right.
Became an international sensation. Now, more than 7 years after being charged, one of 2 teenagers sentenced in the Slender Man stabbing is set to go free. A judge granted Anissa Weier's conditional release after she served 4 years at the Winnebago Mental Health Institute. Bruce Harrison is live with the latest on Weier's release. Bruce.
Charles, good evening. I'm at David's Park in Waukesha. Not too far from where I'm standing, there was a wooded area where Anissa Weier and her friend Morgan Geyser brutally attacked Payton Leutner some 7 years ago. And this area, Charles, this is one of the areas that Anissa Weier, will not be able to visit under the conditions of her release.
She's monitored and she's got restrictions, and you know, surely she'll try, hopefully she'll try to go in the right direction.
Sarah Reddy lives just across the street from David's Park, where the attack took place in 2014.
They're giving her everything to make the right decisions.
Weier was just 12 when she and her friend Morgan Geyser lured Payton Leutner to the woods in Waukesha, where Weier encouraged Geyser to stab Leutner in order to please the fictional character Slender Man. Now 19 years old, Anissa Weier will have assistance and restrictions on the outside. Those include a case manager to monitor medication for psychiatric care, monitored internet use, no social media, and no contact with the victim or her family. Waukesha police say Weier's movement will also be restricted by 24/7 GPS monitoring. If she goes too close to the victim's home, workplace, or location of the attack, it will trigger an alert, and police will pick her up for violating the terms of her release. The court decided, based on mental health reviews, that Weier could leave. Juvenile court judge Ashley Wilcott has been following the case closely since the beginning.
The judge said, listen, regardless of how long it has or hasn't been, she, under these conditions, will not be a threat to society, will not be a threat to herself, and will not be a threat to the victim.
From a legal perspective, Wilcott believes rehabilitation for a juvenile is the justice system working, but she understands others may feel differently.
It feels like, how can that be just when my daughter almost died? So for the family, for the victim, I cannot imagine it feels just.
And Charles, a spokesman for the family of Payton Leutner, told us today that the family's disappointed Weier is already being released, considering the length of her sentence. That spokesperson also said that today Payton Leutner is doing very well as a college sophomore, and that, it's been challenging, but she has a bright future ahead. Reporting live in Waukesha, Bruce Harrison, TMJ4 News.
Yep, challenging 7 years for all families involved. Thank you. Here's a timeline of events in this story that gained national notoriety. The crime happened in May of 2014 in a wooded area in Waukesha when all the girls involved were just 12 years old. Anissa Weier and Morgan Geyser were taken into custody and were charged days later as their injured classmate, Payton Leutner, fought to recover from that attack. 3 years later, after pleading guilty to a lesser charge, a jury found Weier not guilty by mental disease or defect. She was ordered to serve 25 years at the Winnebago Mental Health Institute. Geyser was convicted but found not guilty by reason of mental disease or defect. She was sentenced to 40 years at that same facility.
That was a nice little recap. I like that. All right, but wait, there's more. All right, I've got one more news clip, and then I have a news article. So remember, we heard all about this GPS monitoring.
The Wisconsin.
That she's supposed to be monitored. Well, let's find out what happened with that, with this GPS monitor.
Woman who admitted to helping stab her friend to appease the fictional character Slender Man has now been freed from her GPS monitoring. A judge just ruled that 21-year-old Anissa Weier will no longer have to wear her GPS monitoring bracelet. She's had it on since 2021 when a judge granted her conditional release following nearly 4 years spent at a mental health institution. Back in 2014, Weier and her friend Morgan Geyser lured their friend into a Waukesha park and stabbed her multiple times. That girl did survive. While her bracelet was removed, the court ordered that Weier continue having her supervised release.
So that was 2023. So now 3 years ago, 2.5 years ago, her GPS monitoring has been removed. Interesting, right? All right. Final last thing is I always like to end these rewatches or these look backs or whatever these, I guess, rewatches, and find out, what, end with like the victim.
My name is Whitney Allen and I'm a widow. My husband, Ryan.
And end with, a retrospective on the victim. In this case, Payton survived, right? So Payton survived. So let's see can I actually scroll through here? Oh, you're not going to let me scroll. These websites. Sorry, guys. I thought I could share this with you. I'll read it. I can't scroll. Let me try one thing. Let me just try something. That helps. Okay, that helps. All right. All right, here we go. You can read along with me. Slender Man stabbing victim speaks publicly for first time. Without the whole situation, I wouldn't be who I am. So this is October 24th of 2019. So until now, Payton Leutner has never spoken publicly about what happened to her in the woods at the hands of her best friend and another classmate. Her scars from the 19 times she was stabbed on May 31st of 2014 testified to that moment of betrayal, but they also mark her incredible strength to survive. I've come to accept all the scars that I have. It's just part of me. I don't think much of them. They will probably go away and fade eventually. Leutner survived an attack that captured headlines worldwide. All right, so there she is. And this is 2019. So this is already 7 years. So here she is when she's 17 years old. She said she's grateful for all the love and support she's received after friends tried to take her out in the name of a fictional character, Slender Man. So now Leutner, 17, she's worked hard over the last 5 years to heal and rebuild a normal life. So in 2014, Leutner was a sixth grader in Waukesha, Wisconsin, when Geyser and Weier attacked her after a slumber party at Geyser's home. They had been celebrating Geyser's birthday the previous night. Leutner described herself as hopeful and positive before the attack and said she's tried to see the good in people, including Geyser. Leutner said Geyser had struggled to make friends and that in 4th grade she befriended Geyser herself. She was sitting all by herself, and I didn't think anyone should have to sit by themselves. Leutner said, while they were friends, Leutner said, Geyser seemed like a happy girl, albeit a little lonely. They would have sleepovers together, play outside, and draw, all the things that kids do. Leutner said she considered Geyser her best friend and thought Geyser was somebody she could trust. She was funny, I will give you that, Leutner said. She had a lot of jokes to tell, she was great at drawing, and her imagination always kept things fun. There's another photo of her. Then everything went downhill. Around the time Geyser became friends with Weier in 6th grade is when Geyser also started to talk to Leutner about Slender Man. I thought it was odd. It kind of frightened me a little bit, Leutner said, but I went along with it. I was supportive because I thought that's what she liked. Eventually, the fictional stories Geyser told about Slender Man, a tall, faceless creature, became too frightening, Leutner said. She even asked her mother, Stacy, whether Slender Man was real, and relieved when she was told he wasn't. I told Geyser that it scared me and that I didn't like it, but she really liked it and thought it was real. Leutner even considered ending her friendship with Geyser, she said. I saw the change from 5th to 6th grade when she met Anissa. That's when I really wanted to get out of that friendship. Ultimately, however, Leutner stayed friends with Geyser. She said she felt bad for her friend and didn't want her to be alone. Geyser even guilted Leutner into staying friends. Payton was such an empathetic kid, her mother, Stacy, said. She recognized that Morgan maybe wasn't the healthiest friendship to have, but if Payton wasn't her friend, she wouldn't have any other friends, so she thought everyone deserved at least one friend. As Geyser's fixation with Slender Man grew, it appeared to Leutner that Geyser's friendship with Weier blossomed too. Weier lived in the same apartment complex as Geyser and rode the bus with her to school. I didn't like Weier at all, Leutner said. I just hung out with her because I knew that Morgan really loved her as a friend, but she was always cruel to me. I feel like she was jealous that Morgan was friends with me and her. It was Weier who had really convinced Geyser that Slender Man was real, Leutner thought. Leutner said now she is convinced that Geyser and Weier were a toxic combination. All right. Leutner said she had no idea what the two girls had planned for her in the name of Slender Man when she arrived to Geyser's 12th birthday party. The trio had skated together at the local roller rink and eaten frozen yogurt before the slumber party. Looking back, Leutner said she thinks she can recognize a glimpse of something feeling off that night. Something was strange because at all of our past sleepovers, Geyser always wanted to stay up all night because she could never do that at home. But on the night of the birthday party, she wanted to go to bed. Once I looked back on it, I was like, that was really weird. Why didn't I see something? Why didn't I notice something was weird? I'm not blaming myself at all, but who could ever see something like this coming, right? Nobody could ever see something like this coming. Geyser and Weier later told investigators they had planned to take out Leutner in her sleep that night, according to police interviews, but they changed the plan to take her out the next morning in the nearby park. I remember waking up. They had already woken up and gone downstairs on the computer. So I woke up and went down with them. We had donuts and went to the park. So Leutner said it was Geyser's idea in the morning to go to the park and that normally Geyser wouldn't have been allowed to go without an adult. But because she was with friends and it was her birthday party, her mother had let the three girls go on their own. Once the girls got to the park, the plan to hurt Leutner changed again. Weier told investigators that they suggested go for a walk, play hide and seek. They just wanted to go for a walk. Payton says, but I didn't think much of it. It's just a walk. It's in Waukesha. What bad stuff happens in Waukesha, Wisconsin? Well, it's coming from within the house, right? In the woods, as they prepared to start what Leutner thought would be a game of hide and seek, Weier told Leutner to lie down. Anissa told me to lie on the ground and cover myself in sticks and leaves and stuff to hide, in a sense. But it was really just a trick to get me down there. With a kitchen knife, Weier told investigators Geyser had brought from her home. There's the confirmation, as we've been saying. The weapon came from Geyser. Brought from Geyser's home. Geyser repeatedly stabbed Leutner. Leutner said she didn't remember every detail of her brutal attack and was glad for the relief in not knowing. But she said she does remember her trust being broken by her best friend and not believing Geyser and Weier were going to get help for her. After Geyser stabbed Leutner with a knife, she and Weier left Leutner alone in the woods. Injured and bleeding, Leutner did what many couldn't believe she had the strength to do. She pulled herself out of the woods and into the open where someone could find her. I got up, grabbed a couple trees for support, I think, and then just walked until I hit a patch of grass where I could lay down. It was there at the end of Big Bend Road that a bicyclist found her and called 911. Police and EMT workers arrived. Leutner's focus, she said, faded in and out while in the ambulance. I couldn't focus much, excuse me, because my body was working so hard to keep itself alive. It was probably like vision isn't really a priority right now. Wow. At the hospital, she says she remembers seeing her mother as nurses counted her wounds. I said, you're going to be okay. It's going to be fine. But I could see she was covered. Her arms and legs and her abdomen, they were covered in stab wounds, Stacy says. The doctors at ProHealth Waukesha Memorial Hospital performed emergency surgery and were shocked by Leutner's critical injuries. The stab wound she suffered to her arms and legs had only damaged soft tissue, but the two to her torso had hit major organs. One cut through her diaphragm, damaging her liver and stomach. The other one nearly penetrated her heart and missed a major artery by less than a millimeter. Right? She is incredibly lucky to be alive. If that knife had gone the width of a human hair further, she wouldn't have lived, Dr. John Kellerman said. Wow. When she was awakened after 6 hours of surgery, Leutner said she first started worrying about where her attackers were. I remember the first thing I thought after I woke up was like, did they get them? Are they there? Are they in custody? Are they still out? She said she was relieved to hear that police had captured both Geyser and Weier as she struggled with the pain from the attack and surgery. I wrote on whiteboards to communicate because I couldn't speak much. I had the intubation tube in my lungs because I couldn't breathe on my own for a while. Her recovery was difficult, both physically and emotionally. She says she was also frightened after the attack and slept in the bed with her mother so she wouldn't be alone at night. To this day, Leutner says she sleeps with a pair of broken scissors under the pillow next to her just in case. Wow. When Leutner learned why Geyser had stabbed her, she said she wasn't surprised by the motive. The girls had intended to take her out to appease the fictional character Slender Man and prove that he was real. After I heard what she did, I was like, well, this doesn't surprise me at all because she believed so hard in this thing that she would do anything for it. What did surprise Leutner, she said, was that Geyser and Weier had immediately confessed to the attack and that they told police they'd been planning it for a long time. It was a little shocking to me to see that they had this big, huge plan that they had been working on for months. Now, since the attack, Leutner has done her best to resume a normal life despite the notoriety of the case and the years of litigation. Trusting others, especially new friends, she says, has been particularly difficult after the attack. She had friends, but initially, even with those friends, she kept them at arm's length, Stacy says, and for a long time, even trusting family members was hard for her. Payton Leutner says that she sometimes thinks that her former best friend, Angie, Payton says that she sometimes thinks about her former best friend's mother, Angie, with sympathy. Wow, okay. I thought about what she's going through and how hard it must be for her because I'm sure a lot of people are trashing on her and hating her and saying that it was her fault. She raised Geyser wrong. It wasn't Angie's fault. Morgan's schizophrenic. There's nothing that she could have done to stop that or control that. It was not her fault. Now, in 2026, Geyser's mother told a newspaper that her daughter had been diagnosed with early onset schizophrenia while in custody. A forensic psychologist also testified for the defense. All right, we knew about that. Stacy also said she thought about the mother and father on the other side of the shattered friendship. I was angry for a long time, especially at Morgan's parents, knowing that Morgan's dad had schizophrenia. For a long time, I thought that they were maybe just in denial and ignoring her symptoms, Stacy said, but I'm not angry anymore because I recognize that they're going through their own hell. Wow. Geyser and Weier were charged in adult court with first-degree attempted intentional homicide after the attack. Weier pled guilty. We got all of that. Leutner said she is aware of the long-standing public debate about whether the two girls were old enough to be charged in adult court, but doesn't herself question whether their cases should be handled in juvenile court. Adult crime is adult court. If they had stolen a candy bar, sure, that's a child. But you tried to delete someone, that's an adult crime. Interesting. Leutner says she doesn't ever want to see or talk to Geyser or Weier again, and said what Geyser did was probably unforgivable. She knows Geyser is already eligible to petition the court for release, but she doesn't fear her eventual release. If she ever tried to come by me, she would go right back where she is. Stacy acknowledged her own reservations about Geyser potentially petitioning for release. I don't know that I'm comfortable with her being released right now. I know that their sentences were up to 25 and 40 years, and if that's how long it takes, then that's how long it takes. Payton even surprised herself when responding to the question of what she would like Geyser to know. I would probably initially thank her. I would say, just because of what she did, I have the life I have now. I really, really like it, and I have a plan. I didn't have a plan when I was 12, and now I do because of everything that I went through. Wow. That's pretty amazing. She wants to thank Morgan. Wow. I wouldn't think that someone who went through what I did would ever say that, but that's truly how I feel. Without the whole situation, I wouldn't be who I am. Leutner is a senior in high school and plans to attend college in fall of 2020. She said she'd like to pursue a career in the medical field, which she believes is a goal inspired by what happened to her. And that is, I have confirmed that she is going to medical school right now. If not already out, or maybe she's already out, I'm not sure. To the many people who supported her and sent her well wishes through the years, she said she is very grateful for all the love and support. She said she now wants people to know that she is doing well and that her hope for moving forward is to put everything behind me and live my life normally. We've seen her go from a victim to a survivor, family spokesperson Steve said. Now she's a young lady with a really bright future. She has great grades, great friends. She's got so much to live for, and I can't wait to see what the next chapter in her life is. She's cute. As far as Slender Man goes, Leutner said she had advice for parents whose children might not understand the difference between what is real and fake. Parents need to talk to their kids directly, saying, this is not real, this is fake. She also shared some sage advice to young people regarding bad friendships that she wished she'd known at 12. Get out before something bad happens to you, even if you're guilted into it, if you've been friends with them for years. If you feel something is bad, you need to get out while you still can. So, there she is. Oh, sorry I had that thing on. Jeez, sorry guys. Wow, right? Pretty amazing. Pretty amazing kid. Good for you. So, all right, guys. That's going to do it for us. I'm going to wrap it up. It's 7:30 here on the East Coast. And you guys, let's see. Play on crime. So happy to hear that Payton is able to move on. Absolutely. Widespread panic. Payton has learned to let the adversity build her character. 100%. 100%. Widespread. Yeah, her dad had schizophrenia. I think he was hospitalized 3 times, maybe. Something like that. Yeah, something like that. All right, Grampy. I wish I could show you Super Ball. She's not here. I have other kitties I can show you. I don't have Super Ball to show you. Sorry, Grampy. Wish I could show you some Super Ball. All right, Lynn, have a good weekend. Thank you. Barry, thank you. Thank you for all your chat and your support, you guys. Ambi, good night. Sharon, yes, rest well, everybody. Jennifer King, happy weekend to you guys. Widespread panic, good night. All right, guys, that's going to do it for us. As always, though, I will leave you with little Sid is over there. You can't really see much of her. Little Roger's a little donut over there. A little boy, little donut there. So, all right. Have a great weekend. Monday, we will pick up on Sarah Patrick. What's her name? Sarah Grace Patrick. Jury selection starts on Monday. So we may do something else. We may do like the year, what we're looking forward to, all the trials we're looking into. We may do that so that we can cut into Sarah Grace quickly if we need to. But that's the plan. Is next week is... Then we have a Raul Valley. He's got a hearing on Tuesday. Davine Michael's sentencing is Thursday. And Leilani Simon has a hearing on Friday. Next week is going to be really, really busy. So we may be doing some dual streaming. We may be doing, next weekend we may be streaming stuff. So we'll see. We'll see how it all falls. All right, you guys, again, thank you so much. Leave comments if you like the stream. Thank you to our mods. Thank you to Aaron. And have a great weekend, you guys. And we will see you on Monday for the Sarah Grace Patrick trial starting. And with that, take care. And we'll see you.